Welcome, everyone. Now, officially, I welcome you at our 10th International Forum, Mediation and Law. Now, it's the very nice moment when everyone who was engaged in organizing this event would be able to have a few minutes to welcome the participants. Now I want to give the floor to Muriel Decaux, who is an executive secretary in CEPEJ. Muriel, over to you.
Thank you, Luisa. Good morning to all of you. Can you hear me well?
Yes.
Yes.
Perfect.
So good morning. I have the honor to open this important event with Luisa and Thomas. Thank you very much. More than 590 participants. Wow, it's impressive for this morning. So on behalf of the CEPEJ, the European Commission for the Efficiency of Justice of the Council of Europe, warm welcome to all of you from Strasbourg here in France, to participants, speakers, experts, practitioners, academics, institutional representatives from Ukraine, but also from so many other countries. It's great to be together this morning and during this week. Allow me to thank the Ukrainian Academy of Mediation for the invitation and for organizing this 10th edition of the International Forum, Mediation and Law. The forum brings together a truly diverse international community committed to the development of mediation and other dispute resolution mechanisms. Nearly 30 sessions this week, topic ranging from mediation, court-connected programs to task investment, child-related disputes, restorative justice, and other ADR mechanisms. That diversity says something important. Mediation is growing, is maturing, it's relevant across more and more sectors in the society. So the Council of Europe has working for a long time to promote access to justice across its 46 member states, to strengthen the rule of law and the effective protection of human rights. But justice must be more than a principle. It must be accessible, it must be efficient, fair, and respond to people's real needs. Mediation contributes directly to these objectives by offering parties opportunity to participate actively in resolving their disputes. Mediation is not only a dispute resolution tool, it's also a way of strengthening dialogue, trust, and social cohesion. Mediation can often produce solutions that a judicial decision alone cannot always achieve. At the same time, mediation and courts should not be seen as competing systems. Rather, mediation and judicial proceedings are complementary components of a modern justice system. The practice has shown that well-designed mediation programs can improve access to justice, reduce delays, help courts to allocate their resources to cases that require a judicial decision, and contribute to managing court workloads more effectively. Mediation can increase also public confidence in justice by offering citizens a broader range of pathways to resolve disputes. So the aim of the European Commission for the Efficiency of Justice, the CEPEJ, of the Council of Europe, which was created in 2002, is, generally speaking, the improvement of the efficiency and functioning of justice in its member states. To that end, the CEPEJ is preparing tools, collect and analyze data, define instruments of evaluation, develop contact with expert, non-governmental organization, research institutes, organize hearing, promote networks of legal professionals, etc. In this framework, the CEPEJ has been working for a long time, for many years, to support the development and effective implementation of mediation across Europe. And it has developed practical tools to assist policymakers, courts, mediators, and justice professionals. I can mention several key achievements, but not all, of course. Some guidelines to implement mediation in civil, in family, penal, and administrative matters. The scope is very broad, as you can see. The CEPEJ has also adopted checklists to support national authorities in setting up and monitoring courts. It adopted also methodology aimed at judge and court clerks, focusing on the judicial referral to mediation, a mediator training curriculum, and several programs of mediation awareness for judicial officers, for judges, for notaries, training program for lawyers, etc. Our approach is also practical. In parallel of these tools, we help member states move from principle to real implementation through bilateral cooperation program with some of the member states. Well, let me express my appreciation for this excellent cooperation between the CEPEJ and the Ukrainian Academy of Mediation. This cooperation has been developed in the recent years and continue to grow. As concrete example, I can mention the participation of CEPEJ experts in this forum, as well as in the previous one. The Ukrainian translation and dissemination of several CEPEJ mediation-related tools and material. The participation of Luisa in some of the, or in the quality group of the CEPEJ meeting, contributing valuable expertise and exchanges on quality of justice issue. These examples demonstrated the genuine willingness to work together based on shared value and common objectives. I can also note with pleasure from the program of this week that several experts who regularly contribute to CEPEJ activities are participating in this forum. Their expertise enriched both the work of the CEPEJ and discussion taking place during this forum. I encourage participants to take full advantage of the opportunity to exchange experience and learn from one from another. To conclude, mediation continues to evolve and should continue to evolve in response to new social, economic, and technological challenges. The international dialogue, like the one of today, is essential for identifying innovative practices and maintaining high standards. Forums such as this one play an important role in building professional networks and advancing reforms. The CEPEJ remains committed to supporting member states and partners in developing effective, accessible, and high-quality mediation services. I wish all participants productive discussions, inspiring exchanges, and successful outcome during all the week. The CEPEJ is ready to continue working together to promote mediation as an integral part of a modern, people-centered justice system and as a way to conciliate justice and peace, as it is mentioned in a title of one of your sessions of this week. Thank you very much for your attention.
Thank you so much, Muriel. A special thank you for the developments and tools and programs that CEPESH has developed. For Ukraine, it has become a foundation and basis for our policy making. I talk especially about the foundation for our law and the model that you are that we are now implementing, and that was proposed by CEPESH. We are enormously grateful to the Secretariat and all the experts at CEPESH. You help us develop and promote mediation. We are very happy that in the nearest future, mediation-related tools and instruments will be available in Ukrainian, which helps to develop mediation in Ukraine a lot. I also want to mention that the topics that you bring up, they are very relevant for the justice system, but they go beyond that. Mediation in Ukraine, in many ways, is based on what CEPESH has done before. And special thanks also goes to experts from CEPESH. They are very generous with sharing their knowledge and expertise, and the broad scope that of issues discussed by the working group of CEPESH is very important. This week, we are going to discuss, among other things, cases with participation of children, and that discussion is heavily based on the developments that have taken place in the framework of that working group. The same is true for the tax-related disputes. We are very grateful for your consistent development in promoting mediation in member states. Thank you, Muriel, so much for making it here and delivering the welcome words. I can see that we have over 700 attendees now, and we are also using stream on YouTube because Zoom has the limited capacity, and we hope that everybody who needs that and willing would be able to have access to the stream. Whatever we do in our work, we are basing our materials and programs on what CEPESH recommends and had developed before. And I'm talking about multiple sectors, work with the lawyers, restorative justice, many topics. All of them are aligned with what CEPESH has done before. Thank you for that a lot. Now I will give the floor to Thomas Stavinskas, who has supported us for quite some time now. I'm sorry, give me a second. Yeah, so we have felt this support by EU delegation to Ukraine. And we, with our project, consent project, we feel your support very well.
And it goes beyond the mediation, and we're speaking about alternative dispute resolution. And over to you. Thank you, Luisa.
Dear participants of the 10th International Forum Mediation on Law. On behalf of European Union delegation to Ukraine, I would like to congratulate you on the occasion of the 10th International Forum Mediation on Law. When I look to this figure 10, reaching this figure 10 is a remarkable achievement and clear indication of the forum's success over the years. It also demonstrates the continued relevance and growing importance of mediation and alternative dispute resolution in modern justice systems. Over the years, the forum has become an important platform for professional dialogue, bringing together practitioners, policymakers, academics, judges, lawyers, mediators, and international partners from different countries to exchange experience, discuss challenges, and explore innovative approaches to dispute resolution. As we all continue to work together on Ukraine's path towards European Union integration, one of the central topics remains the strengthening of the rule of law. When we're discussing the rule of law on a daily basis, attention is often mostly focused on legal reforms, functioning of judiciary, effectiveness of prosecution services. While these elements are undoubtedly essential, we should not underestimate the important role of mediation in ensuring access to justice and strengthening the overall justice system. Mediation contributes to the rule of law in several important ways. It increases access to justice, encourages the peaceful resolution of disputes, reduces pressure on courts, and helps parties reach fair, practical, and enforceable agreements. Across Europe, mediation and other alternative dispute resolution mechanisms are increasingly recognized as valuable tools, complement judicial systems, and contribute to more efficient and citizen-oriented justice services. As you know, EU Mediation Directive is playing an important role in encouraging member states to create favorable conditions for the development of mediation. At the same time, it provides sufficient flexibility for national legal systems regarding implementation models and institutional arrangements. As a result, European countries have adopted different approaches to mediation regulation, quality assurance mechanism, court-connected mediation programs, and mediation promotion policies. This diversity demonstrates that there is no single model for organizing mediation system and that Ukraine can draw on the most effective elements of the various European experience. Ukraine has already made an important progress in establishing a legislative framework for mediation and continues to advance reforms in line with European values and standards. At the same time, further efforts are needed. In its latest enlargement report, the European Union noted the importance of developing a national system for collecting data on various forms of alternative dispute resolution. The report also highlighted the need to prepare and implement mandatory mediation for specific categories of disputes, as well as to further promote public awareness and understanding of mediation. European Union has consistently supported these efforts, and especially through EU-funded Project Consent enhancement of the role of alternative dispute resolution in Ukraine. Significant progress has been achieved in raising awareness, strengthening institutional capacity, and promoting mediation throughout the country. Continued cooperation among Ukrainian institutions, civil society, organizations, professional communities, and international partners will remain essential to ensuring the sustainable development of mediation and broader alternative dispute resolution mechanisms in Ukraine. European Union remains firmly committed to supporting Ukraine's reform efforts and its path towards a modern, accessible, efficient, and citizen-oriented justice system. During this week, I wish you a fruitful discussion, productive exchanges, and every success during this forum. I am confident that your deliberations will contribute to the further development of mediation in Ukraine and to strengthening the rule of law for the benefit of all citizens. I wish you success and thank you very much for your attention.
Дякую, Томасе. Дякую за
Thank you, Thomas. Thank you for your opening remarks. Thank you for your support that we feel. And that's so important that the EU integration focus also includes mediation, and it's the promotion. It will push the promotion of mediation in Ukraine. So thank you very much for the EU delegation support in Ukraine and to promote and develop mediation and other alternative dispute resolution. It will enhance them not only as the efficient way to the access of justice, but also then that's something that will contribute to the social cohesion, to the peace building efforts at all the levels. We're deeply grateful. And I would like to say a few words on my behalf as the president of the Ukrainian Mediation Academy. I would like to say the welcoming words to everyone who joined us, to everyone who is going to spend this time with us. We realize that our agenda is very busy. We have about 30 sessions in different time zones for different target audience, and we're widely aware that you cannot be present at each and every, so we're going to provide the records. The colleagues from other time zones, for example, uh, who will have the sessions very late at night, will be able to see the sessions they're most interested in. I would like to indicate that they will have the dedicated sessions focused on the children, and especially on Friday afternoon, Saturday, feel free to engage the children. This is about the support, but also about the shaping the culture of nonviolent communication and dispute resolution. And the children who will join the forum today, just in a few years, will be able to become the speakers, and where they will be growing up realizing what mediation is and how they can apply it in their everyday life. Before moving forward, I would like to say the word of thanks and appreciation to our defenders. And we would like to remind you that the forum is organized amid the full-scale invasion, and those who are in Ukraine understand it very well, realize that there could be various challenges, and during the forum we may experience the attacks. So first of all, the safety is first, and we will have the records, and if you have to leave, you won't miss anything, do what you should. The colleagues who joined from other territories outside Ukraine, just in case, we apologize in advance that if there is a technical failure, something may happen, some hiccups, but we did our best to ensure the stable connection during the forum. Please take it with understanding and rejoin using the link that is one and only for all the days of the forum, so that you could anytime join us. And another thing I would like to mention, to make a forum possible, a huge team worked on it. It's not only me, of course, and not only the team of Ukrainian Mediation Academy. There's a various experts, partners, information partners. The volunteers also helped us a lot. There's also the interns, the school students, university students. Everyone puts their effort to make sure that during this week we can enjoy this celebration of mediation and delve deep into various topics. And of course, this is also our technical team, Oleg, Pavel, and our interpreters who during this week are going to work with us. There's going to be 8 of them who have gone through the dedicated course on interpretation related to mediation or mediation related topics, and we are grateful that today we can understand one another, and it is ensured on Zoom despite us representing different continents. As of the morning, we saw about 3,000 people being registered, and these are representatives for 100 countries. This is truly international event. Every day we have many niceties every day, including for networking. This is the space where you can exchange contacts, where you can find new connections to move forward in your countries, including through development of mediation, or you can exchange your experience and practices. We created this space for context exchange. We will give you the link on the chat so that, and we'll make it happen. Another important thing is that today we open the forum on the International Ocean Day, and that's a great opportunity to remind about the conservation of nature and environmental approach in the work of in the mediators' work and in the work of other professions. And this is another chance how important it is to take care of our nature and environment for our future generations. We will have dedicated sessions on environment. We will also sum up the all Ukrainian content of my Ocean of Understanding and Kindness dedicated to the Europe Day. We have over 300 masterpieces, incredible pieces of art by the children of the age from 4 to 12, and we're going to share it through our link on the chat. You will be able to see this online exhibition of the artworks focused on peace and understanding, the ocean of understanding and kindness. I'm about to wrap up my speech because we're about to start our panel with a representative of governmental bodies. I wish everyone fruitful work. I wish everyone to enjoy this event, and let's see it as a support and inspiration platform for everyone who enjoyed it. With a mediation in heart, let's move forward within this forum. Thank you very much to all. And this is the official announcement of the Mediation and Law Forum. I encourage you to enjoy the quality of the content of the forum. Exciting speakers and experts are going to speak, and use the information from this week as efficiently as possible. Thank you very much to all, and let's move to our first panel discussion. This panel discussion focuses on the vision of mediation development. And first of all, it will look at the government, the state's vision, and it's not only Ukraine, it's only about the international vision, about the experience of other countries that contribute to the mediation development. This panel is quite traditional for our forum. There's a certain opportunity to bring into the same platform for an hour and a half the representatives of central governmental bodies, of international organizations, to speak about the current situation of the mediation development of Ukraine, what are the further steps, what has already been done, what we plan to do, and what is also valuable is that today Ukraine keeps mediation and the focus within the governmental framework. And as I've mentioned, in the context of EU integration, it has a certain influence on the fact that we see increasing attention to this topic. And I would like to give the floor to Mr. Roman. I will introduce our speakers one by one. This panel brings together representatives of different governmental bodies. Today we're going to see the legislative, judicial, execution branches, the representatives of individual services and law enforcement bodies. So today I'm giving the floor to Mr. Roman Babik, who is the chair of the subcommittee on the Enforcement European Court of Human Rights Judgments and Alternative Dispute Resolution of the Verkhovna Rada Committee on Legal Policy. Mr. Roman, for many years, has been putting effort into the development of mediation in Ukraine, into the legal resolution issues in Ukraine. He was directly involved in the development of the law of Ukraine on mediation. And year by year, despite all the challenges of the wartime, he keeps mediation the focus of his attention. And he can share many achievements in his work. Mr. Roman, over to you. Hello, dear participant. Hello, Ms. Louisa. Thank you for the introduction. It was so nice one. And thank you for inviting me yet again to this forum. Thank you for organizing it. And thank you for the opportunity to share our developments, our achievements, and our ideas. You speak so high of me, and this is you emphasize this is the 10th, this like a Jubilee Forum, and thank you to the EU Ukrainian Mediation Academy, thank you to the EU supported project, namely Consent, other related bodies, the governmental bodies, organizations that contributed to the organization of this event. It has become the traditional platform to discuss the achievements and issues of mediation and the problems we see. We also look at other ways of alternative dispute resolution. I've read some background of this forum. I would like to emphasize its consistency, how regular it takes place. It's an important indicator of growing, and we speak about the number of participants, about the scope and scale every year. Apart from some global challenges that organizers cannot influence, this is the first year of COVID-19 pandemics in 2020 and the first year of full-scale invasion. The forum it didn't take place, but other than that, it takes place regularly despite the war. It adjusts to the challenging conditions and including through online mode. And it does not only preserve its importance and format, but it continues to scale up. I believe that online format contributes to that because it enables us to engage so many countries of various time zones and so many participants. Another thing I would like to outline that this is the first time that the forum will take 6 days in a row, including Saturdays, day off at the weekend. But that's another indicator, the market that this is an extraordinary event and it gains increasing importance. This platform for me is a yearly reporting event in a certain sense, and it's a certain watch we synchronize with that makes us look at some results and plan something ahead. And I have already have this certain procedure of preparation to this forum. I review what has already been said during previous years. I look at the highlights during the year and just outline this summary and enjoy this conversation with the professional community in 2024. We jointly carried out this large-scale, the comprehensive audit of the committee hearings, and we registered certain results of this audit.
And today we have this very interesting topic. I mean, this particular discussion, development of mediation of Ukraine and the state's vision of mediation. I would want to show the vision of further development on behalf of our committee and the state per se. So let me say this. In the past 2-3 years, the state stopped seeing mediation as something optional. The vision of the state is as follows. ADR is not something exquisite and external for our country. It's an essential element of European system that provides access to justice for everyone. ADR is an institution that enables us to resolve complex disputes, and that's closely related to the policy making that is taking place as we speak. Here, let me highlight our joint achievement of the recent years. And I'm talking about Interagency Coordination Council. For as of today, I can proudly say that this Interagency Coordination Council is now established. It happened last year, and now it started working full scale. There has been several sessions and several decisions have been made. As for the Interagency Coordination Council, the Ministry of Justice will tell you more about this because they are the owner of that council. But I am convinced that this institution being established represents a huge step forward. Now, the Parliament of Ukraine, the Ministry of Justice, the Ministry of Social Policies, and other ministries and institutions, representatives of the professionals in the law sector, they have a platform to coordinate their efforts. So this coordination council, I hope, will be able to form this well-aligned, comprehensive policy in ADR. Of course, there is certain hiccups still with engagement of certain branches of executive power. The second point I want to make is about development of ADR and mediation. I'm talking about roadmap that is an important element for the EU accession process. We all know that negotiation process is not officially open, but we are almost there because we all know about the developments with the Hungarian position, and we expect this any day now, opening of the negotiation process, official opening. With ADR, we do have some developments to show. I also would like to highlight, maybe some other colleagues will dwell on this more, but I'm talking about the statistical data on the work of the judiciary and the courts. This has been introduced, the collection of data, and it's a very important step forward because data is giving us this foundation. Maybe you know the results from 2025. Maybe you've seen the statistics. And I'm sure it's worthwhile learning the methods and methodology of data collection. And I hope that 2026 will be adjusted with that regard. Now, a few words about the work of the Parliament. I hope you know the real context where we work. We are now working during the wartime, which means we have certain requirements, what we prioritize: defense, security, safety, and so on. This all, of course, affects the timeline for any legislative process at the Parliament, which doesn't mean the reforms are stalling. No. Both in 2025 and this year, mediation is important. It remains important. The consumer disputes is one of the topics that has been covered by this new law adopted in March this year, Law 15100. This, again, is very closely related to our EU integration process. Another bill on economic policy that is also related to mediation. It will be expedited at the parliament. Another bill, 1234, about labor disputes, it's completely prepared for the first reading at the parliament. Now it's waiting until the window of opportunities at the parliament. A few words about other areas of ADR. Arbitration. Now 9041 bill has become adopted. It's about commercial arbitration. And this law now regulates institutions handling these kinds of disputes. Another bill is about to be registered at the parliament. There can be some frustration about slow process, but the work is ongoing nonetheless. The dispute resolution with the participation of a judge. And then other related topics, we keep working at the parliament on them. A few words about the plans and further steps. Here, let me say that based on the Interagency Coordination Council, based on that platform, we are prepared to build on that. This institution is responsible for developing state policies and their further implementation. And we do have certain results. Mandatory information meetings with mediators is one of achievements on this path. I'm not going to talk about this too long because the Ministry of Justice later will give you more details. It's also very important to promote and popularize ADR. We have to show how efficient this tool can be for dispute resolution. For pretrial mediation, mandatory mediation, we have to remember and be aware that the state, probably not only the state, but also mediators, have to guarantee the sufficient number of qualified mediators in every region of Ukraine. We want to avoid the situation when making something mandatory without the necessary resources is rendering it just a technicality, not a real tool. We want to avoid this situation. We want to be sure that people have access to mediators. That's why piloting of this project is very important. Once again, I will say that Ministry of Justice will later give you more details on this. To sum it up, I have to say that the vision of the state, which is the title of this discussion, the vision of the state is not built in a vacuum. Mediation and other tools of ADR or mechanisms are very important for the Parliament of Ukraine, for the Cabinet of Ministers.
Створюються нові закони, інші нормативні акти.
And
Створюються
that
самі
is
координаційні
clearly
ради.
seen
І це
because
все
we
насамперед
see
заслуга
the
ваша,
new
заслуга
bills
спільноти
being
фахівців,
registered.
медіаторів.
This
І
coordination
це
council is
результат
being
вашої
established.
оперативної позиції.
And that's exactly
Як власне
showing
медіаторів, їх організацій, в тому числі
how
Української академії
active
медіації, кучі
mediators
фахівців,
are, how
науковців,
much they
експертів.
do
І
together
саме
with
ви
other
є тим
stakeholders,
двигуном,
academia,
який не дає процесам
practitioners,
зупинятися. Це я
professionals.
відверто кажу, відчуваю на собі, тому
We
що
all work together on that. I
таких
feel it every
прикладів
day.
маса.
And there is multiple
Попереду у
examples
нас дуже
of
багато практичної роботи,
fruitful
від ухвалення
efforts
вже
of
згаданих
us all.
законів у стінах парламенту
I
до
have mentioned
запуску
some
певних нових
bills and
механізмів, які
adopted
сприятимуть
laws.
розвитку
We also have to remember
ADR.
about other
І
mechanisms that are
звідси, що
promoting
Комітет Верховної Ради з
ADR.
питань правової політики,
Let me just
це
say
комітет,
that
який я
the
очолював, був і залишається
committee and
вашим
subcommittee
надійним партнером на цьому шляху.
that I am
І хотів
leading
би
are
вас
your
наприкінці
partners
подякувати кожному з вас за
and are
вашу
committed to our
щоденну
joint
працю,
work.
те,
And
що
I would
ви
like to thank you
навчаєте
for
українців, наше суспільство,
your work
домовлятися,
on
домовлятися не в судових процесах, не в
teaching
судових
Ukrainian
процесах,
citizens to
домовлятися поза нами.
um,
І будуєте взагалі культуру мирного вирішення
resolve
конфліктів в цей складний
disputes
час, а це
in a
надзвичайно
peaceful
важливо
manner
для нашої
in
країни.
our
Тож бажаю
day
всім
and age is
плідних
crucial.
дискусій, бажаю всім
I
успішного
wish us
форуму і
all
бажаю всім
good,
отримати
fruitful
задоволення.
discussions
Дуже
and
дякую.
have fun.
Щиро
Thank you.
дякую, пане Романе, і за те, що
Thank you
зараз,
so
знаєте,
much,
актуалізували,
Roman.
що наразі
Special
перебуває
thanks
в
for
Верховній Раді, в парламенті на
bringing
розгляді,
up
який законопроект,
what's
і дійсно
being
про те, що
processed
підкреслили,
at the
що
Parliament of Ukraine
була
and
досить активною,
for
така проактивною
highlighting
позиція медіаторської спільноти, але я
the
зі свого боку хочу
proactive
сказати, що нам
position
зараз
of
набагато легше,
mediators
бо ми
of Ukraine.
розуміємо, що ми
Thank you for
вже
that.
рухаємося
Now
разом як
we
партнери з
feel
державою,
relieved because
зокрема з
we
вашим комітетом, з
see
іншими
your
органами влади,
commitment
бо вже є
in this
усвідомлення
partnership.
цінності
I mean,
розвитку медіації
the
і
committee and
інших альтернативних
subcommittee,
способів
we
для
see
українського
your
суспільства.
understanding
І насправді,
how
хто
important mediation
задавав
is.
ваш підкомітет, ваш
And
комітет,
your
чому? Бо в
subcommittee and committee
24-му
have
році,
set the
коли
tone.
триває
Why?
повномасштабне
In
вторгнення,
2024,
війна,
with the
і є
full-scale war
величезна
going
кількість
on,
різних
with the
питань, які
huge
постають
amount
перед
of
державою,
pressing
тим не
issues
менш,
before
ви
the state,
знайшли
you
можливість протягом
still
2 днів
had
поспіль приділити увагу питанням того, як
an
альтернативні способи вирішення
opportunity
спору можуть
to
сприяти
to
миробудуванню. І
focus
це
on
насправді
ADR for 2
надзвичайно
days.
цінно і стало
And
певним
that's
поштовхом.
very
Ваші
valuable.
рекомендації стали певним поштовхом для
Your
того, щоб далі ці
guidelines
дискусії
and
йшли.
recommendations
І ми вам
became
надзвичайно за це
an
вдячні,
impetus
бо
for further
відчуваємо цю
developments in
підтримку
this area. We
і
feel
тепер
your support.
повністю з державою як партнери
Now
рухаємося разом.
we
Дякую вам, пане
enjoy this
Романе, за
partnership with the state so
розуміння,
much. Thank you very much, Roman,
відчуття,
for
скажімо так, відчуття того, що ж
understanding
собою являє медіація,
what
і
mediation
розуміння
really
цінності
is
взагалі
and
альтернативних способів
understanding
вирішення спору.
the
Дякую.
value of
І тепер
ADR
я
as a whole.
хотіла
Thank you so much.
перейти
Now,
до
I would like
нашої
to
судової системи,
move on to our
яка теж
judiciary
відіграє
system
важливу роль
that
в питаннях
plays a
розвитку
crucial
медіації і
role
інших
in
альтернативних
development of
способів
mediation
в
and other
контексті
ADR
забезпечення доступу до
mechanisms.
правосуддя. І в нас
Uh,
сьогодні присутній
So
пан
today we have
Олександр
with
Мамалуй,
us
який є
uh,
заступником голови
Alexander Mamaluy,
Верховного суду. І я
Deputy
дуже
Chairman
прошу
of the Supreme Court
поділитися
of Ukraine.
тим з
Now
боку
I would
судової
ask
системи, які
Alexander
кроки
to
відбуваються,
show their
які
perspective
є
from the perspective of
ставлення
the
і взагалі,
um,
які є плани на
judiciary
розвиток
system.
медіації.
What
І
are the
передаю вам
current
слово, будь ласка.
state of affairs and the plans for the future? Over to you, Alexander.
Вітаю всіх учасників форуму,
Thank you so much.
організаторів.
Warm greetings to everyone here, both organizers
Я
and
в своєму
attendees. Thank you for the
виступі,
invitation to
своїй
speak.
невеличкій промові не
In
буду
my
багато уваги
short
приділяти
welcome words, I
нашим
will
здобуткам,
not
нашим
talk a lot
спільним
about our achievements,
зусиллям.
our joint
Це дуже
efforts.
важливе зусилля,
All of that
плідна
is
робота,
very
плідна
and
праця,
very important
але
to
тільки
ensure that
практика
we
містить
work
керівництво
efficiently.
і тільки результат,
But what
результативність
I
є
value
критерієм
most
правильності дій,
is
ефективності.
when is understanding that just the fact that we get the result proves that we are moving in the right direction. What can I say about our results? So, dear colleagues, we all know that mediation has to be developed as ADR has to be developed. The respective policies have been adopted in May 2025. I personally believe that ADR and mediation in particular have great potential with a view to relieving courts from unnecessary load. All our procedural codes say that every judge in the preparatory phase has to clarify with the parties to the dispute whether they are willing to choose mediation as a tool to settle their dispute. Last year, first instance courts did this 204,837 times. So they asked this question, as a result of which mediation was used one time. So they asked over 204,000 times, and mediation has taken place once. In civil jurisdiction, in civil courts, they also have this obligation. They asked this question over 1 million times in 2025. 1,000th of all the cases in civil courts have been processed by mediation. And I don't think it's a good enough result. We have Academy of Mediation. We have all those elements of infrastructure. But still, we have a problem here. Why? Why is that so? I believe, first of all, it's because of lack of trust among people. People don't trust each other. People don't trust mediators. People don't trust courts and judges. But when it's inevitable, people will have to go to the court to resolve their disputes. But when people get an opportunity to resolve their dispute through mediation, they are not knowing what it is, so they don't trust it. What Roman said about popularization of mediation, I believe that's what we have to focus on.
And they may say that, no, we don't want that. We came to court and we would like the court to help us to find the truth. However, they have to be explained that if you go through mediation, you will be reimbursed the 60% of the court fees, and the peace is better than war. So we have to work on that. The second issue that leads to this unsatisfactory result is the economy. Rephrasing calculators that economy is the driver of everything and the foundation everything. Very often the attorneys come to the hearings and they make the contracts to represent the interest of the parties and the court, not to settle the issues through mediations, because the attorneys represent the interest of the parties in court. So mediation is not something that attorneys may benefit from economically. We also have to work with defense community, and maybe they have to include to this contract the paragraphs on mediation and this way of dispute resolution. Because these two aspects, I believe, lead to the results I've mentioned today in terms of numbers. But we do need these forums. The promotion is necessary. The increasing the legal awareness, legal culture of the population is necessary because I see a wide perspective and that this area is very promising that will relieve the load on the courts and it will have the positive impact on the entire system. Thank you for the attention. If you have any questions, I'm open to answer them. Thank you very much, Mr. Alexander. Thank you for outlining the issues that require so much attention. And it's great that we're all partners here to address these issues and to overcome them. Something you've mentioned is the illustration of something we're going to do during this week. These issues are include economy, the need to work with attorneys and the judges, because this is the question of who informs about the mediation in what way. And it emphasizes that you cannot work in just one group of the population, attorneys, judges. We have to have this comprehensive approach. And that's really great that we're all in the same space, seeing one another, realizing the challenges we encounter, and together we can move forward and seek the solutions for these issues. I would like to say the word of thanks to the justice system. This is the Supreme Court that contributes to promotion of mediation. This is about the information boards that we see inside of the Supreme Court and the courts of appeal. It is all with the support of the Supreme Court because when the Supreme Court as the highest court body starts this trend, it's much better perceived on site. And thank you for the state judge administration that changed the portal of the justice system and opened the dedicated web page for mediation and how you can resolve the disputes through mediation. And I believe that next year we're going to get together this forum and to see some results, what worked, what didn't work, what we have to enhance and push forward. This is also the question of how to collect this justice statistics. We have to improve something, to change something. But one thing I know for sure, there are issues we have to address, and the CPAS recommendations and guidelines can really help us to move forward more efficiently. Thank you so very much, Mr. Alexander. You represent the justice system today, and I would like to mention that the National School of Judges of Ukraine plays an important role. They are partners in organizing this forum. This forum is also the additional opportunity to increase awareness about the mediation among the justice system and our other partners at the National Attorney Association who joined us online today. And I would like to place the emphasis that things that Mr. Alexander mentioned today are of utmost importance. So let's put joint efforts to achieve the results of mediation development in the country and the increased number of using mediation and make it more accessible and to have the result in terms of the relief of the load on the justice system and the access to justice among the citizens. Thank you very much. And now I would like to move forward and to give the floor to Mr. Viktor Dubovik, if you're here. He's the Director General of the Directorate for Legal Policy of the Office of the President of Ukraine. And it is important to hear from the Office of the President of Ukraine of their attitude to mediation, what plans you have, and what steps forward you see. Thank you very much for inviting me, for giving the floor at such a respected event. I'm a newcomer who have learned about the mediation just recently, just last year, and I would like to say the words of thanks to the justice system that they outlined these perspectives that the justice system has in terms of the mediation as it opens new horizons. Thank you to Mr. Roman and Alexandra for this framework you outlined during your presentations and during the analysis of what we already see and about the further steps and the mediation development in 2026 and on. And I would like to emphasize that the Office of the President and the strategy of the development of the justice system, we pay much attention to mediation. But I would like also to speak about another aspect. It was presented by me on last Thursday. It's a comprehensive survey we initiated at the Office of the President. This is mathematical projection of filling in the positions and the courts for future years. Why is it important in terms of mediation? We concluded that the pace of the procedural and competition procedures make it possible to at least in the 10-year horizon. And it's only under the condition that we will make this competition procedures easier, and we realize that to keep the justice system as it is regarding the open vacancies means that the access to the justice system will not improve but will deteriorate instead. We carried out the analysis based on the models used in the EU regarding the average terms of consideration of the cases at courts, and we saw from that until 2026 we see the increasing number of days for the consideration of such cases from 68 to 166 days. So this average term of consideration, the first line court. So we see a threefold increase. If we say that we look at the 10-year horizon of filling in the vacancies, it means that in a decade time, we're going to see even worse results. So in the context of understanding that today, the filling in the vacancies of the courts is struggling, and the court justice asks for facilitation of the access. Mediation is the tool to engage this procedure and influence to the average term of consideration of the cases through the relief of load on the courts and judges. And this tool will improve the situation in the justice system of Ukraine. Mediation is the tool to shape the culture of dialogue and compromises, and the nourishing of such culture is closely linked to clarification, explanation why we need mediation. We have to reshape their understanding of justice, that justice is not to win the case in court, but instead of finding the result that it will be mutually accepted, not imposed by the country, by something that the parties came up to. The statistics that Mr. Alexander mentioned shows that the understanding of mediation currently is just that it's very beginning. It's a conception stage, including in this community of judges and attorneys. Maybe we can amend the legislature to stimulate the access and to using this mediation processes. And this is our plans for this and the following years to improve the access to the mediation system and including in the context of our EU commitments. Thank you very much. Thank you, Victor, and thank you for bringing this perspective to the understanding of mediation development, because this is about ensuring access to justice, but it can only be achieved if we work consistently both with judges and attorneys, as well as the representatives of other legal professionals. So we speak about the legal ways and using and mediation as the dispute resolution mode. We're looking forward to the results of this survey. We will add it to the forum materials. I have it on my Facebook page, so please follow me because I posted there the summary and the recommendations. Thank you very much, Mr. Victor, including for finding the place for mediation in the program documents that the Office of the President develops. And now I would like to give the floor to Ms. Olga Hildyushkina. Are you here? I cannot see you for now. Then Mr. Олександр Олійник, are you with us already? Yes, hello. Then I'm giving the floor to Mr. Alexander, who represents the Ministry of Justice of Ukraine. Today, he is also responsible for the roadmap on the rule of law, and Alexander is also takes care of Interagency Coordination Council that Mr. Roman referred to today already. Alexander, over to you. Dear colleagues, hello. Thank you for, Luisa, thank you very much to you for the introduction, for organizing this large-scale forum on mediation and law. This is the 10th one, and I congratulate you on that. And thank you for this profound analysis from the previous speakers. Mr. Victor, I believe that maths, not only the science, but the queen of our mind, and something that numbers speaks to eliminates any disputes on the importance of something. And Mr. Alexander mentioned the numbers that outlines objective picture of what we have here, whether people go into mediation or not. And when we speak about the court cases, we can see that the courts mentioned that they have this opportunity. How they word it, that's another thing. And statistically, in 2025, very few, if any, cases were settled through mediation. Within the Ministry of Justice and the Interagency Committee, we also asked this question, why is that? And we looked closely at this question. We heard several answers to these questions, both from Mr. Alexander and Mr. Roman. Probably we don't need some economic predisposition. Those who are a part of this forum, ask yourself a question. Can you advise a good attorney to a party that comes to you? Probably yes, likely yes. And can you recommend a good, competent notary if you need to take some notary activities? But can you recommend a good mediator that will help you to resolve the disputes? That's the question. I have other examples in my life. A mediator I know would send the people she knew to that mediator, and the mediation failed, actually. It wasn't successful. Why that could happen? As of now, due to various objective and subjective reasons, we do not have this mediation market. Not yet. It is quite fragmented and granular. And we don't have certain criteria regarding the quality of services, some general criteria. We don't have the criteria for quality control for such services, and we don't have the responsibility for violation of this quality. So we don't have this mediation institute that would have trust of people for various reasons. So that's the reason people do not go into mediation because they're concerned who they're going to go to, what if something goes wrong, how we can address this issue. Within this Interagency Coordination Council, we agreed on the following. The Minister of Justice, with the coordination of mediation community and the courts, is going to launch the pilot project. According to Savage recommendations, is something that Mr. Victor and Alexander mentioned. It may become the ground for the legislative amendments provided in the codes before going to mediation, before going to court. The pilot project will imply, on one hand, will establish certain responsibility. This is something to be discussed with the Supreme Council of Justice, with the Judges Council regarding the way the courts are going to inform the parties regarding the mediation. And this notice, this information will provide the information that there is this pilot project, and I will speak more about that. That the parties can go to mediators selected within this pilot project. So, in a certain way, the state in certain way ensures the quality of the service provided by the mediator. If the parties are interested in mediation, they will have certain perks. Namely, this is reimbursement of the court fee. That's maybe saving some money on the further court fees. This is the attorney fee, some additional expertise conclusions. We heard that there is a threefold increase in the number of case consideration because potentially the duration of consideration of the cases may be reduced. Then we may emphasize on the preparation phase into the court hearing and engagement mediation in that. So we will encourage the party or the parties to reach out to a mediator who will be part of this pilot project. We also discussed whether the state can provide it free of charge. We discussed that with centers of the Free Legal Aid Center. Maybe you're not aware of the fact that we have the Ukrainian Center of the Free Legal Aid, and we launched this pilot project of using mediation in terms of this recovery justice regarding this juvenile crimes. And 70% of people who go to the coordination center for mediation use this service. And regarding this cooperation with these underage children, and this is they discuss the settlement for to compensate the losses of the victims, and it influences the future of these children. And The Free Legal Aid Center reimburses the fee for the mediation services. We have this register of mediators at the coordination center, and using this format, we're going to have this registry where we select the mediators for this information familiarization meetings within the cases when the court forwards them to the mediators through this pilot project. Of course, they do not. This is not an obligation to go to the mediators who were selected within the project, and the people who have the certificates. Well, who believes they're mediators or not? That it differs.
Хтось би хотів, але от немає доступу до клієнтської бази. Тобто сторона може звернутися
Some people
через
do want to
спеціальний
do this, but they don't
відповідний
have
медіатор
access
створений,
to
і
client
далі
space.
1000 справ
So
буде
a
вкладатися
register
бюджетний
is a
механізм
good
ще грошей.
development.
Ці інформаційно-оціночні зустрічі з медіатором буде
These
безкоштовно,
first
розвивається
information
кожен місяць.
meetings will be free
Юридично
of
тут ми
charge.
бачити не можемо, але я думаю, у них проблем немає.
I'm
Але
sure
для
it's not going to
фізичних
be a
перші 1000
problem,
справ
but for the physical persons,
будуть оплачувати за рахунок держави.
the state will cover the cost of this information meeting when the parties just meet a mediator and get basic information. If the parties decide to move on with mediation, they do it. Otherwise, they will go back to court. At the pre-trial session, judges will ask if parties have attended an information session with the mediator without going deeper into details. But there is several scenarios how things can develop from here with the parties, up to all the way up to resolving dispute outside of court. What are we doing with this development? Having mediators more available and accessible to the parties, including through online tools. We want to see if parties will use this option. We want to collect some statistics on how willing the parties are to use it. Then the state will support this. All mediators will be able to engage in this process. As for the methodology and the materials for the information sessions, we need to be very clear about each dispute, whether it's mediatable or not. Leaders of mediators community have to work together to develop necessary materials. That's what we have now. We, at this latest session of IACC, supported this pilot. Once we are in line with all the stakeholders, including the judiciary, we will revisit the program all together so that we know all the managerial nitty-gritty details. Probably the Council of Judges will also have their own recommendations. What will we get in the long run from this pilot? First of all, we will see if this kind of approach will be efficient when the judges give out these memos during the pre-trial session about mediation. We want to see how many people will use mediation. That will give us some baseline, which we will be able to analyze, to improve and build on. So on the one hand, mediators will have more work. On the other hand, we will measure the number of cases resolved by mediation that would alleviate some workload off the shoulders of courts. And all of that will enable us to do further steps in changing, reforming our system. We hope that this pilot will be launched in 2026, and then in 2027, we will be able to analyze the results by the end of 27. Thank you.
Так, дякую. Дякую, пане
Thank
Олександре,
you,
за те,
Alexander,
що розповіли настільки детально
for
про цей
your
поки що
detailed
заплановане,
overview of this
як він буде втілений.
planned pilot project.
Сподіваємося, що найближчим часом в
We
межах
hope
міжвідомчої координаційної
that
ради матимемо
Interagency
можливість всі
Coordination
разом це
Council
обговорити,
will
прийти
be
до
able to
якихось конкретних
discuss
рішень,
all
в
of
тому
that
числі, зокрема,
together,
чи
finds best
через рішення
solutions
Ради
for each
суддів
issue.
України, чи якимось іншим
Maybe we
шляхом
will
для того, щоб
use
запровадити
as a tool, we
цей
can
пілот.
use a decision
І
of
насправді роль Міністерства юстиції є
Council of
надзвичайно
Judges
важливою.
or some
І,
other
як я вже сказала, і в
mechanisms.
контексті
The Ministry of Justice
євроінтеграційних
plays
процесів,
a
і
very
в контексті,
important
звісно,
role both
забезпечення
for
діяльності
mediation
цієї
and
міжвідомчої
for
координаційної ради.
the
І
EU
сподіваємося,
integration
що далі
process
буде
as a whole.
існувати ось
And
такий
we
тісний
hope
діалог
that we
між
will keep
організаціями, між
being in this
медіаторською спільнотою, між представниками різних органів
close
влади.
dialogue
І тут одразу
among
хочеться
all the
звернути увагу, що
stakeholders.
в нас є
I want to
медіатор,
highlight
який
here
тільки
that
медіацією
we
займається,
have
і, на жаль, це
mediator
не можна
who
побачити
is
через
focusing
статистику, бо,
only
наприклад,
on
в нас немає такого
mediation.
виду економічної
It
діяльності.
cannot be
І
measured through
якщо він
statistical
з'явиться, то
data
я
because
зможу,
we
як
don't
медіатор,
have this
наприклад,
as a
звітувати,
separate
і буде в статистиці
um,
видно, скільки в нас сьогодні,
economic or business
наприклад,
activity.
фізичних осіб-підприємців або
Once we
організацій,
have
саме
this in
займаються
place, we
наданням
will be
цієї
able to
послуги.
see the statistics, how many
Сподіваюсь, що ми
mediators
зможемо
do
це так
just
само
mediation, nothing
найближчим
else.
часом на міжвідомчій
Hopefully, it
координаційній
will
раді
be
ці питання
discussed at the
підняти, щоб
following session, at the next
питання
session of
статистики,
the
удосконалення теж
Coordination
це
Council.
має важливе значення, бо
Statistical
вимірювати можна
data are
по-різному.
important,
Щиро
but
вам
how we
дякую.
measure
Зараз
the data,
тоді
how we
хочу
collect the
передати
data is also
слово.
important. Thank you very much
В
once
нас
again. Now, let me give the
інше
floor
зараз
to
заплановане
the next
напрям нашого
speaker.
руху. І ми зараз поговоримо трішки
Now we
про
are going to switch the topic a
медіацію в
little bit.
контексті
We are going to
оподаткування.
talk about
І в нас
mediation
зараз
in the
як
framework
присутня
of
тут пані
taxation.
Леся Карнаух, яка є
Lesa
виконуючий
Karnauch is
обов'язки
here
голови
with us.
Державної
She's an
податкової
acting
служби
head of
України.
the State Tax
Пані
Service of Ukraine.
Леся, дуже
Lesa,
прошу вас нас ввести в курс
please
справи
enlighten
стосовно
us
планів,
about
чи є
the
якісь
further
плани на
plans
медіацію, на інші якісь
related to
розвиток альтернативних
mediation
способів
or
вирішення
other
податкових
ADR
спорів,
mechanisms
і
in
взагалі
tax-related disputes.
якою є в цьому напрямку політика
What's the
саме
current
Державної
policy
податкової
of the
служби?
state tax service
Вітаю,
of Ukraine?
колеги, вітаю учасники конференції. В
Greetings,
першу
dear
чергу хочу
colleagues
подякувати
and
Українській академії медіації за організацію
attendees
цього
of the
заходу.
forum.
Ми його чекали
I
вже
would
півроку,
love
і
to
ми активно
thank
співпрацюємо з Українською академією
Academy of
медіації,
Mediation for
адже
organizing
ми
this
у
forum. We
Державній
are
податковій
actively
службі наразі
cooperating with the
реалізуємо
Academy.
пілотний проект з
We are
спільної
now running this pilot project
альтернативного
at the tax
вирішення
service,
податкових спорів шляхом
where we
медіації.
are
Але
piloting
розпочну я трошки
mediation
з
as an
мотивації,
ADR
розпочну
of
я, чому ми до
tax
цього
for
прийшли.
tax
Тому що
related
питання
disputes.
оподаткування і питання справедливості виконання своїх податкових
Taxation
зобов'язань, вони турбують не тільки Україну, вони
issues
турбують
are
практично всі
hot
країни
and
світу.
very relevant
Усі
for
податкових
Ukraine and
адміністрацій світу
other
розглядають те
countries of
саме
Ukraine.
питання, яким чином
Tax
забезпечити
services
високий
throughout
відсоток
the globe
добровільного виконання податкових зобов'язань.
think
І яким
about
чином це зробити
how
настільки
to
легко і
improve
просто для
the
того, щоб у платника податків не виникало
tax
ніяких сумнівів в
obligations,
необхідності
how
співпраці і
the
належної
citizens,
держави.
how can
І
we make
жодна
citizens
податкова
fulfill
адміністрація
their
не знайшла
obligations?
відповіді на це
Neither
питання і постійно
us nor
набувають
other
хвости. Це
tax
робиться шляхом
services in the world
посилення
have
фіскально-квантового
found
методу виконання податкових
a silver
зобов'язань.
bullet for
Хтось
that
робить це шляхом
issue.
автоматизації,
Some
перезаповнення і створення
countries use
корисних сервісів, тобто
automation,
всім відома Естонія, і
like
є така
Estonia, for
концепція
example.
це реальної економіки, коли
They have this
безпосередньо
real
розглядається
economy
платник
concept
податків
when
держава і податкова адміністрація як
taxpayer
партнери.
and tax service are seen as partners. Our country is also using this concept. We at the tax service we are using this service orientation. We want our services to be as comfortable as possible for the citizens. Why is it important? In 2024, State Tax Service of Ukraine conducted a survey using World Bank methodology to measure level of trust. Unfortunately, we have seen very sad results, and that means that we have to find new alternative ways of communication with the citizens, with taxpayers, and increase the trust. Some statistics. At the moment, State Tax Service of Ukraine has around 33,000 disputes handled by courts. And it means that a huge number of our officers are dealing with those disputes. Branches of our service that are responsible for the court cases consist of 72 officers. On average, we have 12,000 court cases per year where we are a party. And that's a lot of work for our responsible officers. That's a very high workload. So on that and other requirements towards us made us join this pilot project together with Ombudsman, where we business ombudsman, where we use mediation as a mechanism. We have 3 successful cases so far. What do we see there? These cases are dealing with high amounts of money, and taxpayer chose to resolve this conflict outside court, and that for us meant lower workload. This positive result inspired us a lot to use this procedure more. And so we have revisited the current legislation that regulates all the tax-related disputes. So we developed a respective bill together with, and we are very grateful to the Ukrainian Academy of Mediation for the consultations they provided to us. So we have developed this bill on alternative resolution of administrative disputes through tax mediation. We have worked with a lot of details. We understand that tax mediation is not a silver bullet. It can be only when there is a complexity of existing legislation in this field. So the tax service, it's when tax service believes they are right, and the taxpayer believe they are right. In such cases, what matters is behavior of both parties. So based on preliminary communications between parties, cases usually end up in court, and payments, court fees are not that high, and that enables some delays that can be good for taxpayers in these cases. The state has to collect taxes to cover the costs, including the defense sector costs, which are so important now. That's why this disruption in tax payments due to the prolonged court cases is not optimal. So we chose cases where mediation could be a good option, and we took care of not making mediation substitution therapy, so to say. We made it very comfortable for both parties, and we paid a lot of attention to questions of who can be playing the role of mediator of these cases, so that legal implications of disputes settled through mediation procedure would not escalate the conflict further. We have an intention to carry on running this pilot project. We are going to get a go-ahead from the Ministry of Finance for our draft law, and we will have consultations with the entrepreneurs, with businesses. We will have the broad consultations with the respective institutions and stakeholders. We have to work together to unload the judiciary and ensure that tax payments are carried out in timely manner. Like I said, these draft laws will soon be up for public discussions. And once again, let me highlight that we are aiming at making tax service of Ukraine as service-oriented as possible. We have to make sure that taxpayers do pay taxes. That's what we do. Thank you so much for your attention. Thank you, Olesya, for sharing your perspective on further development of mediation or maybe ADR in general. On my behalf, I would like to thank you for openness to dialogue and communication, partnership. Despite the huge workload you have, I would underscore that tax service officers still manage to find time and take part in many initiatives, including 2 trainings. Despite all the challenges, we see your dedication and commitment. And what you say about service orientation are so meaningful. We see a lot of work you are investing into this. Thank you so much. Let me just say one more thing. To help develop mediation in an administrative sector, our academy, together with other partners, initiated establishment of interagency entities, and now tax service is part of this initiative, and other institutions of executive power. We will try and see how the dialogue can be facilitated further between businesses, state, and us. Now, let me give the floor to Olga Kildyushkina. She is representing the Vice Prime Minister for European Integration of Ukraine. We have heard today already that mediation is a hot topic for everyone, and it's one of the issues to be dealt with on the way to European integration. And Ukraine is paying a lot of attention to this issue. Thank you. Olga.
Пані Луїзо, вітаю, колеги.
Thank you,
Дякую.
Luisa.
Мене чутно?
Can you hear me?
Чутно прекрасно.
Yes, we can
Супер,
hear you
чудово.
very well.
Я теж рада вас всіх бачити. Вражаюча
I'm
кількість
also happy to
учасників.
see all of
І
you, an
кожного
impressive
року
number of
це
participants, and
суперпродуктивні дні
each year
форуму. І я дуже
this
вітаю
event is super
Академію з
productive,
останністю.
and
Це
I
вже десяте,
congratulate
що
for such a
відбувається.
consistency
Дуже приємно бути частиною
because it is the
цього
10th time
обговорення
we
і
have such
частиною цієї
event. I'm
спільноти.
pleased to
Бо
be a
сама
part
я
of
є
this
медіатором,
community
я не
and
практикую, але дуже
communication.
добре
I'm a
знайома з
mediator
процедурами,
myself. I do
свободами
not
і
practice, but
перевагами
I'm
цієї
widely aware with the
процедури. І щиро
benefits,
вболіваю
issues, and the
за цей
procedures of
підхід в нашій країні, в нашій правовій
this
системі.
activity, and I'm rooting for
Сьогодні мені дуже
mediation
зручно
in our
оскільки я
legal
говорю
system.
після
That's very
всіх
comfortable
гілок
to
влади і
speak for me
навіть
after because I
після
speak after all
податкової, тому
branches
що
of power
це показує,
and
наскільки
after
медіація є
the tax
універсальним
service.
інструментом.
It
На самому початку
demonstrates how
розвитку
universal
цього
mediation
цього
is.
інституту
At the
було
very
чітке
beginning, at the inception of the
протиставлення.
development of this
Є суди
institution,
і є
was
от
clear
альтернативний спосіб
division. There
вирішення
is the
спорів,
court and
і от
there is
це наш шлях, от
ADR. And this
розвантажити
is
суди.
how we
Тепер вже
see it, to
абсолютно
relieve the
очевидно, що
workload on the
медіація це
courts.
абсолютно
Now it's quite apparent that
універсальний
mediation
автономний
is the
інструмент,
universal
який є
autonomous tool.
частиною
It is a
великої
part of
системи засобів
bigger
вирішення спорів,
ecosystems of
куди
the
також
means of
включені і суди,
dispute
і
resolution.
арбітражі,
It
і
incorporates
переможці. І
arbitrary
фактично, дійсно, тільки що
negotiators and courts, of course.
пані
And
Карнаух сказала,
Ms.
використала вираз
Karnauch
послуги
used this
держави.
word,
Дійсно, держава має
the
забезпечити, щоб ця
state
екосистема
services. And
працювала
indeed, the
як
state has to ensure
ефективно,
that ecosystem
передбачувана, і щоб
is
кожен
predictable,
учасник і кожен
efficient,
громадянин, і кожен
and
бізнес
that
мали
every
можливість
participant,
обрати,
every
з
citizen,
чим саме
every
їм треба
business can
скористатися в тій чи іншій ситуації,
opt for
і
a certain
який
tool and
інструмент
a
в тій
certain
чи іншій
situation,
ситуації буде найбільш
and
ефективним.
which tool is
І
going to
дійсно,
be the
сьогодні
most
вже мої
efficient and
колеги
applicable in
попередні
certain
доповіді
situation.
говорили про
The
те, що
previous
медіація це
speakers
про довіру.
mentioned that
І це
mediation is
таке,
about
знаєте,
trust,
той наріжний
and
конець в цьому
it's the cornerstone
цьому інституті, оскільки
of
це довіра
this
і до
institution, because
сторін
we
одна
speak
до
about the
одної,
trust of
і до
parties to
третьої
one
особи,
another
тобто
and the trust to
до
a third
медіатора
party to
довіритися
mediate,
фактично незнайомій людині, яка
to
допоможе
trust
пройти цю
a
процедуру і
stranger who
допоможе
will
знайти
help to go
вирішення.
through the
Але
procedure
головне
and find a
це те,
solution
що це
is
довіра до
very
того
important.
і
But what
впевненість
is
в
also
тому,
important
що
is the
сторони
trust
можуть вирішити ці
that the
успішно і
parties can
спільно і
actually
забезпечити
resolve
правильність результату.
the dispute
І
independently and ensure
сьогодні
the
вже і пан Бадій, і пан Мамой
sustainability
казали
of
про те, що
this result.
дійсно ми
Previous
ще як
speakers mentioned
країна
that as the
маємо
country,
докласти значних зусиль
we
для
have
того,
to
щоб
put
плекалася ця довіра
serious
всередині
effort
нашого
to
суспільства.
nourish this
І ми зараз
trust inside
знаходимося
of
в дуже
our society.
непростому
We're in a
історичному
very
моменті,
challenging
але тим не
historic
менш
moment now,
ми не маємо опускати
and
руки.
yet we have to
І
keep going
дійсно,
and not
коли ми
give up.
говоримо про
When
євроінтеграцію,
we speak about
то ми
European
вже
integration,
не тільки щодо медіації, але й
it's
щодо
not only
інших
about
інституцій,
mediation,
ми
of course, but
говоримо
also
не про
about other
прийняття
institutions.
законів
It's not
чи
about
розробку
adopting
якихось
laws
процедур
or developing
чи
certain
створення якихось
procedures or
інституцій.
creating
Ми
certain
говоримо про
institutions.
сталість і
We speak
ефективність
about
тих
sustainability and
інструментів, які в нас
efficiency of
вже
the
є в
tools
руках.
we already have.
І як я вже сказала, головне, що ми
And
включаємо
the main
медіацію в
thing is
ширше
that
коло
we
питань.
engage
Те, що
mediation in a
медіація
wider
вже
scope of
на рівних
issues.
правах
Mediation
і
is
дорожнього права,
is
соціального
now
господарського права,
engaged
і
in
в
the equal
стратегії
terms in the
реформування
roadmap of rule of
правосуддя і
law and
конституційного
into the
судочинства,
strategy
говорить
of
про те, що
reforms in the
медіація вже
constitutional justice and
виросла з такого
rule of
дитячого
law.
віку, коли її
It all
сприймали
means that
як
mediation is
якщо
now a grown
додатково,
up.
якусь
It's
таку,
not
знаєте, екзотичну
seen as
процедуру,
something
яка
auxiliary, some exotic
працює, якась
procedure that
магія там
may
просто
work
прихована,
and that's
така.
like
Тут
some
ми
magic
да,
is
всі
going to
поговорили,
work.
десь вирішимо.
Everyone talks and they
І
found the
сьогодні ми
solution.
бачимо, що вже на рівні
Today, we can
держави є
see that at
абсолютно
the
чітке розуміння
state
розуміння
level,
того,
there is a clear
що медіація є
understanding
одним
that
з
mediation
інструментів
is one of the tools
розбудови і ефективного функціонування нашої держави.
Development of
І
the
ці
efficient
точки зору
functioning of
держави
our country. And
інвестується і час, і
from the state's
зусилля, і ми це
perspective,
чули в
we
деяких
invest the
доповідях,
time
про
and
те, щоб
effort. We heard it from
правила,
previous
за якими
speakers.
функціонує
The
медіація, а також
rules
інші
that
процедури
mediation
є
functions
зрозумілими,
and other
є
procedures should be
сталими,
understandable,
є ефективними.
sustainable,
В той же час
um,
велика роль
and
щодо
consistent. At the same time,
медіації і поширення все
the
ще лежить на
promotion
медіаторах.
of
Дійсно,
mediation is on
тільки
mediators'
спільні
shoulders in
робочі
the first
вчинки в
place. Only
координації
concerted efforts
можливий
in the
якісний хороший
coordination,
результат.
it is possible to produce
Якщо ми
the high
говоримо про
quality results.
євроінтеграцію,
If we speak
то
about European
дійсно
integration,
ми як держава звітуємо по
as the
виконанню
country,
дорожньої
we
карти,
report about the
і
fulfillment of the roadmap.
пан Олійник вже говорив про те,
And
що
Mr.
робить
Olinik
Мін'юст.
has already
Мін'юст також збирає
mentioned
інформацію про те,
what
що
the
роблять
Ministry of
інші
Justice
інституції,
does. They
для
also
того,
collect the
щоб ми
information
продемонстрували
about
нашим
other
європейським
institutions'
партнерам,
activities.
що
And
дійсно ця
we
робота
have to
здійснюється.
demonstrate to our EU partners that
Цей
we
інститут,
continue the work that
знаєте, все більше і
this
більше
institute
нарощує м'язів для того,
has
щоб дійсно
uh,
стати
is becoming
повноцінним
increasingly
механізмом
stronger
вирішення
to
спорів в рамках
become the
нашої правової
full-fledged
системи.
mechanism of dispute
Дійсно, ви
resolution
сьогодні
within
вже
our
згадували про
justice
те, що
system. It was
це
already
особливо
mentioned
актуально для
today
нас
that
в
is
умовах війни.
especially relevant
Ми
during the
говоримо
wartime.
про зовнішніх
And
ворогів, але
we
тим не
speak
менш
about the external enemies,
все
but
це
also
навантаження психологічне, воно створює
this
новий конфлікт
mental health
і
load
поглиблює старі.
triggers
У нас все
the
більше
new
є
conflicts
напруги в
and
громадах, в сім'ях
deteriorates the old
під
ones.
час
We can see the increasing
трудових
tension
відносин.
in the
І
families and
окремий блок
the
питань щодо
communities and
відносин,
in the
щодо взаємодії
labor
громадян з державою.
interaction. And
І все це потребує
the
того,
including
що
the interaction
і
of the
на рівні
citizens with
держави,
the
і на
state.
рівні
At the
професійних
level of the
спільнот ми
state
маємо
and
говорити про те,
professional
що в нас
communities, we
з'являються
have
нові
to
потреби, і нові
speak
конфлікти
about the new
потребують нових
challenges we
вирішень.
see, and new
І
challenges
дійсно
require
дуже
new
важливо, і
solutions.
це видно не
And
тільки під час таких важливих заходів
we
публічних, але під
consider
час
its
щоденної
importance not
роботи
only
і
during these public
асоціації,
events, but during the
і академії
everyday
адвокатури,
work of
творів
the
медіації.
Academy
Я
of
переплутала всіх, але
attorneys
всі
and the
урядові
Mediation
організації,
Academy.
всі
Oh, I
професійні
beg it.
об'єднання
But all the
дійсно
professional
інвестують багато
communities
зусиль. Ми
invest
дякуємо, звичайно, нашим
lots
донорам
of
і міжнародним
effort, and we're
партнерам,
thankful
які
to our donors, the
надають
international
фінансування на
partners
це,
who support us
для того, щоб
financially,
дійсно
to
в кожному маленькому
make sure that
маленькій сфері
each
ця робота йшла з
smaller
самого низу.
segment
Ми не можемо нав'язати медіацію зверху, ми не
worked
можемо
well
перевірити
within. We
всіх,
cannot
які
impose
демонстратори. Ми
mediation
знаємо,
from
наприклад, інших
up
країн, що це
down.
не
We cannot
призводить
force
до
people to
ставлення
go to
високої
mediators.
цього
We could
інституту,
see the practices
але
of other
робота
countries
і
that it does not
поширення
contribute to the
медіації і найкращих
sustainability
практик
and
на
stability of this
рівні
institution. But
громад,
the
тих
spreading
колективів
of best
сьогодні будуть
practices
нести
at the
тяготіння
level of
на рівні шкіл, це
communities,
дозволяє
schools,
розбудовувати
and
дійсно потужну
the
систему.
talents within the
Я хотіла б
organizations
вже
makes it possible
підсумовуючи
to build a
сказати про
really stable,
такі
powerful
важливі
system.
якби
At
тези
the end, I would like to
озвучити, це те,
highlight
що дуже важливо розуміти, де
that
саме знаходиться
we
медіація
must
в
understand
системі правосуддя.
the
І ми
place
вже,
of
на
mediation within the
щастя,
justice system.
відійшли від
Fortunately,
тотожного
we
правосуддя і судів.
no longer
І під час цього
equal
форуму це також
justice and
простежується.
courts, and we can see
Дійсно,
during this
важливо
forum too.
фіксувати постійно і
It
нагадувати
is
про те,
important
що
to continuously
система,
register and
яка
remind
існує в
people
Україні,
that
вона
ecosystem we have in
повністю є
Ukraine
такою, яка
is
забезпечує
the one
вирішення
that
спорів медіації
ensures
як
the
одним з
dispute
інструментів.
resolution, and the
Друге
mediation
питання
is
це теж
an
сьогодні
important
згадували.
tool
Це питання
here.
якості
Another
медіаторів і
issue is
якості
the
їх роботи.
quality of
І тут
uh,
дійсно величезна
services of
робота йде
mediators, and
професійної спільноти
we can see that
щодо
professional
забезпечення
community works
виконання
hard
професійних стандартів,
on
щодо
ensuring the
дотримання
professional
етики, щодо належної
standards, the
відпустки.
code of ethics,
І
the
вся ця робота має
proper training,
продовжуватися і
and
має
this work
посилюватись.
has to continue and
І
become
в
enhanced.
контексті цього також важливо сказати
And
про
in this
правничу спільноту.
context,
Ми
the legal
правники маємо
community is
також
also an important
підтримувати
component
і
here. We
бути
have to
дуже
support
обізнаними
and
про роботу наших
to
колег
be
медіаторів.
widely aware
Ми
about the
маємо і
work of
судді, і
our colleagues,
адвокати,
mediators, both
і інші
judges,
правники мають
attorneys, and
чітко
other
і
legal
зрозуміло
professionals have to
пояснювати
have
і
clear
клієнтам,
understanding and be
сторонам
able to
про
explain
те,
to the
які
parties, to
варіанти
our
дійсні.
clients about the
Вже ми
options they
відійшли
have.
від
We
одного дня в суді, як казали колись.
stepped away from one day in the court seen as the access to justice, that somewhere everyone can come and see a judge and submit the case to the court. It's not only the case, and the legal, as legal professionals, we have to speak about that to the businesses, to citizens, and now that business mediation develops actively
Маю
too.
сказати, що ми маємо продовжувати
We also have to
якби вдосконалювати і
continue
позиції,
to
і
improve the
законодавчу історію.
policies and
І
legislative
це дуже
framework in
сильно
this
пов'язано
area.
з тим, що
It is
медіація
closely
як
linked
інституцій
to the
не
fact
стоїть на
that
місці, вона
mediation
розвивається.
as an
І
institution
завдяки таким
does not
заходам
stand
ми
still. It
почули
keeps
різні ініціативи
developing,
саме в
and
контексті судовому
thanks to
і
that,
європейському.
thanks to such
Вони
events
вже
like this, our mediators
колись ми навчалися
in
від
the
наших
European
європейських
and
колег.
global
Тепер ми
context.
вже
At some
разом із
point, we'll
колегами
learn from our
обговорюємо і
European
будь-які питання
colleagues now,
і
where
будуємо нашу
on equal terms
спільну
discuss some
спільне бачення
challenges
і
and
спільне
issues
розуміння
and build
цих
up
ситуацій.
our joint vision of
І
challenges
наостанок
and the
хочу сказати,
situations.
що найважливіше це
And
поширення
the most
інформації про
important thing
медіацію.
is spreading
Це
information about
комунікація, це поширення
mediation.
цих історій
This
успіху.
is about the success
Дійсно,
stories,
є
the communication.
велике питання в тому, що медіація
The
це
big
процес конфіденційний, часто
Of
сам
course,
факт
the
медіації є
mediation is
конфіденційним. Дуже важко
the confidential
розказати про
process, and the
успіхи,
fact of mediation is
тому що
confidential.
немає
So
можливості
it
розкрити цю
may be
інформацію,
quite
але
difficult to
тим не
speak
менш
about
це
success
треба
stories
говорити,
because
треба
you cannot
говорити
disclose this
простою мовою,
information. But we have to
пояснювати,
speak about that and in
які є
simple
переваги
words, to
в
speak
цього
about the
важливого
benefits of
інституту,
this important
і
tool.
таким чином
And
будувати базу
in
для
this
того,
way,
щоб
we will have to
ця
build the
процедура
foundation
працювала і
to
була
make
дуже ефективною.
this procedure to be
Наостанок
as
хочеться
efficient as
сказати,
possible.
що дійсно європейський вимір медіації в
Uh,
Україні це
when we
по-перше,
look at the
універсальність
EU
приймати медіацію як
perspective in
вихід
Ukraine,
дискусій.
means that
І це ми
no,
розуміємо,
that
що
we no
це
longer
частина
see mediation as an
сучасного вірусу.
alternative. We see
І
it
для
now
нас
as the part
це
of modern culture.
те, що
And
довіра не будується через рішення судів. Вона
trust
будується
does not
тоді,
build
коли люди
through
беруть на
the
себе
court
відповідальність,
rulings.
вступають в
It is
діалог,
built when people take
домовляються і
responsibility, step
забезпечують
into the
тривалість
dialogues,
цих домовлень.
settle, agree, and
І розвиток
ensure the
медіації це не про те,
continuity
що
and
ми хочемо
sustainability of these
якимось новим чином вирішувати
agreements.
спори,
Mediation is not
а про те,
about
що ми
new ways
формуємо
of
правову культуру в нашій країні.
resolution,
Ми
dispute
підтверджуємо, що
resolution. It's
наші
about building
інституції
this
є
legal
сталими і
culture in
дієвими,
Ukraine.
і про те,
We
що ми
rest
як
assured that our
суспільство
institutions are
вчимося працювати з
sustainable and
конфліктами.
mature, and
Ми
that
їх
we
не
as society
замовчуємо, ми
learn how
їх
to
не
work with the
доводимо до
disputes. We
точки
do not
кипіння,
bring it
але
to the
ми
boiling point. We
застосовуємо
do not
інструменти для того, щоб знайти
turn a blind
рішення
eye to
і
it,
через
but we
діалог
use the tools
розбудувати нашу державу.
to find
І
the
це особливо
solution and
актуально
use the dialogue
зараз,
to
дуже
build
актуально
our
буде після
country,
нашої
and
перемоги,
it will be
коли буде
especially relevant after
велике
our
відновлення і
victory
на
when we're
рівні
going to go through
інфраструктури, і на рівні
major
інституційного
recovery
керівництва.
at the
Я
level of
дуже вам дякую
infrastructure
за
and our
можливість сьогодні бути
societal
тут.
social
Буду
relationships. Thank you
залишатися
very
тут,
much for the
послухати
opportunity
ще
to be
доповіді
here.
колег.
I will stay with
І
you because I
сподіваюся,
want to
що це
hear the
буде
colleagues'
захід, який, як вам обіцяла,
presentations.
під час якого ми
And
звіримо годинники і
I
будемо
believe
готуватися
that
до того, щоб
that's
на
going to be
наступний
the
рік
event that will
розказувати
enable
вже
us
про
to
результати
synchronize our
пілотних
effort.
проєктів
And next year, we're going to
і
speak about the
інших
results
заходів.
of the
Дякую,
positive
пані.
results of our pilot project. Thank
Дякую,
you
пані
very much.
Ольга, і за
Thank you, Ms.
підкреслення
Olga.
європейського
Thank you
виміру
for
і
bringing
за
the
всі
European
ті,
perspective
знаєте,
here
такі
and for
висновки, які ви
all those
зробили,
conclusions
підсвітили.
you
Звісно, роботи
highlighted
багато і
here. There are a
точно
lot of work
те,
to
що
do ahead,
стосується, знаєте,
but
це форум, це якщо тут це вже озвучено, то
if
треба буде
you
обов'язково
voice that on this
переговорити.
forum, it means that you will
Ці
have
пілотні
to
втілювалися як
speak
що
about the
планують,
results of this pilot
бо
projects. You'll
дійсно
have to speak about the progress.
треба давати таку актуальну інформацію.
You
Дуже
have to
часто
provide
ми
this
не знаємо,
relevant,
що
timely
відбувається.
information.
Скільки багато
Sometimes we do
роботи
not know what's
втілюється,
happening.
наприклад,
We
та ж
may
сама
not be
система
aware
зарплат виробничої
about the
допомоги на
work
рівні міністерств, на рівні
being
окремих
done.
закладів.
For
Але про
example,
це
there's a
просто
free legal
невідомо
aid centers at the
широкої
different
кількості
levels, but not
населення, людей,
many
і
people
ось такий форум
are
можливість
aware of that. And this forum
окреслити
is another
всі здобутки і
opportunity
всі плани.
to highlight all the
Дуже
plans
вам
and all the
дякую. І тепер
achievements.
хочеться
Thank
перейти
you. And
саме
now
до
I would like
однієї з
to
служб, яка
give the
багато,
floor to one of the
надзвичайно багато
services
протягом
that
цього року зробила
during
для
this
розвитку
year has done
медіації
a
в
lot
контексті
to develop mediation in the context of labor legal cooperation. Mr. Dmitro, are you with us? Dmitro is the head of the National Mediation and Reconciliation Service. And before giving you the floor, I would like to thank you in advance for all the achievements that during the short period of time, just a year, you managed to achieve. You trained the pool of professionals, but I'm giving the floor to you for you to share. Hello, dear participants of the forum. Thank you for the invitation. I used to be the moderator of one of the panels last year, but this time I'm finally invited to as a speaker. Thank you for that. The National Service of Mediation and Reconciliation focuses on promotion of mediation in labor cooperation, the collective labor disputes since late 2022. In October 2022, we created the Interagency Working Group. It dealt with draft law on the collective labor disputes. This draft law provides for institutionalization of labor mediation as the specializations of mediators with a basic level according to the applicable law. We carried out 53 meetings of this working group. The group incorporates the social partners, the trade unions, employers. It also incorporated the international experts as well as the representatives of the leading academic institutions and other institutions. As a result, we drafted the law on the collective labor disputes registered by the group of the MPs, group headed by Ms. Tretyakova on the 16th of September 2024. The draft law was approved by the committee for the first reading, but as Mr. Babi mentioned, it is expecting for its window of opportunities to be put on voting. The provisions of this draft law in terms of labor mediation were submitted as the part of the labor code registered under the number 14336, and it's now anticipating for the first reading in the Verkhovna Rada. Apart from the 53 meetings of the working group that were taking place through 2.5 years, well, already have about 23 meetings of the group, of the working group initiated by the committee itself, and the results were well coordinated and approved. We also gained the technical memorandum of international labor organizations with 15 remarks, 13 of which were taken into account by the members of working group. We have two alternatives. This is either the draft law 120/24 or the draft of labor code book 4. Both of these documents provide for institutionalization of labor mediation. Accordingly, without waiting for the adopting of these regulations, jointly with the partners, we took part in the development of the professional standards of the on labor mediator. In March of 2024, it was approved by the National Qualification Agency. With the support of the International Labor Organization, in May, June last year, the International ILO Training Center performed the hybrid mode of training of 18 Ukrainian mediators. They were trained as the trainers for labor mediation. After that, in April this year, the trainers trained in Torino performed the training of the pilot group of Ukrainian mediators focused on labor mediation. The training was a success, and we mm, uh, in this way got 24 labor mediators. Further trainings are scheduled for September, October, um, and accordingly, September, October this year. And our organizations and ILO plan to train two other groups of labor mediators in the following year. So until the end of next year, we hope to have the pool of over 100 labor mediators across all the regions of Ukraine. Currently, jointly with ILO, we look for the opportunity to create user-friendly register of trade mediators held by our organization on our website.
We also have some arrangements with the Free Legal Aid Coordination Center concerning pro bono mediation services in cases for both collective and individual labor disputes. But we work not only with mediation, we are promoting also other mechanisms of ADR. Just yesterday, I came back from Turin, where I attended training on labor arbitration for trainers. So we promote labor arbitration as another ADR tool. So we are moving towards development of ADR system for labor disputes. One more point I'd like to make. In February last year in Geneva, there was this technical session of ILO on labor disputes and justice tools. So there was over 70 countries represented at that session. We were talking about labor arbitration as a golden standard for the entire world. Ukraine is also moving in the same direction. As it has been mentioned today by other colleagues, mediation as an ADR tool is a very promising method, and there is certain limitations on strikes and other forms of social protests related to martial law. But once the martial law is over in Ukraine, we expect more conflicts in the society, especially in the labor sector. So the current limitations can be used as a window of opportunities to get ready for the later burst of conflicts when Ukraine will be bouncing back from the wartime. Once again, thank you very much, everybody, for your attention, for thinking and working with mediation. Thank you once again, dear organizers, for the invitation. Thank you, Dmitro, for sharing your overview of ADR and mediation in particular. That's all interrelated and very important on our way to settling conflicts in labor. disputes with outside the court. Thank you very much for saying all that, and I hope that all of you, dear listeners, heard that in September there will be another training for mediators who want to specialize in labor disputes settlement. A prerequisite for this training is online participation in one of the basic courses from ITCI law. There will be an individual register where mediators with labor specialization will be seen and found. And this training is free of charge. It's paid by our international partners. One more important point, there is spots reserved for mediators who are veterans. We do have this group of mediators in Ukraine today, war veterans who have attended basic course and have become mediators. So it's for your attention, dear mediators. We have a lot of questions related to employment of war veterans in the peaceful society. Now, thank you very much. Let me give the floor to Vera Protsiv, Deputy Head on Education Safety in Education Safety Service of the National Police of Ukraine. I will say a few introductory words here. Actually, this cooperation has become quite unexpected for us, but it's a huge source of inspiration for Ukrainian Academy of Mediation. It's really smooth and fruitful cooperation with the Educational Safety Service. Thank you very much, Vera, for that, and thank you for implementing nonviolent communication in educational sector. Thank you, Vera, over to you. Thank you, Luisa, for the introduction and for the opportunity to speak at this international forum. It's also quite an unexpected development for us, and we hope to make it a good tradition. Our cooperation is very useful for us, for the police service, and for our beneficiaries, of course. A few words about our service and about importance of mediation for us and our beneficiaries. Now, with the ongoing war, children's safety is a pressing issue, and safe educational space is a space where a child can develop and learn and study safely. So educational safety is an important part of our work. Inspector of our service is not just a police officer, it's also a mentor, communicator, mediator, and prevention specialist. We work with the children, with the teachers, and with the parents. Our main goal is to prevent risks, not just respond to consequences. Through our daily presence at school, we build trust where children know where we are and they can easily reach out to us if they are bullied or something else taking place. The peace culture is becoming more and more important today. Peace culture is all about nonviolent communication and dispute settlement. Our inspectors conduct a lot of activities at schools to help children develop their emotional intelligence, tolerance, safe communication skills. Today, inspectors' work entails mediation, among other things. All our inspectors undergo special training, and we understand that mediation is a very important element. So once again, thank you, colleagues from Ukrainian Academy of Mediation, for your support in this work. We conduct these lessons of peace and justice, and these activities are very interactive, where children learn how to hear others, how to communicate effectively, and how to settle disputes. We help children to develop empathy, active listening skills, respect diversity of opinions, counteract bullying, take responsibility for your own deeds. These peace and justice lessons that were organized together with the Mediation Academy, it was not just lessons, it was a very important tool to build the safety in educational sector. That's why, and that's how our inspectors help school students learn how to build dialogue, facilitate dialogue instead of escalating conflicts. Another important element of our work is interaction with teachers, psychologists at school, and parents. This comprehensive approach helps us prevent conflicts and provide support to the children who need it. We have over 1,800 inspectors of educational safety service, and we, through this work, show that our officers can be someone children have trust in. And that's possible due to mediation, among other things. We are investing into safe educational space, which takes care of safe future Ukraine. We promote values such as respect, responsibility, and so on. We need to teach children how to build safe communication. Now we have ongoing war. Both adults and children are stressed and suffer from uncertainty, and we have to promote peace as a value for our future generations. Our service is aimed at bringing up a new generation of Ukrainians who know what peace is, how valuable it is, and how important it is to build safety every day. Our cooperation is not that long. We have started quite recently, less than a year ago, but we have achieved a lot. Our police officers keep working despite the end of the school year. They work at summer camps. They use all the materials we got from the Ukrainian Academy of Mediation. We are very grateful for that. We can see wonderful feedback both from the teachers, from parents, from school students. They talk about changes they observe in their communication with the peers, and it's an art. It's not easy at all to be able to communicate well. It's really important for us that we can show that a police officer is not someone wearing uniform, it's an adult who can be approached by a child in need, who can help this child find a good solution to settle a conflict or problems they have. When I was a school student,
побудувало такого безпечного,
I was really
здорового,
lacking
позитивного
this
поліцейський
safe
психолог,
adult, like
який
a
знав, що таке
psychologist or
медіація.
police
І
officer
хтось
who would
з колег
help me
присутніх,
through mediation, for
виступаючих,
example.
сказав, що
Some of the colleagues
медіація це
before
ж не
me
просто там
mentioned
якийсь
that
інструмент,
mediation is
не
not
просто
just a
як
tool,
додаткова якась опція, а це має
is
бути
not just an
щоденним
option.
актом і
It has
основою
to be
для
something that
усіх
we
служб,
use
які
every day
працюють
for
для
all the
людей і заради
services
людей.
that
Тому
work
насправді ще раз
for
дуже
the
вам
people, with
дякую.
the people.
Дякую за те,
Once
що
again,
маю
thank
можливість
you so
розказати про
much
нашу службу і про те, що
for
впроваджуємо
popularizing
медіацію у
our
своїй
service, for
державі
supporting us,
на сьогодні.
for investing this effort together
Дякую,
with
пані
us.
Віра. А я ще
Thank
хочу
you,
сказати, окрім
Vera.
відкритості
Let me say that
взагалі,
apart
служби
from
інспекторів освітньої безпеки,
openness on
наскільки
this
плідною ця
educational
співпраця, наскільки
safety
все чітко,
service,
ми не
it's
встигаємо, у нас
all
є спільний
so
чат, не
smooth.
встигаємо щось підняти, написати, вже одразу
We have this
будуть
joint
реакції.
chat
Це
with
не
you. We
тільки про
immediately
уроки не
see your
розповідаються, це і
reactions
про
to
ротарі
our
денснички,
messages.
і про постановки, які
I'm talking
відбуваються
about
десь
all
в
kinds of
школах. І
activities we have,
низький
all the
уклін за все, що
books
ви
and big.
робите для наших дітей, бо
Okay,
під час
I'm
війни дітям
so
надзвичайно важливо
grateful to
бути
you
почутими.
for
Ну
your
просто
work at
така
schools.
кількість
It's
різних
very important for
зараз
the children
проблем,
to be heard.
викликів. І
Adults in Ukraine are
того, що в
so
школі є зараз ось цей
so
безпечний дорослий,
overloaded with
який
all the
не
challenges
тільки
and
може
stress,
когось
and it's so
покарати,
crucial
а
that
який може
there
бути
is an
тією
adult
людиною,
in
яка
school
допоможе бути
who is
почутою,
safe,
яка
who can
допоможе
help the children
відновити
be heard,
комунікацію,
help the children
взаємодію. І
restore communication that
я
has been disrupted.
захоплені від того, що в
I'm so
Україні
inspired
створена
by
не так давно була ось ця
seeing this
служба
new
освітньої безпеки.
service,
Ми 1 квітня
educational
святкували
security, safety
річницю,
service
так, чергову.
in Ukraine.
І
You are
я
very young. You are
хочу
less
так
like
відкрити
you've
до
just turned 1 year, right?
застосування інструментів ненасильницького
And I'm so
спілкування.
happy to see your
І тут я
openness
хочу
to
звернути увагу, що в суботу у нас буде
communication
окремо
tools.
проводитися урок,
Let me
буде
just
більше
say
про
on Saturday
ініціативу
we will
року
have
миру та
this
справедливості.
lesson.
Вона
We
насправді
will
була
talk more
первісно
about
запровадження,
peace
і
and justice
авторами є
initiative.
це суддівська спільнота, це Асоціація розвитку суддівського
It will be
самоврядування. І всі,
part of
кому
the
цікаво,
judicial
приходьте,
self-governance. If
дізнавайтеся.
you're
В
interested in
нас
this
є
topic, please join
перекладене
us.
англійською, це
We
мультфільми,
have
які ми будемо,
the
мультфільм
cartoon,
один ми будемо
one
переглядати
cartoon.
онлайн.
We will watch
Дітям
it
буде
together
цікаво і буде
with the children.
проводитися цей урок. І, звісно,
It's going to
буде
be an
представник служби
online
освітньої
class,
безпеки так
and
само
of course,
ділитися
the
досвідом
educational
проведення таких уроків.
safety
І ще гарна новина, що ця
inspector will be
ініціатива
present.
є
Another good
перемогла в
news:
номінації
this initiative
партнерства,
won
де
this
приклад
competition
партнерства
in partnership
суддівського корпусу,
um,
організації, що
award.
представляє суддів, це медіаторів, Українська академія
Judges,
медіації і
mediation,
Національної
and
поліції України.
national
Ось
police
коли
are the
така
partners
синергія робить
that
користь нашим
build this
дітям і
synergy
визначає
for
наше
the benefit
майбутнє.
of our children,
Дякую,
of
пані
our
Віра.
future. Thank you very much,
Я
Vira.
вам також дякую від
And
мене,
I
від
also want to
кожного інспектора
thank
Служби
you
освітньої
on my own
безпеки.
behalf and on behalf of
Насправді
our
ми,
inspectors.
представники Національної поліції, звикли, знаєте, працювати за
You know,
наказами, але
national
така
police
співдружність
is used to
відгукуємося
working with
насправді.
the
Це не тому,
orders,
що
with the
так потрібно, а
documents,
тому,
but
що
we are
насправді
very responsive
це
because
відгукується поліцейським,
this kind of
вони
work
відчувають, що
is
їм це потрібно,
really
і їм це дуже
something
допомагає у їхній
valuable.
щоденній роботі.
Everybody who is
І
involved in it
служимо,
feels
захищаємо,
that.
сподіваюсь, працюємо
We
разом
serve
задля
Ukraine
миру,
together
задля безпеки
for the
і
peace
задля
and safety,
гарного мирного майбутнього наших дітей. Дякую.
hopefully for the safe
Дякую.
future of our children.
Дякую
Thank you.
вашій особі, усім інспекторам.
I
Дякую.
thank you and all your colleagues.
Ми почули
We
бачення
have
різних органів влади
heard
на те, де
representatives of
сьогодні є
different
місце
branches
медіації, які
of
є плани на розвиток
power.
медіації в їх
We talked
діяльності. І
about the
саме
current state of
зараз час
affairs, about the
перейти
plans,
до наших
and now it's
міжнародних
time
партнерів.
to give the
І в
floor
нас
to our
сьогодні
international
присутня
partners.
пані Ніна Майя
I'm
Шрепфер, яка
giving the floor now
представляє
to
УВКБ
Miss
ООН.
Nina
Насправді без
Maya
підтримки міжнародних
Schreppfer, who is
організацій,
deputy
без підтримки міжнародних партнерів,
representative of
медіація б не
UNHCR.
могла рухатися в своєму
Without them,
розвитку
mediation
настільки
in Ukraine wouldn't
швидко,
be
як це
able
зараз
to
відбувається в
move
умовах
so
війни, в тому числі.
smoothly,
І ось
especially
пані
now in the
Ніна
wartime. So,
хочеться звернутися до вас саме з огляду
Nina,
на
let me say
те,
this.
чим займається ваша
Considering
організація.
the
Звісно, Україна
specialization of
продовжує
your
стикатися з
organization,
масштабним
of
переміщенням
course, Ukraine
населення
is still
та
facing,
іншими
is
соціальними
now facing
наслідками війни. І ось
the challenges related to big amounts of IDPs moving in our Ukraine. So I would love to hear your perspective on the role of mediation or in the context of migration. Where do you see the potential for cooperation between the state, NGOs, and other stakeholders? Over to you, Nina.
Thank you very, very much, Luisa. It's a pleasure to be here, and good morning to everyone, or good afternoon for some of you already. Luisa, we are really pleased to be part of it and share our view on how we are increasingly incorporating mediation in our work to help Ukraine manage a very large-scale displacement situation, and more so to support nearly 10 million Ukrainians that have been forced from their homes, whether they live in Ukraine or have been forced to move abroad, to attain a durable solution. We all know that displacement creates a lot of challenges for those who are displaced, for the communities hosting them, for local authorities, and for state institutions alike. Often these challenges evolve around housing, access to services, and finding a job, around social integration, and increasingly also community cohesion. And all of these factors are central to what is coined as a durable solution to displacement. A durable solution is about creating conditions that allow and enable a displaced person to recover from displacement, whether it is through return or integration, and to live normally and at par with others and well integrated in a community. And now we are 5 years into the war. Many millions of people in displacement, we really must shift towards support to ending displacement, to support people find a durable solution so that they do not continue to live a life in limbo and uncertainty. And you might ask yourself, where does mediation come in? Where is mediation relevant in managing large-scale displacement and in supporting durable solution? A durable solution, of course, requires a multitude of sectors and interventions to come together. And mediation is no magic wand. And as a standalone intervention, it will not be able to resolve all of these challenges related to displacement because they're very complex. But mediation can play a valuable and impactful role as part of a broader set of interventions to manage displacement and support durable solution. At UNHCR, we are using mediation as a structured, voluntary, and impartial process, and both in a preventative, remedial, and enabling form. In its preventative form, mediation is particularly relevant in our work to address and transform negative perceptions around displacement and turn them gradually into neutral and positive perceptions, as well as to proactively manage disputes before they turn into social tensions or even escalate into conflict. Mediation in its remedial and enabling role, it helps communities, authorities, and institutions to rebuild trust, to make decisions in polarized and resource-constrained environments using participatory approaches, and to create a sense of togetherness and build social cohesion in a community that is reconstituting itself as a result of the war and the ensuing displacement. We see that mediation in Ukraine in its most promising role is not as a substitute for legal remedies, but as a complementary tool, a tool that helps communities to manage the practical consequences of war and displacement and to effectively support durable solutions. And the greatest opportunity lie in embedding mediation from the local level upwards to the central level. At local levels, it is essential that people are aware and interested in using mediation resources. And several of the previous speakers have already highlighted the need to further sort of popularize mediation and mediation resources, available mediation services amongst people, so they do know what it is about, how they can access it, and how effective it can be to address their situation. We also need local authorities to develop inclusive and participatory approaches to local planning and local decision-making. This is particularly important to build trust and to address problems related to actual or perceived exclusion. We need to invest further in civil society. Civil society at the very local level in particular is absolutely critical to facilitate mediation services and provide community-based mediation platforms. And lastly, at central level, while the government has already taken a lot of steps to create an enabling framework, more is needed, in particular to incorporate mediation in the broader recovery framework as a complementary tool to other systems to address conflicts. And of course, international partners such as UNHCR, our role also needs to be played, both in supporting capacity in systems and to really help popularize mediation amongst people, amongst civil society, and amongst state bodies. Civil society entities is at the center of UNHCR's mediation work here in Ukraine, in particular very localized community-based organizations and so-called IDP councils. We see that these are often the most effective brokers of trust, and that is what makes them a very effective stakeholder in a collaborative mediation approach. And this is why we are investing a lot in their capacity and their role in mediation. For example, we do work with over 350 community-based organizations across Ukraine. Their strength is to contribute to social cohesion in communities that have hosted a lot of IDPs for several years now. We saw in the social impact assessment of their work that these local organizations, they do a wonderful job in stabilizing community relations, in mitigating tensions in a community, but they do not have the mechanisms at hand yet to positively transform communal relations. And this is why we start to invest in professionalizing them to become mediators, to have mediation expertise, to take their role a step further. We're also working very closely with over 100 IDP councils across Ukraine. IDP councils are advisory bodies established under Cabinet Minister Resolutions 812. They are composed of IDPs, members of host communities, local civil society, and local self-government bodies. These IDP councils are set up to be a mediating mechanism to inform participatory and collaborative approaches to local planning and programming, as well as local decision making, and to inform mechanisms that build or rebuild trust and address perceptions of exclusion. And finally, we have a large network of legal facilitators in communities where services are otherwise under a lot of constraint due to the full-scale invasion. And these legal facilitators will be further trained to provide mediation services so that mediation services are available where formal systems are not available, or to complement the formal systems and reduce the burden on them. We have seen in our work so far that areas where mediation to address displacement and the consequences of displacement can be particularly impactful. And we see the following four. The first, monitoring and early prevention mechanisms that identify emerging negative perceptions and social tensions early on and connect parties with available mediation services to enable communication and problem solving. The second good practice are community-based mediation initiatives that are designed to proactively support social adaptation, social integration, and social cohesion, reducing emerging and escalating tensions, and sustainably transforming communal relations. The third good practice are to provide mediation services systematically to address disputes and to complement legal pathways while preserving communal relations. And lastly, the participatory and inclusive dialogue, notably through IDP councils and other community-based platforms to inform local planning and decision-making by authorities to help address the perceived exclusion and increase trust by IDPs as well as other communities in local decisions. At UNHCR, we continue to integrate mediation in our program, especially at the very local levels, using all of our mechanisms that we have at hand. We probe different pilot initiatives to determine which ones are most impactful, and we will scale them up. We see that these mechanisms through community-based protection are often the most relevant contribution at local levels where state systems otherwise are too impacted by the war and not always fully functional. We are looking forward to working with you, Louisa, your team, the Ukrainian Academy, to further professionalize these mechanisms to increase the overall capacity of mediation and providing mediation services to provide community-based mediation platforms across the country. Thank you so much.
Щиро дякую, пані Ніна, і за
Thank you
всю
so
ту
much,
роботу,
Ms.
яку ви
Nina,
робите для
including for
підтримки
all that
внутрішньо
work you
переміщених
do
осіб,
to
для того,
support
щоб
IDPs
допомагати
and
формувати цю
the work
соціальну
you
згуртованість
do
на
to shape
місцях,
social
в громадах.
cohesion at the
За всі
community
ці
level on
ініціативи,
site,
які
for
ви
all the
вже
initiatives
створюєте.
you have already
І я також хочу вам особисто
implemented.
подякувати
And let me
за
thank you
привнести
personally
теми медіації
for
в
bringing up
звісно,
the
завжди є
mediation
хтось
topic.
всередині,
There
хто
is always
драйвить це,
someone who
і
is
я
a
знаю,
driving
що це ви.
force to that,
Дякуємо
and I
вам
know
за
that
те,
it's
що
you. So thank
розумієте
you
його
very much
цінність,
for
особливо
understanding the
в
value of this
умовах
topic,
переміщення, в умовах
especially
війни.
in the
І
terms of
наскільки
displacement,
важливо
in
те,
terms of
що вона може
wartime,
забезпечити. Вона, звісно, не
and the
магія, вона,
importance of
звісно,
what
не
it can provide
панацея,
for.
але
Of
вона може
course, it's
дати
not a
те,
silver
чого
bullet, that's not
сьогодні не
panacea,
вистачає. Вона
but
може дати
it
можливість
can
бути
provide something that
почутим
we're
і
missing,
почути
the ability
інших.
to be
І
heard and
особливо
the
це
ability
важливо,
to
коли
hear
ми
other people. It's
опиняємося
especially
в
important when we
громадах,
find ourselves
яка
in the
є для мене
communities
новою. Я в
that
ній не зростала,
a
я тоді
new one
була
that
вимушена
wasn't my home,
переміститися.
that I
Для мене
had to
є
replace there,
прихисток такий, як тут
and I have
отримати,
the
однак це
shelter there,
не
and
означає,
yet
що не буде
it doesn't
величезна
mean
кількість
that.
питань, які потребуватимуть
But it means that I won't
обговорення,
have the
вирішення
issues.
і
I will have
особливо
issues that
відповідяться, яка
need to be
має бути
addressed.
чинне
So the
порозуміння
mediation,
і
that
воно
the
стає
way to
важливим.
the way towards
І я хочу
reconciliation, mutual
звернути
understanding
увагу,
is
що
of
в
utmost
середу буде
importance.
ще
I would
окрема
like to
подія,
bring your
яка буде
attention that on
проводитися
Wednesday we are going to have a
у
dedicated event
партнерстві з
in
УВКБ-ООН.
partnership with
10 квітня
UNHCR
ми її
and the
організовуємо, і можна
organization the
подивитися,
10th of
скільки
April, this at the
можна
Kvietnia,
досягати
and you will
порозуміння
see
в
how much and this
громадах,
mutual
коли там
understanding
є
you can get
представники різних
in the
культурних,
communities
культурних
that incorporate
різних культур. Так
various
можна їх
cultures
сказати.
and
Тобто
ethnicities.
представники різних культур. І, будь ласка, доєднуйтесь,
And
цікаві спікери будуть.
please
І
join
знову ж
this
таки
panel.
поговоримо в
We'll have many
середу про
interesting
те,
speakers.
як
And on Wednesday,
стрес
we're also
впливає
going to
на
speak
ментальне
about the
здоров'я в умовах переміщення,
effect of
коли
the
ми
stress
не маємо
on mental
вибору,
health
є
in the
питань, де ми
context of
хотіли би бути, займатися тим, чим ми
displacement when
хотіли
we
б
don't have
займатися.
the opportunity to live
Щиро
where
вам
we would
дякую.
like to live and do what we would like to do. Thank you so
Колеги,
much.
ми
Dear
трішечки
colleagues,
сьогодні
we're a little bit
затрималися.
behind
Це
the
наша
agenda,
перша панель,
but this
коли
is our first
хочеться, знаєте,
panel when we want to
окреслити різні
outline
траєкторії
or
руху, різні
various
напрямки
trajectories
роботи нашої
and
протягом
areas
тижня.
of work we're going to look at
В
deeper
нас
during the
план
week.
такий надалі,
The
на цей
plan
тиждень. Сьогодні
is
ви
the
зможете
following
почути
for
окремо,
this week.
наприклад, про
Today,
податкову
you could
медіацію.
hear
У
about
нас в
the
четвер буде
tax
окрема
mediation.
подія,
On Thursday, we
присвячена
are
цій
going to
темі,
have the
тому цікаво
dedicated
приєднуйтесь. Буде
session on this
представники з
topic.
Великої
We
Британії, з
invited
Бельгії, які
the
будуть
representatives
ділитися
from
досвідом,
Great Britain, from
як
Belgium,
ще
who are going to
можна
share the
спори
experience of
між
how
державою і
to
платниками податків. Ми
resolve
сьогодні
disputes
говорили про роки миру
between the
справедливості.
taxpayers
І
and the
сьогодні
state.
у
We also
вас
spoke
буде
about the
можливість почути
peace and
більше і
justice.
навіть
On Saturday,
приєднатися і
you will
діти можуть взяти
see
уроки,
more, and we also
участь в
invite the
такому
children
уроці
to
миру та
take
справедливості.
part in this
Далі ми
lesson of
сьогодні
peace and
говорили
justice.
про
Today, we
суддів, ми
also
говорили
spoke
про
about
адвокатів.
the
Те, що
attorneys and
стосується
the
суддів і
judges,
судової
and
системи, в нас сьогодні вже за 1,5 години буде
just an
окрема
hour and a
розведена
half, we
панель,
are going to have
в якій
another
братимуть
panel,
участь
and
судді,
it will be
представники
participated
з
by the
різних країн
judges
світу, звісно, з
from
України,
different countries,
представники
including, of
апарату
course,
суду,
Ukraine.
які
That will
також
be the
будуть ділитися
court
власним досвідом
apparatus
стосовно того, як може бути
representatives that will
налагоджена
share
взаємодія між
the
судом
experience of how to establish
і
cooperation
медіаторами
and
або
interaction
медіацією
between the
як
court and
інструментом вирішення спорів.
mediators as
В нас буде окрема
ADR.
подія,
We are also going
присвячена
to have the
супроводити
session
адвокатами
looking
своїх
on
клієнтів в процедурі медіації. І
the
як я
attorneys
вже казала,
accompanying their
багато
clients in the
цікавого
mediation
заплановано.
procedure. We have
В
planned
нас
many
будуть багато
exciting
анонсів
sessions ahead. We will have many
звучати
announcements
протягом
ahead
цього тижня. Хто
during this
можливо
week.
туди
you will hear about the opportunities to join this or that session. And on Friday, that's a bit a little spoiler. After we determine the winners of this children's competition and tune in this art, we're going to present the achievements of promotion of mediation through art, and we will present this song written by the veteran. It will be in two languages, in English and Ukrainian, and it will tell you that it's not magic, and we all have these tools in our hands to be ready to hear one another. We have planned so much, so please follow the agenda. Now we're going to have a break for an hour and a half. Those who are going to join the session, we go back on 2 p.m. Kiev time. We're going to speak about the mediation and court. Another session we're going to have today is the meeting with of literature community, those who create pieces of literature, and how we could promote mediation in this area, especially for the children. Later in the evening, since we have the day of oceans, we're going to discuss how we can address the maritime disputes. That's going to be a very interesting panel. Don't miss it. And I hope that next year we'll be able to meet in a peaceful Odessa on the Black Sea coast and carry out this discussion, sipping coffee when we see one another face to face. And I hope that our overseas colleagues can will be able to join us too. This year we're going to be online, but still trying to create this spirit to provide the quality content. So please stay tuned, stay with us. Our website has the full program. You can follow it and you can join these sessions using this one link. Have a nice break. The next session will take place in an hour and a half.
and then choose an appropriate language. In your case, English channel. Сподіваюся, всім вдалося увімкнути
I
синхронний
hope
переклад.
everyone was able to switch on simultaneous interpretation. We will also write it on the chat. And let's move forward. And I'm giving the floor, and it's on for me. And we start this very interesting panel on the interaction of a court and mediation. We will look at the effective model of such interaction. The moderator of this panel is going to be Maxim Hodakivsky, the judge of the Suborny District Court of the city of Dnipro. He's a doctor of philosophy in law, and of course, he has the mediation training and more than one. Mr. Maxim, over to you. Hello, all the participants. Hello, Ms. Louisa. We're catching up from you this wave of distribution of the excitement of a mediation and the passion about mediation. And after the welcoming remarks, after let me express appreciation to all the organizations who are engaged in ADR and shaping the culture of ADR. Welcome to the justice panel. Many speakers in the morning spoke about the necessity to enhance the mediation and justice and then raising awareness of all the stakeholders and the big engagement of mediators into dispute resolution. It was very important to hear the words of CPEJ representative. She mentioned that it's so important to promote mediation about all the achievements and developments we have in Ukraine. And it was also great to hear from the EU representatives that mediation and ADR have to be more engaged in the roadmap, namely in justice. CPEJ indicates that the judges are the driving force and moderator who can enhance HR culture in the country. So today's panel looks at the court and mediation, how they can effectively interact, how can they cooperate, how they can provide opportunities to the parties to settle the disputes not only through court ruling, but also through mediation procedures. Many countries have them sustainable and durable mechanisms and criteria of how courts can collaborate with mediators. Today's panel will be focused, first of all, on the highlighting the experience of other countries. Today we will see the experience of the US, Finland, Poland, as well as Ukraine. They're going to speak about what we have already in this area and what we can learn from the other countries. And I'm happy to introduce you our today's panelists, these representatives of the US who are pioneers in the introduction of mediation and settlement culture, mediation culture, and ADR culture. USA is represented by Cynthia Juris, the director of the Maryland Judiciary's Mediation and Conflict Resolution Office, Dr. Nick White, program manager, research and evaluation, mediation and conflict resolution. Office Administrative Office of Courts, Maryland Judiciary, State of Maryland, Daniel Shalov, IDR Administrator for the United States District Court of the Eastern District of New York, and the representatives of the EU, this of Finland and Poland, as I've mentioned before. Finland is represented by Ms. Maria Van Hanen, who is judge of the District Court of Helsinki, and another country who is now pushing the IDR mechanism. This is our neighboring country, Poland. Ms. Agata Gwalowski-Subusak, who is the president of the district court in Breszko, Poland. We will also hear a Ukrainian who is the chief staff of Vinnytsia Court of Appeal, chair of the co-founder of the NGO VAPS, attorney, mediate and PhD, Ms. Natalia Korol. I can see that all our speakers are with us, and I would like to give the floor to the representative of the United States of America. They will have the joint presentation, Ms. Cynthia Juris and Dr. Nick White. They represent the judicial branch of state of Maryland. They will focus on the collaboration of court and mediation. Over to you, Cynthia.
Greetings. And thank you, Judge Kodakivsky. Thank you for including Dr. White and myself in this panel. It is truly an honor to be here with you today, esteemed colleagues from Ukraine and around the globe. I'm the director of the Mediation and Conflict Resolution Office, also fondly known as MACRO, for the state of Maryland Judiciary. And I'm here today to share some of the rich history and present practices, including the work of our office, that have contributed to the robust mediation and conflict resolution tools that we have available in courts and communities in Maryland. The seed of mediation in our Maryland courts and communities was firmly planted in 1999. Way back then, when our then Chief Justice of our Maryland Supreme Court, Robert M. Bell, had created a commission comprised of hundreds of individuals from our state and beyond, with the goal of transforming a culture of conflict into a culture of conflict resolution. So in the context of a legal system that otherwise calls itself an adversarial system, Chief Judge Bell stated that it was essential for the court to take the lead in promoting alternative dispute resolution where appropriate. Improving the court and increasing litigant satisfaction were two of the goals, and it went beyond that to advance the use of ADR in schools, neighborhoods, businesses, throughout communities to support a framework for resolving conflict even before it arrived in the courts. And fundamental to this initial work and to our work today is the recognition that mediation, these alternative dispute resolution tools that we have, where people who know the most about their lives and their needs are empowered to make their own decisions that work for them. We find it just works better for people, and then providing a justice that works for everyone involved. The Mediation and Conflict Resolution Office of the Maryland Judiciary was formed to promote the availability, use, and quality of alternative dispute resolution in Maryland. We have now robust mediation programs in 3 levels of our courts across the state. Our lowest trial court level, the district court, which handles small claims, traffic, and landlord and tenant matters. Then the next level, which is circuit court, which is our next level of trial courts and includes family court and other civil and more serious criminal matters. And our first level appellate court of Maryland as well. Each level has a different approach to how ADR programs are handled. Now going to share my screen and navigate for a moment. Let's see, am I able to do that? Maxime, am I able to share my screen? Let's see the button here now.
Так, це можливо, будь ласка.
Yes, it is possible. Please do.
Let me see. Okay, one more button. Navigating to our macro web pages on the Maryland Judiciary website, I'd like to share with you some of what we offer today. Is this showing for you in Ukrainian? Can you see the screen in
Бачимо добре.
Ukrainian? Hey.
Yes, we can see it very well.
Oh, good, good. The pages are designed to serve court programs, practitioners, and the public to provide rich resources to support our work in ADR. You can see on the left-hand navigation, you can see areas that you might want to take a deeper dive into, including our research and evaluation pages, which Dr. White will talk a little bit more about in just a moment. This homepage shows three main areas of our initiatives. First, supporting ADR programs in courts and communities through technical assistance, working closely with court ADR program managers, grant funding for court programs in community mediation, and providing tools for data collection and evaluation of the effectiveness of ADR programs. Next, providing support for ADR practitioners through our Maryland Program for Mediator Excellence, providing training and continuing education, promoting quality assurance and ethical standards, and providing resources for the public, including a consumer's guide, a video series to help the public better understand and prepare for mediation. Now that you have a sense of what is here, let's take a deeper dive into court ADR practitioners on the left-hand nav. I'm going to As you can see at the top of the website, at the top of the page, you can choose many different languages, including Ukrainian. So in our court ADR practitioners, this is where potential ADR practitioners can go to learn more about mediating in our circuit courts. So Macro manages the mediator roster application process for our circuit courts, and we work closely with practitioners and our court ADR program managers in our circuit courts across the state. That has been very valuable for helping to move our programs forward. The circuit courts are not a unified court in that they have a certain amount of local autonomy, although all are governed by the same rules. The circuit courts assign the mediators to their cases on the local level. Macro is in the administrative office of the courts, which is a statewide office, able to provide certain functions such as the statewide practitioner roster, funding, and resources to courts for their ADR programs. We have worked and continue to work closely and collaboratively with the judges across the state to advance ADR and to support the quality of the services offered. Now, Nick White will share information about mediating in the district court. And Nick will also say a little bit more about our research and possibly share a video that is part of our public awareness efforts if we have some time. Nick, I'm going to stop sharing. Unless you'd like me to navigate on the page. I'm going to stop sharing and then turn this over to you.
Okay, good morning. Cynthia said my name is, actually good afternoon. My name is Nick White. Pleasure to be here. As Cynthia said, I work at Macro, but I also serve on the district court mediation roster. Cynthia said the district court is equivalent to our small claim, landlord tenant, under $30,000 generally. And they have, I think, some unique features we want to share with you. So one of them, and this is in Ukrainian, so it might not point to the exact right location on the screen, is that if people will call up the court and say, I have this conflict with my neighbor, my landlord, whatever it may be, I haven't filed a case yet. What are my options? So one of the things they developed is a pre-filing option. And so they fostered relationships with community mediation centers throughout the state of Maryland. And these are nonprofits, and actually our office provides some grant funding for those offices, and sometimes they're completely independent nonprofits. Sometimes they're housed in community colleges, so a variety of different places. But what they do is they serve as a service provider for pre-filed for conflicts that haven't gone into the court. And then they also do a variety of other community dispute resolution processes beyond that. But there are also many times, as you can imagine, people have a conflict, they file a case. In that scenario, the district court has a roster to handle that, and they offer both mediation and settlement conference services. And they have two ways they can offer that. So they can offer that remote. So if the parties are interested, they can actually resolve the dispute before their day of trial, right? They can do it, get it arranged ahead of time. System currently uses Zoom to provide remote mediation. Again, that's both in mediation or settlement conference officers can provide those services. And then they have what they call day of trial. People have shown up in the courthouse, they are there. And oftentimes either the staff in the district court ADR office or the judge or staff for the judge may look at the docket ahead of time and look for cases they may think may be well suited for mediation or settlement conference. And they'll have that list with them. And as the judge is getting the day organized, doing attendance, seeing who is present, who is not present, the judge can offer mediation. In about 2 minutes, I'll actually highlight research on how judges offer mediation, how that impacts people's likelihood to try or not try that. So it's nice that the district court offers ADR to the public in a variety of ways, and that pre-filing, I think, is a unique and wonderful tool that they can offer. Something else I want to highlight is they have an apprentice process. So I came to the court, I'd already had, I think, 15 years of mediation experience, and no matter how many years of experience, everyone goes through their apprentice process, which I appreciate. So if you come onto the roster, you observe an experienced mediator twice, and then you get observed your first 2 mediations or settlement conferences. The staff observes you at least twice. And if they feel like there's some more coaching involved, then they'll support you around that. So it's really to raise the quality. It's not a punitive, oh, you didn't make the cut, you can't mediate. It's really how do we get you to the level that we think will serve the public. So they'll continue to work with you to get you to that point. So eventually you'll be doing solo mediation, solo settlement conference, whatever that process may be. Another nice thing is to stay on the rosters, they require continuing education. So every year you have to attend sessions like these or others to grow as an ADR professional. And finally, something that came out from research we did earlier was the finding that people who engage more often as practitioners generally have more positive benefits and outcomes for the parties. And so that court requires that their practitioners sign up at least 4 times a year to provide the service. They want people to maintain those skills, stay sharp. So that is the district court. So now I'm going to switch to going back to Macro's homepage. It's actually not the homepage, but on the left-hand side, there's research and evaluation. So I just want to highlight, we don't have time to actually go into these, but I just want to give you background. I dropped the link for the Macro homepage if you're interested in more. So we've had 3 annual reports, and this looks at ADR in the court system. And so we're in the drafting of our 4th ADR data analysis. So that will be up there soon. Most recent research we've done is looking at remote mediation and disabilities. So many parts of the US, and my impression is broader than that in the world, are using Zoom or some other video technology to provide remote mediation. And so we're interested in what impact does that have on folks. And the outcome is there are things we can do to make it better for people with disabilities. And reality is those same things make it better for all users, for the entire public. Then this report, I mentioned the district court. So the question was, when a judge talks about ADR in the courtroom, what is going to increase or decrease the likelihood that people will try that? So that's what this report looks at. And we have a 2-page in the full report, 2-pager summary and the full report, depending on what you're interested in. And the last thing I want to share in that area is farther down here, there are a variety of reports that are very powerful. What makes them powerful is we had folks go into the mediation processes and they coded the behavior. So they were observing what was happening. It wasn't relying on the parties or mediator to describe what was happening. They were observing and coding the actions. And so it came up with a lot of identifying what were important strategies that mediators could use and how that impacted the parties. And one of the findings of the reports, and again, these have 2-page summaries and the full report. One of the interesting findings is we looked at over a 12-month period after a case had been settled. We followed them for 12 months. We found that ADR cases were half as likely to return to court as cases that had reached a verdict in the court. So that was very powerful for our court system to think about, and the role that ADR can play in not only immediately addressing the docket load, but also the long-term impact and the quality impact that ADR can provide in addition to a full trial. So we're not going to have time to show the videos, but I did want to show you where they are in case you're interested. And I need to go back to.
Я думаю, що це було б дуже цікаво нашим учасникам. Давайте спробуємо.
Let's try and watch video. I guess our participants would be really interested in seeing it.
So I'm sorry, you do want to see one of the videos? Is that correct?
Так. Всі вказують,
Yes,
що так.
that's correct.
Okay.
Participants indicate they would like to see it.
Okay. So at the macro homepage for the feature about mediation ADR, and then I went to learn what to expect about ADR. And I know we're clicking through this quickly. So if anyone has questions, please feel free to follow up. And I actually already have it opened in Zoom. So let's make sure I'm sharing my audio here for this. Okay, so if folks on the other end can let me, usually in my Zoom, there's a place I click to share the audio or video. I don't see that in my share. So I'm going to start that. Hopefully that will work. But if the audio isn't coming through, please let me know.
Welcome to the Maryland Courts video series on mediation. This series will introduce you to the mediation process. In the first video, you'll learn what mediation is and about its many benefits. Be sure to watch the other videos in this series on where to find a mediator and how to participate in the process. Let's get started. Often, people in conflict go to the court for a solution. The court process can be long, stressful, and expensive, with no guarantee of a favorable result. A judge or jury makes all the decisions. Someone wins and someone loses, and sometimes neither side gets what they want. Mediation is an alternative way to resolve your conflict, and it gives the participants an opportunity to control the outcome. In mediation, a neutral person, the mediator, meets with the people involved in the situation. They're brought together to listen to each other and to find common goals. Each person has a chance to speak, to be heard, and to hear each other. The goal is for the parties to create their own solution to resolve the conflict. Mediation can be used in a variety of situations. It can be part of a court process, or you can choose to go on your own. Courts sometimes require people to go to mediation because it can help both sides find a solution that works for them, and it can also be faster than going to trial. If you reach an agreement, you may not need to go to trial. During mediation, you cannot be forced to agree to anything. When no agreement is reached, you can still have the matter decided in court. There are many benefits to mediation. First, it lets your voice be heard. It also helps you understand the other person's perspective and helps them understand yours. You can express your needs openly and honestly. Through mediation, you will work together to find a solution to the conflict. Second, in mediation, you are in control of both the process and the results. You choose what's agreeable. You can end the mediation at any time, but give the process a chance and keep an open mind. You might find a resolution that meets your needs and those of the other person. If at the end of the process you do not reach an agreement, you don't lose your rights. You can still have the matter decided in court. Another benefit to consider is that mediation sessions are private. Unlike a trial, sessions are not open to the public and are not recorded. While most mediation sessions occur in person, participants in some situations can meet with a mediator through video conference or phone. Also, keep in mind, mediation can be less stressful, faster, and cheaper than having your case decided by a court. While mediation is very effective at helping people to resolve their conflicts, it is not always appropriate for every situation. The court or mediation program staff can help you determine if mediation is appropriate for your case. Now, let's discuss the role of the mediator. The mediator is there to manage the process in an impartial way. They will help you talk about the issues, focus on what is important to you, and guide discussions so you can better understand the other person's perspective. They will also assist you in discussing difficult topics so that you and the other person can develop your own solution. Mediators will not give advice or tell you what to do. They will not take sides or make judgments about who is right and who is wrong. Mediators do not recommend the terms of an agreement. That is up to you and the other person. They will also not push you into settling your case. There's one more feature of mediation that is important to understand. Mediation is confidential and protects your privacy. The mediator cannot discuss what happens except in very limited circumstances. What is said in a session generally cannot be used in court. The mediator will talk to you about confidentiality and the exceptions at the start of the process. Let's review. Mediation is an alternative way to resolve conflicts. It allows you to work together to find a solution. A mediator will help guide the conversation. They will assist you in identifying issues and options, but will not take sides or decide the outcome. Mediation can be less stressful, faster, and cheaper than going to trial. Most importantly, it places you in control and lets your voice be heard. Mediation is your solution. Watch the other videos in this series for more information on where to find a mediator and how to participate in mediation. On behalf of the Maryland courts, thanks for watching.
So that was one of 4 videos, and just as a state agency, those are in the public domain, and so feel free to use those as you see appropriate. The others go into more detail. The one thing I'll say about that video is we're very intentional about what we wanted to highlight and the approach and techniques around mediation. That's everything I had. I just wanted to end with our contact information, Cynthia Jurius there. And myself, please feel free to email us, call us, reach out to us if there's things we can answer, direct you to different resources. We're very happy to help. And we're very appreciative of the opportunity to be here and wish you the best of luck with your ADR profession and growth.
Дякуємо, шановні Цинтія та Нік, за цю
Thank you,
надзвичайно
Cynthia
цікаву
and Nick, for this
презентацію,
extremely interesting presentation. It was very practical, and also for the link to your website with all the visual material, which can inspire us with mediation in Ukraine. We have now Q&A session, 5 minutes for it. Please write your questions in the chat. As a moderator, I wanted to ask the first question to you, probably 2 small ones. The first one, you said that the judge has to underline the uniqueness of this method, of this ADR method. How exactly can the judge underline us? How does the judge explain it to the parties that mediation can be applied or other alternative dispute resolution methods? And what are the particular actions of a judge during this court session? Also about the videos, about the visuals which you have on YouTube. Did you feel that posting of this video resources helped to promote mediation in your courts?
Nick, do you want me to answer?
Sure,
Would you like to answer?
Yeah, go.
So when it comes to the study regarding what judges say in the district court, that applies to when they are in the courtroom in a day of trial mediation. And it's very nuanced. It was a very nuanced study to understand that in Maryland, to understand, should the judge say, hey, try this process, or should the judge be more specific about saying, I'm sending you to mediation? Should the judge say these are volunteers, or should the judge not say that? So those are the types of things that the study provides. In our courts, there are various ways that the cases are sent to mediation. When a case is ordered, there is a court order that is sent. But there may be many levels within our court process and other personnel who help to indicate that a case should be sent. Family cases, such as child access cases, have a level of being more presumptive as to mediation, with exceptions, of course, for any sort of intimate partner violence or child abuse. But those cases are sent presumptively to mediation, and staff people evaluate that beforehand. So that is, and then an order comes from the judge. So in those cases, it's not as much about what the judge says in a courtroom as it is in the case of the district court, where it is a day of trial program and mediators are present there in the day of trial. For your question about the videos, we do get a lot of views for our videos. Our government relations team is able to look at that. We can't really say how that has impacted, but we wanted to be sure that people had an understanding of what mediation is, what they could expect, and how they could prepare for mediation. So that is the purpose of those videos. Elsewhere on our site, we have various other kinds of videos and resources that you can see about, seeing people in mediation, using different frameworks and various types of things like that as well.
And I'll just add, I think the video is an important step, and there's many different things you can do, some within your control to raise awareness and some not. And I can't say to what extent it has an impact, but in the United States, you start to hear the news more in baseball, football, our big sports, that athletes were going to mediation over contract disputes, right? That just starts to normalize the language and put it in a much broader that reach than we could ever, ever as far as the media exposure, right? So I think there's a lot of different things playing out here in the United States as exposure normalizing. And so that helps. I'll just say, agree with Cynthia, everything she said. The study is definitely robust in the state of Maryland across our variety of district courts. Can it be extrapolated to Ukraine and another part of the world? Probably not directly, but I think it's good to look and reflect on the variables we found and just be intentional about some of those things can be done without with a small lift. For example, if in Maryland, if the judges said it's free, people are less likely to try it. So my suggestion is, and say the courts have invested in this program, the courts will cover the cost of this program, right? Can I guarantee you they'll make a difference? No, but I can tell you in Maryland, if you say it's free, they're less likely to try, right? So some of those things are easy lifts, right? Not everything. I think some of those things can be transferred without much effort.
One of the other pieces of that district court research, and I think Dr. White alluded to this, is that it was interesting that parties in the court were more satisfied with their court experience if they had gone to mediation than if they had not gone to mediation, even if their case did not resolve during mediation. I found that an interesting study because it showed that people viewed the justice system overall more positively if they had had the experience of mediation.
And this will be my last comment in the research. There's what I call the hallway effect. If you can get the people out of the courtroom into the hallway, meaning that or into the mediation room, their likelihood to at least attempt it is astronomical, above the 90 percentile, right? So it's that if you get them out there to attempt it, at least in our context, people would give it a try, right? It's getting them out of the courtroom to do that is the big mental shift for folks that they have to go through.
Sounded like that some of your previous programs were relating to involving stakeholders. And I think that is an important part. We have in our Maryland judiciary, we have 12, now 13 main committees that focus on various areas. And we are very fortunate that when this structure was created, one of them was alternative dispute resolution. So that is a way that we get to work very closely with our judges across the state to look at ways to continue to improve and develop our alternative dispute resolution in our courts.
Дякуємо за ваші відповіді на це запитання. І в нас
Thank
ще
you very
є
much for your
питання
answers
з чату,
to
теж
my questions. We also have a couple of questions in the
дуже
chat
жваво
because
обговорювали.
the discussion was really
Я
lively
групую
after
їх,
your
систематизую,
presentation.
тому що їх
I
так
will
багато.
probably put them all
Перша
together
група
and
питань щодо
systematize.
оплати, якщо
The first
можна,
group
щоб
was
ви
about
пояснили, як
how
оплачується
will
послуги
it be
медіації в
paid,
вашому штаті,
how
чи є
these mediation
безкоштовна
services
медіація,
are being
і
paid if
які
you have
найбільш такі сприятливі
free of
категорії
charge
справ для
mediation,
передачі
and
до
what are
медіації.
the favorable
І третє запитання,
cases
найбільш таке
to
розповсюджене, це чи є
be sent to
випадки, коли
mediation.
сторони все ж
And
таки
then if you have
відмовляються від
cases
медіації і
when the
категорично
parties
наполягають на
refuse,
судовому розгляді справ.
categorically say, no, we don't want any mediation, we want to go to the trial.
See, so with regard to fees, that there's a variety there. As Nick described, we have community mediation, which is something that the court helps to support. They are community organizations, typically nonprofit organizations. They have a statewide entity that we also help to support that provides very robust training and orientation and apprenticeship. So those are without charge. So those, and in many jurisdictions, those programs do work closely with our courts. At the same time, in our circuit courts, when a case is ordered, there is a fee, and that fee is paid by the parties. And those fees are set by each county court, each circuit court, and we have 24 different jurisdictions in our state. Those fees are set at that level. We also do provide some support for when people are not able to pay. And we provide that through our office and the administrative office of the courts. The second piece about when people refuse to go to mediation. Well, we do consider it to be voluntary. It's always tricky when you explain that to people, particularly in the child access area where mediation is ordered and is somewhat presumptive. One way that I explain that is to say, the court has ordered you to mediation, and if they have a reason such as there's been abuse in the situation or past violence, then certainly there are exceptions, right, to whether a case is appropriate for mediation. But I suggest that people give it a try, because what you agree to or don't agree to is going to be entirely up to you. Another piece around that is when a case is ordered to mediation in our circuit courts, people have 30 days to opt out in that case, to say, I don't want to do it. And that is fine. That is fine. They also have an option to substitute a different mediator. So that is an option that's also provided in our rules. So it does give people flexibility. I think we have an underlying philosophy in mediation that the voluntary agreement of the parties is still important.
Дякуємо. Дякуємо вам за приєднання сьогодні до нашої
Thank you for joining our important session today, court and mediation, effective models of interaction on example of your courts and your state. We will get inspired by your experience, by your videos, and please join our other webinars of our trainings for the judges, for attorneys and all who have something in common with this topic. We understand that it's an early morning with you, but still you joined us and you shared your experience. And now we will move from state Maryland to New York. We have one more US representative, and this is Danielle Shallow. She is an ADR administrator for the United States District Court for the Eastern District of New York. And this court has a special program of introduction of ADR, and she will share experience of New York, of cooperation between judges and mediators, and how this process involves judges. Danielle, the floor is yours. I see that you are already with us. Good morning, to you in the United States.
Мікрофон, будь ласка, не чути.
Your mic is off. We don't hear you. You're
Шановні
muted.
учасники, якщо у вас є питання, ви можете ставити їх в чаті, я буду озвучувати. А зараз, поки ми будемо вирішувати це питання технічне, я тоді
We
пропоную
will
передати
try to
слово
resolve this problem
нашому
with
спікеру
our
вже
tech
зв'язку.
support, but let's.
No,
Oh,
Це
yeah.
нормально,
yes,
це
it just
нормально.
wouldn't, thank you so much. It just wouldn't let me unmute myself, but thank you. It's been fixed. I'm so thrilled to be here. Thank you so much for having me. My name is Danielle Shalov, and I am the Alternative Dispute Resolution Administrator for the Eastern District of New York. And so I'm just going to share my screen. Okay. And share a bit about our program. So I'm going to start here. First, I thought it would be helpful to understand where we are. And so our court is located in New York State. There are 4 district courts. So these are federal courts within New York. Ours 2 courthouses sit in Brooklyn and on Long Island in Central Islip. And so these are our 2 courthouses. And we have 2 programs that are connected to the court. We have a small arbitration program, so that's where neutral would work with the parties to issue a non-binding monetary award for certain types of cases. It is quite a small program. Our larger program is our mediation program. And in that, any civil case is eligible for mediation. And it's a voluntary process. So you heard this before from the courts in Maryland about really putting to the parties that this is their process, something that they are in control of and that they opt into. So in our court, we had in some instances cases that had to automatically go into mediation, but for the most part, it's the parties are selecting to come in. And so what happens is that the parties are informed about the process, which I'll show you in a moment how we get the word out to parties about this program. And then the judge has to order it. So there is a judicial referral that refers the case into the mediation program. All right. And so in terms of the mediation process, because it's happening at the same time, the parties have filed their case in court, it's going through, it's before a judge. At the same time, oh, the presentation disappeared. Hold on. Can you see the presentation now?
Зараз видно.
Yes.
Так, ми зараз бачимо.
Yes, we understand.
Okay.
We see the presentation. Thank you.
Okay, wonderful. Is it still up now? Yes. Okay. So it's a parallel process so that the parties are still going forward with their case, but at the same time that they're mediating. So there's no stay in the litigation. The litigation still moves forward. And what happens is that we want to keep the process confidential. It's going to be a separate process than the litigation. So we have a department in which I'm the administrator. I have 2 staff with me so that we can sort of act as the intermediary. This way, anything that happens within the mediation, with very few exceptions, is kept confidential. And so it's not shared with the court. And this really encourages parties to participate meaningfully and know that they have that protection of confidentiality so that they can really discuss all of the options. What would it look like to settle? What would it look like to move forward with the litigation, knowing that what they discuss there is not shared with the judge in the case. And so in most instances, if things are reported back, they work with their mediator. If there's an issue, it comes to me. It doesn't go to the judge. This way, we keep it as a separate process. There are really clear directives on what is kept confidential and what isn't. And so administrative things like selecting a mediator, who is the mediator, what day it's happening, those things are shared with the court, as well as if there is a need to extend the time for mediation. And then the outcome. But the outcome is reported as the matter was settled, it was partially settled, it was unsettled. That's all that's reported back to the court to make sure that we keep that process confidential. Let's see if I can move forward. Okay. All right. All right. So our mediation panel has 169 mediators. So what happens in our panel is that people apply to join, and these people who will apply are attorneys. They have significant mediation experience, and they apply to our panel. Their applications are reviewed. We have an advisory council that interviews them, and their applications, if they move forward, actually go to our entire bench. So they go to all of the magistrate and district court judges that sit within our courthouse to make sure that the people who join the panel are appropriate, fit, and understand really what the directive of our program is. And so from this, we're looking for certain qualities. One is that they have subject matter expertise in the type of case that we're having that comes into our court. And our court sees a lot of different cases. We don't mediate criminal cases, but those are also in our court. But for any civil case, it could have anything to do from employment. It could be a contract dispute. It could have to do with admiralty law. So we have to make sure that we have a mediator who we can pair with all of these cases so that the parties see that there's someone who has subject matter expertise in the area of their case. And we make all of this information available on our website to the parties, which is that we have a website which I link to at the end of this presentation. It links to our directory of mediators, and you can search through the mediators by their area of specialty. So if you have an employment law case, you can refine it so that you can see these are all of the mediators that have that area of expertise. And I saw a question that just came up: do the mediators have to be attorneys in the U.S.? And so there are programs where you do not have to be an attorney. For our program, you do. So if you want to serve as a mediator on our panel, you do have to be an attorney. One of the things that we really try to do in bringing on panel members is not only make sure that we cover every subject matter that's going to come before the court, but we want to make sure that the people who are on our panel follow the directives of the program. So for us, mediation, just as was explained before, is a voluntary process in which the parties are engaged and involved. And it's really, it's party-centered. And so we support, and people either like the terms or don't, but a facilitative model, right? So we don't have the mediator coming in and evaluating the case. Instead, they're really there to facilitate a conversation. So that is the model that our court backs and has led to great success. And so we want to make sure that that's what our mediators are doing. A challenge for a court program is that when a case goes out to mediation, it's the mediator in the room with the parties. And so there's no representative from the court there. That's also to protect the confidentiality, but to ensure that our mediators are mediating in the style that we are advertising and that we support, we collect party feedback at the end of every session. And so that the parties can provide information about not only the outcome of the mediation, but their experience. Was it a positive experience? Was it easy to find the mediator? Was the mediator helpful? How did they prepare? What were the qualities of the mediator that they found particularly useful in that mediation? We collect all of that data. And part of it is really important to ensure what we call quality control, to ensure that, that the mediators, as I said, are adhering to our directive. And the other part of it that's really useful, and Cynthia was talking about this before, was the parties are really pleased with the process itself, right? And so we ask them, what is their takeaway from the process? Was it a positive experience? And for the most part, the satisfaction rates are in the 80s and 90%, and our settlement rate is not 80 or 90%. So people who are not settling are still really pleased with the process. And our program was actually studied, and they found that, and Cynthia alluded to this too, which is parties who come into mediation who don't settle, who then move on and might have a settlement conference with the court, they are more likely to be successful in settling later if they've come through mediation first. And that's really because it's changed the sort of perspective of the parties. Instead of adversarial, they've started to work together and to see what's possible. And so we find collecting this data and sharing it is incredibly, incredibly useful. We also give trainings and workshops to our mediators throughout the year. Here in the US, I'm sure there's something equivalent, but we have this continuing legal education requirement. Our panel, we also require that they have mediation training to remain on the panel. And so we want to make sure that our mediators are really supported in their practice. And so we offer them these opportunities as well. Just going to go to the next slide. Oops. So one of the next things I'd like to talk about is just how we encourage mediation within the court system. Like I said, we're sort of a separate entity, but we work with judges and the parties to really encourage everyone to support the program. So what I do as administrator is I periodically throughout the year will meet with groups of judges. What I want to do is two things. One is to share information. So all that data we collected from the parties about how they experienced the process, if it was positive or not for them. We also have data on every type of case that comes through. What is the likelihood that it would settle? How many mediators do we have in that area? I share all of this information with them so that they can understand, one, that what our program can handle. Because oftentimes a judge might think of a case and maybe it's not a good fit, but providing data at least and having these conversations allows them to see the vast area that we can cover with our program. I think the more important thing that I do is I listen. I sit and listen to what the judges need. And so often they'll express that there's a trend or something that's happening, or there's a type of case and they're having this difficulty. And we really collaborate and work together. And I become, and the ADR process becomes more integrated in their own process. So if they're saying we're having so many of this type of case, I can tell them, well, we've had this type of case before. It benefits when it comes in early. And you'll see here that we actually become integrated in the process where they put us into their scheduling orders and the orders that they enter onto the docket, so that the judges will send out to the parties a scheduling order, a discovery order about how is this case going to progress. And baked right into it is a request to come into our program, into the mediation program. And so parties can opt in this way. And judges also, when they have preliminary conferences, will discuss mediation with the parties. And as you see below, then they can enter an order in which they come in to mediation. So on the top is the scheduling plan, and on the bottom is an order that one of our judges entered saying, this is how you're going to proceed, and mediation is baked right into it. So that's another way that we really meet the needs of the court and the parties by becoming part of the process. Judges will also just call on a case-by-case basis if something seems like it might be appropriate, to see if the timing is right. And that's another way also that we work together with the judges to try to get this process more ingrained and mainstreamed. I'm going to try to go forward. There's a little bit of a lag, so let me see. Here we go. We also work with parties. So one of the most important things is to make sure that all parties who are going to participate in our process have access to information. So every year, all of the data that I was just talking about, which is maybe how many cases are referred, what is party satisfaction, we produce an annual report. And within this report, we have all of that data, and it's presented, it's on our website, and we have an archive going years back showing all of this data. We think it's really important for total transparency and for people to see what is the program, what can it do. The other thing is we have a really robust website. And so we offer that information, and below is as an example, people can click on, it's on the homepage of our court, it says ADR, they click on it, and it brings them to this where it explains what the process is. I wish we had videos. I think that would be wonderful. Instead, we have a lot of interactive information so that parties can access and find out what is mediation, how do I select a mediator, what does it look like, why would I want to participate in the process. The other thing we do is we have a large level of engagement with the parties. And so we do presentations that are open to the public. I'll talk in a minute because we do allow parties who are unrepresented to participate in mediation. And so several times during the year, I'll give presentations to self-represented parties explaining what mediation is, how they can access it, and what might be some of the benefits. So the idea is if there is a need or a group of people or anyone that we can reach out to offer mediation services, we really try to engage. I also go out and speak in instances here and instances within the state to different bar associations to talk about our program and what we can do. So I'm just going to move to the next slide. And just to share some of the data that I'd been referring to in 2024, in the Eastern District, there were 8,930 civil cases filed. Of those, 898 cases were referred to mediation. And remember, this is the parties choosing to come in. And so 69% of those cases that were referred to mediation were at parties' request. And so judges will mention this to parties. It'll be in their scheduling orders. It'll be available to them. But most parties are opting in on their own, which is really, it's a wonderful thing. And it also shows us the reach of our program. So I'm going to go to the next slide. In terms of the mediation procedure in our court, the timing of the referral depends. Cases can come in very early after filing, so we have certain types of employment cases that come in quite quickly. And that's a great benefit to the parties because at that point they have not expended a lot of time and money on the case, and so it's an early opportunity to discuss settlement. Sometimes cases come in a little later. The parties might need discovery. They might need more information. Cases can come in at that point, and we have cases coming in right on the eve of trial. So there might be a trial scheduled, and those cases can be referred to mediation. At that point, the parties have a good understanding perhaps of their case, of this other side's case, what are some of the risks associated with proceeding to trial, and so it's another opportunity. We also allow parties to come back to mediation so that if they've tried early on and they were not successful in settling the case, they can ask for a referral and they can come back to mediation and try again. So in terms of timing, it's really the lifespan of the case in which the case can be referred to mediation. The parties then select their own mediator. As I said, on our website, we have a directory of our mediators, the area of expertise, and so parties select. Our referral system is different than some of our sister courts because our mediators are paid directly by the parties, so that our board of judges sets the rate that mediators are compensated at for their initial session and additional time. That rate was just increased, but it was the first time in 17 years that it was increased. So it took a little while to get an increase, but this allows at least our mediators to be compensated. I will note that it is a reduced rate, and so that our mediators might charge much more privately, and part of their service to the court is agreeing to this lower rate to mediate for the court, but they are compensated for their time. When we have unrepresented parties, so those are self-represented litigants, they can come into mediation. We have two programs to support. The first is the Mediation Advocacy Program. That's where we locate limited scope counsel. So we'll find an attorney who's available to represent the party just for the mediation, not for the underlying litigation. But they'll come in and work with the party to prepare for the mediation and attend the session. And we found this to be incredibly helpful. Even if the case doesn't settle, the self-represented litigant has someone to speak to and has a better understanding of their case, what the possibilities are, and how they want to proceed. So we found this to be a really great program, even if it doesn't result in settlement. And we also find that the attorneys who volunteer are more likely to participate in this program because mediation is a limited amount of time. Instead of taking on an entire case for free, they see the benefit of providing these pro bono, these free services for this limited period just for the mediation. We also allow, when we have self-represented litigants, the mediation fee can be waived by the judge. So if someone makes an application saying they want to participate but cannot afford the fee associated with mediation, the judge can then waive the fee. And every member of our mediation panel is required to take a certain number of pro bono cases during their time, so that we can match services with litigants who would like to proceed. After the mediation session, the parties report the outcome, and that's what's filed publicly on the docket. And as I said, we're very careful with what we share, what is confidential and what is not. But that's reported on the docket. If the case is settled, then the parties can then resolve and discontinue the action. And if it's not, they continue with litigation. I'm going to go to the next slide. And in 2024, just to show some of our data, we had a 67% settlement rate. And so within the program, that includes cases in which the parties reached a settlement at the mediation session or before the mediation session with the assistance of the mediator. Sometimes that happens. They have a preliminary call and they end up settling the case on the call, which is always wonderful. But it is it's a very successful program in helping parties find that resolution. I'm going to go to the next slide. The other programs that we have in our court, we have a program called the Trial Ready Rapid Mediation Program. And it's a mouthful, but it started in the pandemic when it was really hard to bring in juries into the courthouse because of distancing. And so the program was developed so that we speed up the process of mediation. So generally a case will be referred, the parties select their mediator, and they complete mediation within a certain amount of time. In the Trial Ready program, we shorten that amount of time to give parties the opportunity to explore settlement before their trial date. So in that instance, as I said, it's very similar to any other referral, except that it's expedited. We also have our mediator mentorship program, and that's when we have attorneys who have had some mediation training who would like to join our panel but might not have the experience that is required. They can come in and they get paired with a mentor, and they go through training, they observe mediations, they co-mediate with a panel mediator before graduating from the program and then applying to become part of our panel. As I mentioned, we have an advisory council. So those are members of, they could be our mediators, our arbitrators, they could be advocates who participate in that mediation advocacy program. We meet together about 5 times a year, and we review what are the areas of need, what are programs, what are trainings that would benefit. And so they offer invaluable input into our program. And so those lead to the trainings and events that we have. I think the last slide is my contact information, as well as the link to our website. And so I always encourage it, and our information is everywhere, but I always encourage people, if you have a question, please reach out. I'm always happy to talk.
Дякуємо, дорога Даніель.
Thank
Ви
you
вже
very
відповіли
much.
на деякі запитання.
Daniel, you answered some questions that we saw on the chat, but we have several other questions we would like to get the answers to. You mentioned that you have your own program, and we know that each court, each state has their own EDR program. How is it happening? Who approves this program? Is this the Council of Judges, or there is the other way to do that? And was the question whether the mediation works in the bankruptcy or insolvency cases, if this is the jurisdiction of your court?
Thank you so much for those questions. Yes, it's a complicated system in that there are state ADR programs, and those are set by different rules. And so in New York, we have a state program that runs according to different directives than our federal program and our directive. So there are two layers. I'll say that at least for us, we have a local rule. So in the federal courts, we have a local rule that governs our program. And then we have procedures that sort of outline all of the ways that our program should work. But in terms of where does the directive come from, there's actually a statute that required that federal courts have and offer alternative dispute resolutions to litigants. And so then there are certain requirements within that statute that talk about what the program should look like. And so we follow those directives informing our local rule and our local procedure to make sure that they're all in line. And it's offering ADR, it's keeping the data, it's making sure it's a quality process. So all of those directives then are baked into both our local rule and our procedures. So that's where the direction comes from. I also, our program in the Eastern District and in other district courts, this is the case, which is that we have an oversight judge. So our oversight judge is Judge Levy. He's a magistrate judge in the Eastern District. So he oversees the program. He receives information about directives from other programs to make sure that we're in compliance and that we're keeping up with whatever sort of new developments are. And other courts have either a single oversight judge or a committee that oversees the program. As I said, we have this annual report, so that's shared with all of the judges within our court as well. And the second question about bankruptcy, there's a separate bankruptcy mediation program. I actually don't oversee it in our court, but there is a separate program that operates in our bankruptcy court, and it's also quite successful. Bankruptcy cases are so interesting because they have so many different pieces and parts, and it really lends itself very well to mediation to be able for the mediators to take the time to work with the parties working through the process, because it can be quite time consuming, and so it's a good match for mediation.
Дякуємо, що приділили сьогодні нам
Thank you very
час.
much for finding time for joining us today. This is morning in New York, but you're still working with us. We truly appreciate that. It really helps us. Thank you for this insightful presentation. It integrated statistics, your modes of work, collaboration of court and mediation. We're very thankful, and we'll be seeing you again, hopefully. And I am giving the floor to the representative of the EU. These are two countries who during recent decades enhanced the use of mediation in the courts. I would like to start with Finland. I'm giving the floor to Ms. Maria Banhaman, the judge of the District Court of Helsinki. And she will look at the interaction of court and mediation in Finland. Ms. Marie, over to you.
Thank you very much. I'm very happy and honored to be here, and I really hope the Finnish experience can be interesting and useful for you. My intention today is to briefly introduce you how the mediation proceedings work in the Finnish courts. You will see some differences to what my US colleagues just explained on the US experience. Unfortunately, the slides are not in the material yet and not translated, but maybe this can be provided afterwards. So I'll just share my screen and hope you can see the presentation. Okay. Can you see the presentation now?
Так, все добре.
Yes, we can see it.
Okay, excellent. So, a very brief introduction to Court Connect in mediation in Finland. It's been 20 years since the first Court Mediation Act entered into force. And we mediate in the general courts as opposed to the administrative courts in Finland. So the district courts, where I preside over cases as a judge and mediate in the Helsinki District Court. There are 20 others, but also in the appellate courts, theoretically in the Supreme Court, although I don't know any case mediated there. There are two methods of transferring cases. Either during the proceedings, you can transfer a pending civil case. If the parties agree to mediation, then the court decides to start mediation and the case is transferred to a mediator in the court. Or there can be a direct application by a party or both parties. If all parties agree to the mediation, then we start the mediation. So it's always a voluntary process in the Finnish courts. It requires agreement, so we do not have a mandatory mediation system. So that's kind of the two avenues of going to mediation. I'm actually very happy to tell you that if we look at the 20 years, even between 2015 and 2025, if we look at the statistics, the use of mediation as a means of resolving civil disputes more than doubled in the Finnish courts. So it has taken a lot of persistent work from people who really believe in the process, the mediation process as a means to resolve disputes, and also cultural change among attorneys who either recommend or don't recommend mediation to their clients. I will speak a little bit about some of the project work that we have done in the Finnish courts a bit later on. A slightly different system, because in Finland, the judges mediate. We don't have volunteers. It is very rare that you might have someone from outside the court participate as a mediator in the process. It's possible, but very rarely done. Of course, not the judge presiding over the case, but another colleague in that court, another judge who will mediate that case as it will transfer within the process. We have a 3-day basic training every year or every other year, depending a little bit on the resources. The training is coordinated by the National Courts Administration in Finland. And we hope that, and it's based early on CEDR. I'm sure you're very, very familiar, many of you, with the CEDR model. So I think that's what the Finnish kind of mediator training started with, and the model that we train today is also based on that model. It's a structured proceeding with 5 stages. I will not go into detail on that. And it's more of a facilitative model. Although we are judges who mediate, it is not evaluative, or it's not supposed to be evaluative. To at least to a very great extent. So it's more of a facilitative model where the parties themselves find the solution to their dispute. And of course, we can, if there's an agreement, it can be confirmed, and it has the same force of law as a judgment would in that court. In Helsinki alone, we have more than 30 court mediators who have received the training. Not all judges mediate, but a great percentage of the judges do mediate, so they're familiar with the process. And we can mediate anything from, let's say, €100 debt or 100 million construction dispute. All of this and everything in between. So all of this has been mediated successfully in the courts. and we try to train and improve our skills every day. And I think there has been a real development in the culture, so a positive trend continues. It depends a little bit on the district court to have direct mediation applications. In Helsinki, it's not too often, but it does vary depending on what the culture among the local attorneys is. I wanted to raise, there's also a family mediation proceeding specifically for custody or living arrangement and visitation rights types of disputes, which is a bit different because you will always have a co-mediation with an expert, so a judge and a psychologist or a social worker. I will not go too much into detail on this, but it normally takes 1 to 3 mediation sessions because oftentimes you would have some temporary agreement to see if this really works, what you have agreed, and then you come back around the same table. And also there you can confirm an agreement if such is reached. Okay. A bit about the culture and the projects, what we have done in the Finnish courts. First of all, there are 20 courts in 20 district courts in Finland. And I could say that each and every, depending on the area, it might slightly different. There might be slight differences depending on how much, depending on many different things. Different district courts also have slightly varied different caseloads depending on what types of cases do come to that specific court. Also, many of the Finnish courts have had their own specific mediation projects where they have really tried to push mediation as a method for dispute resolution. Not every court has done it, but I would say at least 5 or 6 courts in Finland have had their own project dedicated to promotion of mediation. Also in 2022, the National Network of Court Mediators was established. I'm the secretary to this network, and I think it's very valuable to have a network where every district court is represented, trying to promote best practices. We have drafted a handbook on mediation just to try to share some of the practices and thoughts so that everyone could benefit from that. We try to have training. We could give statements to some and so forth. So I think that has been a very good initiative also, and the support from the national courts. Then I think in Finland we preside over cases, and I think, and I used to be an attorney, and I know that many attorneys might find it also hard to, at their own initiative, say that, okay, let's try, we want to mediate this case for some reason. And I know that some of the former colleagues still say this. And when judges themselves say that, hey, have you considered mediation in this case? I think if this would be a really good case for mediation, then it's much easier to agree. Okay, yeah, this would be a good thing. In the courts, I think almost in every case we ask, would you like to engage in mediation, and explain a bit about the process with leaflets and so forth. But I think the role of a judge as a gatekeeper is still really important, what we have found. We try to have a lot of dialogue also between the courts and stakeholders. We have had events with attorneys who are very happy to engage in a discussion, because it's a joint effort to make mediation more well known and so forth. And I wanted to give you something concrete and to talk a little bit about mediation project that went on in the Helsinki District Court from 2020 to 2025. I joined in 2021, but the project team that was the kind of first ones, I wanted to give their names because they're really important to the Finnish mediation scene. Perhaps Antti Heikenheimo is familiar to you. Some of you, if you know a bit about Finnish mediation, he's really kind of the one of the mediators who have trained so many people in mediation in Finland. And Camilla Raumasem, who is a judge and also has done a lot of training. And before Helsinki, they did another mediation project in another district court in Finland, and then they joined the Helsinki courts. And from the start, I think it's very important to have support from the leadership. And even in this project, we had a steering committee with the chief judge and all the department chiefs of the court. So really the tone from the top and the support is very, very important to make people understand, okay, you know, this is very important. And what we did, we trained all the court personnel. There are new mediation rooms to really cater to the specificities of the mediation process. We drafted tools to make it easier for all judges to market mediation, not just those judges who already knew mediation because they were mediators, but to everyone. We found that very important. We did checklists on what kind of cases are good for mediation, almost all cases. We held stakeholder events with attorneys, with some of the city of Helsinki as some of the others to try to promote mediation. We called some old cases. We called the attorneys that, hey, you know, this has been pending for some years. Would you like to try to mediate this case now? We think it would be really appropriate for this one. And we had some very good results. In 2024, also the Court of Appeal of Helsinki had their own mediation project, and the results have been very good. I understand they managed to get a lot of cases to mediation, even at the appellate level. And I think step by step, we try to develop awareness and also trust in the mediation process and in the competence of the mediators in the courts.
Дякую, Марі, дякую. І в нас є декілька
Thank you
невеличких
very
питань.
much, Marie. We have a few questions. You mentioned that you have the opportunity for the judges to carry out mediation. Do we speak about all the judges or those who express this desire, and how they're enabled to carry out mediation? Is this the justice, the Council of Justice, or some mediation council? And another question, can the parties discuss the issues other than those indicated in the case and presented to the court?
I will start with the last one. Thank you for the questions. Yes, the parties can bring other issues to the mediation. It's really driven by the parties. If there's something they want to discuss, that's allowed. So we are not strictly limited to that particular or the arguments or that. So we try to find interests from outside the case. And as to the first question, I think the judges in each district court who are interested in mediation, want to have the training, they can mediate. But of course, you will never mediate your own case that you preside over. It's always transferred to another colleague. But there is no, and each court has their own systems on how the mediation cases will then be distributed to the mediators. The parties can even ask for a particular person to mediate their case. So that's also possible.
Дякую. Дякуємо вам за участь і за цей
Thank
дуже
you very
цікавий
much.
досвід.
Thank you for participation with this interesting experience of how you carry out this interaction between mediators and the courts. Now we're going to look and experience other European country. Today, we're joined by the president of the district court in Brestko, Agata Gavlovska-Supisak. I can see her has joined us already, so over to you. Agata also represents GEM. This is European Organization of Judges for Mediation. So we'll be really interested to hear how this organization operates in Poland, because they've recently celebrated 10 years of GEM in Poland. You're muted.
Мікрофон, будь ласка.
You're muted.
Now it's good, yes?
Є.
Okay. Good afternoon from Poland. It's an honor to be with you today. I want to talk about how important the role of judges is promoting mediation. Poland is behind the USA, Finland. In Poland, judges can't be mediator, and there are no program, mediation support programs. And now, may I please presentation? And next slide. Mediation has been in the Polish legal system for over 20 years, but only a small number of cases have been referred to mediation so far. And next, in 2022, in District Court in Brzesko, were referred only 2 cases to mediation. And next slide. Only 2 cases, only. In 2023, I became the president of the district court in Brzesko. As a member of GEM, I decided to change the situation. But how to do that? And next. First, we organized legal training for judges. It was necessary to explain to the judges why should the parties try to resolve the dispute between themselves. The best way to do that is a settlement, an agreement reached between the parties during mediation. And second, next slide. We organize meetings between judges and mediators. Why? Because judges were concerned about referring cases to mediation, because they didn't know mediators and their competencies. And next. And finally, we created a mediation room. It functions like a mediation center in a big city. We have a team of mediators and opening hours. It was the first mediation room within the jurisdiction of Tarnow Regional Court. In 2024, we introduced a pilot program for referring family cases to mediation. It's the first such program within the jurisdiction of the Court of Appeal in Krakow. Some of family cases, child support cases, child contact cases are referred to mediation before the first hearing. In Poland, mediation in family matters is not obligatory, but in the district court in Brzesko has become mandatory. It's revolutionary. In 2025, we introduced an information meeting program. This program is being implemented in 3 stages. First, a judge and mediator meet with the parties to discuss alternative methods of resolving disputes. After this meeting, the parties may meet with the mediator and reach an agreement. Second, the meeting will be led by a mediator and a judicial assistant. And finally, the meeting will be led only by a judicial assistant. And the moment we organize legal training for judicial assistant. This meeting it's very important because the parties are informed about various alternative dispute resolution methods, like in USA, like Maryland, and people during this meeting give full information about alternative dispute resolution. And next. But in Poland, people love courts. And promotion of mediation means that the parties are encouraged to use mediation before referring the cases to court. And we decided to educate children about mediation. And I want to say a few words about it. We have a program for children, education for mediation. This year, 500 children have taken part in it. we organize mediation simulation workshop for children. And we organized an art competition, Change the Narrative and Choose Mediation. Children's drawings decorated the mediation room and this presentation. And local newspapers featured these drawings in their issues. The next. The educational activities of our court were recognized by the Minister of Justice, and it's very important. All these activities we carry out voluntarily and without payment. Thank you.
Дякуємо вам, Агато, за те, що поділилися вашим
Thank you
досвідом.
very much, Agatha, for sharing your experience. It's very similar to Ukrainian. We are also at the beginning of our way into culture of communication between judges and mediators. We will take into consideration your experience. You've made so much. Thanks a lot again. And now I will give the floor to the Ukrainian representatives. There will be Chief of Staff of the Vinnytsia Court of Appeal, Chair and co-founder of the NGO BAPS. Also, we will hear from Ms. Lilia Korpovan from Odessa Commercial Court, and we would like to hear what Pani Lilia will advise us to provide. Thanks a lot. Thank you, Maxim. My presentation is very spontaneous. I'm just jumping in between my court sessions, and I know that the topic for the judges is very important. And what I want to tell you particularly about the region I work in, Odessa region, from 2018, we have in our commercial courts the following projects supported by the Ukrainian Academy of Mediation. They actually introduced this project before the law on mediation was adopted together with a European partner. We have a lot of information banners in court regarding the procedure. Also, the judges during hearings explain to the parties the opportunity of conduction of mediation on the websites of the courts, of our commercial courts of Odessa region, and also of our appellate court. We have a lot of materials regarding this process. Also, Q&A regarding the services, register of mediators, all the information on the procedure of mediation, how it's being conducted, and how it can influence if the trial is ongoing, if the hearings are on the merits already. So how can it be related to the procedural legislation? And before the judges explain that if the parties go into mediation, the trial proceeding will be put on hold, and if the mediation is effective, if they achieve the agreement, then they will get back 60% of their court fees. So this is also some stimulation for the judges. Also, I would like to say that it's very important for commercial courts because we are hearing mostly economic cases, business cases, and they are very important for the economy of the country. They are not only important for these two parties, but for the whole country. So this procedure saves time for the parties, also saves money for the parties, but it's also very important for the economy of our state in these difficult times. We place also information about assistance to Ukrainian Association of Mediators because it's possible to get support and mediation from them. Of course, they can go either to mediation or to other mediators. So all this information is placed on our website, and we refer the parties in this direction. Also, as in any other countries, as I've heard in the previous presentations, of course, the judge is not allowed to conduct mediation. So in this procedure, we have, of course, an opportunity of conflict dispute resolution with the help of the judge as part of our court procedure. And we also post the information what the difference is between these two options, and the parties decide which procedure to choose. Of course, some of our judges were trained as mediators and they have a mediator status, but this is for their own self development and to use this knowledge and the skills in the procedure, but without this mediator status. And of course, we understand the importance of this institute, and we are trying to provide it. Maxim, that was very interesting, your conversation with an American colleague about the bankruptcy cases and mediation in them, because we just started to implement this. And of course, the judges are not allowed to participate in such disputes, but of course mediation could be very effective in this sphere, because when we talk about bankruptcy, it also influences the condition of businesses, condition of state economy, and of course we have to copy this experience and start implementing it. Thank you very much for joining, and it's very valuable for us that you post information about the differences about dispute resolution with participation of judge and mediation. That is very important for the participants, for the parties to understand that these two procedures are absolutely different and that they can choose what is more appropriate for them. Now I want to give a floor to one more Ukrainian representative, Ms. Natalia Korol. She's the chief of staff of the Vinnytsia Court of Appeal, and she is always open to all new staff in the judiciary system of Ukraine. And I want to ask her what was the most important for you from what you've heard today, and what would you like to introduce in Ukraine in order to support the ADR culture in Ukraine? Good afternoon, dear colleagues. It's a big honor for me to represent our experience. I represent here an NGO of our employers of courts. From the first panels, I've heard that we all need to look at a different point of view to the fairness and what the fair dispute resolution is, and to change our approaches to this definition. And dear colleagues, I take in mind the timing, and I want to take now a different point of view on mediation instruments in courts. We talked a lot and we've heard a lot of experiences from other countries, and it's very valuable for Ukrainian judges how to resolve the disputes between the court proceedings participants, but our association of employees of courts, in terms of a big project, it was 1.5 years long, and we had a suggestion of a solution. I'm not meaning the process now, but how to organize the work of the court, how to create a typical a directive to manage the conflicts in court. Why do I talk about managing conflicts? It can be very weird for you to hear, but when people come to court, they want to resolve the dispute, but at the same time, our Ukrainian courts are full of conflicts themselves. And it's good news, because if in an organization there is a conflict, it means that the organization is developing. And I will share a small presentation with you now. There I will tell you in brief about what we mean when we talk about creation of this conflict management service in courts. This idea appeared on the stage when we were discussing what is to be done in terms of implementation of project of reloading access to justice, how to implement model decision, as to which we were implementing in support of the European Union project Travel Justice. And we thought that we have a lot of conflicts inside the courts. Why? Not just because we are developing, but also because probably for our foreign colleagues, our courts in Ukraine, they're unique because we have different legal status employees. I mean, we have not just the judges, but we have also staff. Some have status of a judge, some have some other participants of the staff. And those who are just our staff, they are assistants of judges. It's absolutely different proceeding, or their cooperation, how their work is being organized, and so on and so on. At the same, in the staff, they have state employees covered by the Ukrainian law on state employment. They have, again, different rights and different obligations, also how they're being employed, and also they have, of course, conflicts because of this difference in their legal status, for example, between the secretary of court and assistant of the judge. Also, we have people who can be appointed by the chief of staff without any competition. It's another status. And then the fourth is just a regular employees. So all the people have different legal statuses, and also it's like also their values, their basic values, and their relation to their work. So before creating anything, we decided to ask our colleagues if you have conflicts in your office. And 150% said yes. It's 62% from our staff, and they said yes, we have conflicts in our work. Sorry, we cannot change your slides. And now we can, now we can change them. I don't want to use the slides. After this survey, we asked the Ukrainian Academy of Mediation for help. We wanted them to assess the results of this survey. And of course, I'll show you the next slide with this result. And we wanted some help from them. What could assist our employees. Why is it important for us right now? Because we spoke with the colleagues during today's forum already that our experience is unique because under these conditions, not a single country of the world is working right now. It's important now because we have a huge deficit of employees. We are also emotionally overwhelmed. We have organizational changes. And we always change our statuses. Some of the courts are being put together, and we have to still stand through these problems and keep on working. Also, we made a survey with the Proper Justice about our well-being and about our professional load. And I will present the results on the 15th of June during an international conference, but I will tell you that 96% of court staff said that they were overloaded and it's impossible for them to recover after the working day. It's just for you to understand how people are working during the war under the war conditions. So with the lack of staff, they are also at the age of burnout, and that's why it's very difficult to settle disputes within our courts. Of course, we created not to react to the existing conflict, but to prevent it, to create a safe space for dialogue and such conflict prevention. What is the service? This is a mechanism constantly active which could prevent conflicts, support communication, negotiation, and a kind of mediation among the employees of the court. Under the support of Ukrainian Academy of Mediation, our NGO of court employees, we conducted the first school. It was a school of court administrator court up. And one of the blocks was a block regarding mediation skills, in general, how to communicate with each other, with the visitors of the course. And I was educated by the Ukrainian Academy of Mediators as a mediator, but I was shocked when some of my colleagues that they were not at all aware that mediation exists and that it's possible between the participants of a conflict. So they were quite far away from understanding that mediation is a part of our everyday life and we can apply it for each kind of conflict. So it's this service is not just to resolve the disputes, but also to disseminate the information about mediation. So yeah, we wanted to create this safe sphere, a safe platform for the dialogue. We constantly have dialogue between staff and judges, between the chief of staff and colleagues, between chief of staff and panels of judges. So we have a lot of different formats of communication, and we want to make it understandable by means of introducing this service of conflict resolution. And what this service could do for our courts. Consultancy. We spoke a lot about mediation. Our colleague from Poland is telling that they start from children. So they involve already 500 children to make them understand what mediation is. And we working in courts, we were not aware about. Of course, we have to consult to organize mediation, to organize negotiations, to train basic skills of mediation and communication, and of course, promote the culture of dialogue. In order to implement it, we need to be at least aware about it, what can be used and how
Як і
can it be.
медіація, діяльність служби базується
As well as the
на
mediation, the
ключових
activity of
принципах,
our
як
service
добровільність,
is
конфіденційність,
based
нейтральність,
on
неупередженість,
confidentiality,
рівність і незалежність. Тобто
impartiality,
вирішити
and
конфлікт
independence.
за
So to
допомогою такої
resolve
служби
the conflict
можна лише
with the help of
добровільно.
the
Тобто
service,
добровільність є
you can
ключовим
only do
фактором
it
у
voluntarily.
вирішенні,
This is
коли
our
люди
key factor.
зацікавлені у вирішенні
When the
конфлікту,
people
так,
are interested
як ми
in
кажемо,
resolving their
ми
dispute, their
слухаємо не для
conflict,
того, щоб відповісти,
we
ми
listen
слухаємо для
not
того,
to
щоб
answer,
почути. І
we
ось цьому
listen
потрібно
to
просто
hear.
навчити абсолютно
And
усіх,
we need
хто
to
працює
train
в суді, тому
everyone
що
who
в
works in
конфліктному
courts to
середовищі
follow it.
очікувати
Because
людини
in this
орієнтованості, так, про яку ми
conflict
зараз дуже багато всі говоримо, про
environment,
те, що кожен судді,
to
учасник повинен
expect
бути
a
почутий,
focus
ми
on
повинні забезпечити
personalities,
безпечне
to
середовище,
hear
ми повинні
everyone,
бути
to
абсолютно
guarantee
людиною
the safe
орієнтованими. І
environment.
загалом суд розглядається як
Mm,
інституція, яка
So
надає
yeah,
судові
the
послуги,
court is
то для того, щоб
the
таку послугу
institution which
надати в
provides
середовищі абсолютного
certain
сприяння і
services,
людиноорієнтованості,
and of course
потрібно
it
бути
has to be
самому внутрішньо
focused on the
налаштованим, так, і не
people,
перебувати в
on each
конфлікті ні з
particular
собою,
person.
ні з
But we
своїми
need to
колегами.
not
Тому,
be in
звичайно,
conflict with
діяльність такої
ourselves
служби
and with
є
our colleagues.
сьогодні,
So this service is
як
for
на мене,
today
ну, абсолютно необхідною.
absolutely necessary.
Як таку службу створити? В типовому
How to
положенні,
create the
яке ви
service?
можете знайти на
There is
офіційному
a
сайті громадської організації,
website
запропоновано
of our
такий спосіб
NGO,
утворення, як через
and we
рішення зборів
offered
суддів. Збори суддів,
to
відповідно до закону України про судоустрій і
to
статус суддів.
create a decision
Це
by means of
такий
a meeting
один
of
із
all the
інструментів
judges.
теж управління
This is one
судом,
of the
які
instruments
мають
of
право ухвалювати
court
рішення, які є
management, and
обов'язковими
this
для працівників суду, так,
organ
в тому числі.
have the
Ось
right to
широкі
take
повноваження зборів суддів надають нам
decisions.
таку можливість, принаймні не
So this
виключають таку
meeting
можливість створення служби, яка
gives
би
us
могла
an
зарадити
opportunity to
багатьом
create a service
процесам
which could
такої
help a lot of
внутрішньої
processes
комунікації між
of our internal
працівниками апарату і
communication
судом та й
between
загалом
the
між собою.
staff
Тому
and
запропоновано
judges.
піти через рішення
So
зборів суддів як
we wanted
колективного
to get
органу,
this
як органу суддівського
collective
самоврядування,
organ
і,
of
звичайно,
judges'
призначити координатора служби,
self-governance,
тобто
and
людину,
to
яка
appoint
би
a coordinator of
загалом
the service, a
регулювала, була
person
таким
who
загальним
will
регулювальником
genuinely manage it,
всіх цих
will be the
процесів.
general manager
Переговорники
of
маються на
all the
увазі судді і
processes,
працівники апарату,
also
які прийшли підготовку з
negotiators, the
медіації. Таким
judges,
чином ми ще більше
and the
будемо
staff
заохочувати
employees who
проходити хоча б
were trained as mediators.
базовий
So
рівень
we
підготовки. Звичайно,
motivate them
ключова
to
вимога
get at
відповідні
least
компетентності довіра
basic
колективу.
mediation
Саме
skills
тому ми
training. And so
схиляємося до того,
by
що
this
якраз
means we
рішення
are going
зборів
to
суддів
build the trust
може бути
of
оптимальним в
our
даному випадку, тому що збори суддів
co-workers,
вони
of
можуть
our
висловити
colleagues.
як недовіру,
So
так і можуть висловлювати довіру. І
this
ось ті, кому вони довірять, тобто це
people,
будуть люди з певним
these
кредитом
judges,
довіри і
they will
з
be
певним
able to say, okay,
набором уже так
this is the
базових
person, the
навичок,
mediator
вони могли
who
би
has these
забезпечити
basic
роботу
skills,
такої
and we
служби.
trust this person absolutely.
Погляд
They
у
make it as
майбутнє.
decision
На
official, so these
сьогоднішній
people
день
are
результати
able
опитування,
to
які були
work.
проведені
So
буквально
today we
рік
have
тому,
results of the
засвідчили, що
survey. It's 1
незначна
year old,
кількість, поки що
and they said
незначна
that
кількість суддів України
just
готові
few courts in
включитися в
Ukraine
роботу
are
служби
ready to
управління
join the
конфліктами.
service
Якщо я
of
правильно
conflict
пам'ятаю,
management.
20%
And
опитаних,
I
а
remember
опитаних це
that
було 150
20%
суддів,
of
які висловились про те, що вони готові стати
20%
пілотом
of
в
courts, of
напрацюваннях і в організації роботи
150
такої
courts,
служби.
they
Для цього нам
said,
потрібно,
okay, we are
звичайно,
ready
щоб в
to
таких
be a
судах були люди,
pilot
які пройшли
project.
базову
Of
підготовку,
course, we need
люди,
their
які готові зайняти таку
people
проактивну
who
позицію,
had
так, вийти
basic
з таким
training
рішенням
of mediation,
організаційним
who
на
has
збори, отримати підтримку зборів і, звичайно,
basic
підтримку безпосередньо
And
керівника
of course,
суду,
the
так,
support
суду,
of
який
the
чарівним кивок
chair
головою
of
має бути,
the
тобто всі готові до
courts.
того. Але я
So
думаю,
when
що
everyone is
під
ready
час
to step
11-го
in, but I
форуму я
believe during
поділюся з
the
вами
11th forum,
практичними
I'm going
результатами
to
впровадження
share
такої
practical
служби. Я
results of
щиро
introduction
надію в те,
of
що дуже
such a
багато суддів
service. I
долучаться.
am a strong
Була дуже
believer that
рада,
many
що
judges
Вінницький
are going to
апеляційний суд
join, and I
застосовував
will be
медіацію
glad
не
that
тільки
Vinnytsia
як
Court of
підтримку
Appeal will
вразливих,
use
тому що ми це вже
mediation not
робимо,
only as the
і
support to
попередньо
vulnerable
висловлюємо службу
groups that we
підтримки
already
та
do. We
довіри,
refer
потерпілих у судових справах про
through the
домашнє
service
насильство, хоча я
those
знаю, що це
the
спірний момент,
victims,
але ми
the
продовжуємо,
survivors of domestic
переадресовуємо.
violence. I know that the arguable moment, but still use this referral. But I believe we can join this pylon because the strong court starts with a strong team, and the human-centered approach is only possible if we solved all our own conflicts. And this is the word of thanks. Thank you very much, Ms. Natalia, for this presentation. Thank you for enhancing the culture of dialogue, the culture of reconciliation, not only in your region, but also in your court institution. It's truly valuable. I would like to thank all the panelists for today's session. And now we have our 600 participants and speaks. It attests to the great interest, and these are only Zoom participants. People are interested in the cooperation, collaboration between court and mediation. Today's presentations reflected the extensive experience of other countries that court and mediation can truly efficiently collaborate. Let's recall the statistics that our New York colleague shared that out of 9,000 of civil cases, almost 1,000 was referred to mediation at the request of the parties. It means that we can enhance this important mediation collaboration in Ukraine. We can do it within the roadmap on the rule of law. Within this negotiation process of EU accession of Ukraine. So we'll have lots of work to do, and we have to create this environment of collaboration among courts, mediators, attorneys, and other stakeholders. And many more cases will be referred to mediation. And we will see more settlements, pre-trial settlements. As of now, we have this agreement that we're going to have to carry out this fundamental training for the staff in courts and in attorneys that were to train them in terms of IDR standards, how to refer parties to the mediation, and how to use CPEJ standards. It also relates to the National School of Judges that train the judges for the courts of Ukraine. And next year, we're going to share the numbers of using mediation in the courts of Ukraine, and how we will see that judges are proactive in explaining the parties the benefits of mediation and creation the mediation rooms in the court as it is provided by the roadmap and rule of law. Thank you very much for attention. It was extremely beneficial and insightful session. And please share your feedback, your comments on social media regarding the insights and recommendations our esteemed participants from Ukraine and from overseas shared with us today, and about the values, the core values that we heard today regarding the court and mediation. Take care. Thank you very much. Thank you very much, Mr. Maxim, and we're thankful to all the speakers. It was such an inspirational session regarding the levels and the models of court and mediation collaboration. We could see this room for improvement, the possible synergy among all the stakeholders, the judges, the mediators, the attorneys. It was very interesting to see and to hear, and especially in the context of the future pilot project we've mentioned. We heard today from the Minister of Justice. It is going to be really valuable to explore. We're going to have a very intensive schedule ahead, but I would like, Ms. Agata mentioned how much courts can be active in terms of promotion of mediation among the children. And we invite our overseas colleagues on Saturday. It's going to be the lesson of peaceful justice. It was initiated by the Courts of Government Association, and our academy brought in mediation component there. And on Saturday, we're going to have this lesson. They take place quite often time in courts if security situation allows for that. We have online lessons, we have joint lessons with judges. They speak about a judge, what the court is. They show the attribute, the features of the judicial power, and they're accompanied by attorneys and mediators who can share the alternative modes, and children can tell the difference. In no way do we make this differentiation or showing the mediation as a counterparty to the court, but it's about collaboration. And people have to be aware of the various modes they can achieve justice in a specific situation. So yeah, warmly welcomed to join, and also please stay with us and during all other days, because today is only day one. We have so many activities, and thank you so very much for this interesting, insightful panel. This is something that there is lots of food for thought for us here regarding our way forward. Thank you very much to all. Now we're going to have a break and we go back to work in 24 minutes. Our next panel is not less important. It will look at the literature, especially children-oriented literature, can be used to channel their values and tools, mediation, tools of nonviolent communication. Please, if you're interested, stay tuned. floor to you.
Зорієнтуйте, будь ласка, чи наші спікери вже
Our speakers have joined us already.
мікрофончики. Вітаю.
Так, є.
Hello, hello, we're
Чудово,
here.
чудово. Тоді можемо розпочинати.
Great, then
Отже,
let's get
шановні
started.
учасники, я
Dear
вам рада
participants,
представити
let
сьогоднішніх
me
наших
introduce you
виступаючих.
our today's
І,
speakers in
власне,
this
тема у нас
session.
пов'язана
And our
з
topic
популярною
today
літературі,
is associated with the
зокрема, в
mediation
дитячій
in
літературі.
literature and in
Важливо
children's
загалом
literature,
говорити про
namely
культуру
how
порозуміння,
important
про
it is
тему
to speak about the
порозуміння, які вони
reconciliation,
характеризують
about
комунікацію,
nonviolent
як це
communication,
впливає, власне,
how
на
it
ефективні антибулінгові
influences
заходи, про
the
які сьогодні
anti-bullying
розповідають представлені
activities that have been
представники
mentioned today by
Служби освітньої безпеки від Національної
the Service of the Educational
поліції
Safety
України.
of the
І,
National Police
власне,
of
пані
Ukraine.
Ірині та пані
And
Тетяні.
I'm giving the floor to Ms. Irina and Ms. Tatiana.
Так. Чи є у нас звук?
В мене
Can we
перерив.
hear
Трішки
them?
чути, чи чути мене, друзі? Чи
Uh,
чути мене?
can you hear me well?
Чути прекрасно.
Так, і мене також.
Yes, we can hear you well.
Чути
And can you
прекрасно.
hear me well?
Олечка, це
Loud
щось
and
зі
clear.
зв'язком у Олі
That
саме.
Ola has
Трішечки
some issues
пропадала,
with
але вас
connection.
чути
Yes, she was
прекрасно.
freezing a bit, but I can hear
Добре,
you
я не
very
розчула
well.
останніх слів
I
Олі
couldn't
теж
hear
через
Ola's last
мій
words
інтернет,
because I
але
thought I
якщо
have some
раптом буде ні,
internet
то я
hiccups,
швиденько
but if I have
перемикнуся
some
і
issues with the
змикнуся
internet,
знову до
I will
нашого
switch to the
Zoom.
other network and will
Хочу
rejoin
привітати
our
усіх. Ми
Zoom.
можемо починати. Я правильно
Shall we
розумію, пані Ірино?
start?
Так?
Right?
Дякую. Хочу усіх
I would like
привітати
to
і
welcome
відразу
everyone
подякувати
and would like to
Українській
say the word
академії
of thanks to
медіації
the
за
Ukrainian
те, що
Academy of
запросили нас,
Mediation
і
for
взагалі за те,
inviting
що
us, for having
поєднали
us
і
today,
поставили поруч
and
два таких
for
важливих слова, як медіація і
bringing
література.
in two
Мені
important
самій
words,
теж
mediation and
дуже
literature.
цікаво, якою
I'm
буде
really
сьогоднішня наша розмова,
fascinated about
оскільки
seeing
я
how
маю
our today's
безпосередній
conversation is going
стосунок
to
до
end because
літератури,
I have
і
the
наша
direct
запрошена гостя
link to the
Тетяна
literature,
Стус
and
також
our invited guest, Tatiana Stus,
безпосередньо, окрім того, що пише, вона
besides
теж
being a
має
writer,
стосунок
she
до літератури.
also
Отож,
relates
я кілька слів
to
про себе, тоді
literature. Let me say a few
представлю пані
words about
Тетяну і будемо
myself, and let me
починати
introduce
наш
Miss
діалог. У
Tatiana,
нас з вами
and we
десь
shall
приблизно
get
1,5
started. We
години
have
для
about an
спілкування,
hour and
але
a
я би
half for
хотіла, щоб
communication, but I
не
would
тільки ми
like
з Тетяною зайняли
not
увесь
only
цей простір,
Tatiana
дуже
and
хотілося б,
me
аби
to occupy
наша
all the space,
публіка
but
теж
we
приєдналася. Якщо у вас
encourage
будуть
our dear
якісь коментарі,
participants
запитання,
to
ми би
step in.
хотіли,
Should
щоб
you
ви
have
з
any
нами
comments
вступали
and
також у
questions,
діалог, де дуже
please
важливо. Ми
let's
представники
start the
літературної
dialogue. We
сфери, тому дуже
represent the
важливо, щоб ви,
literature
ті, хто
area,
активно з
and
юриспруденції, з
we would like to
медіації, з
hear also
психології,
from
теж
someone who
доєднувалися
have the
до
psychology,
нас.
mediation, and
Отож,
a legal
про
background.
роль літератури і загалом
Speaking
авторськості
about the
в поширенні
literature role
цінностей
and the author's
комунікації,
role in
емпатії
terms
і
of
мирного регулювання спорів, буду
dissemination of
говорити
the
я,
values of
Ірина Рудика,
empathy
я фахівча
and
з розвитку
nonviolent reconciliation.
язикознавець, взагалі
I'm
займаюся
Irina Rudika.
неформальною
I am
освітою,
learning and
пишу,
human capital development
організовую,
specialist. I
ну і багато
work in
чого іншого.
informal, non-formal
І також по
education.
іншій
I'm
бік
a
вашої
writer
екрану з
and
вами
cultural
Тетяна Стус,
practitioner. We're also joined by
літературознавиця,
Tatiana Stus. She
письменниця,
is
дитяча
a
психологиня, керівниця
literature
лабораторії
professional. She's
дитячого
the author,
писання
psychologist,
Національного
and
центру
founder
Малої академії
of
наук,
the
засновниця
Brabuka
проекту
Children's
Беребука.
Reading
Я думаю, що
Promotion
більшість про нього
Project.
вже
She's
чули.
also
Ну і
in the
також
leadership of the
громадська активістка
Junior
реформування
Academy of
шкільної
Sciences of
літературної
Ukraine, and
освіти.
she
Отож, як
also the
бачите, у нас
activist advocating for
ну ось
school
прям
literary
прямий зв'язок з
education
тими
reform.
статтями,
So
про
we
які ми
have this
будемо
direct
говорити.
correlation with the topic we're going to
Що би я
explore
хотіла
now.
зауважити відразу,
What I
що
would like
все, що ми
to start
говоритимемо
with,
сьогодні про
everything we're
літературу, ми
going
будемо
to
говорити в розрізі
discuss
часу, починаючи від
about,
цього
we're going to
великого зламу,
speak
від великих змін, які
from
трапилися з
this
українською
fundamental
літературою,
changes from
українським
the pivot in
книговиданням
the
з початку
Ukrainian
повномасштабки.
literature that
І,
happened
звісно, ми більше
with
сьогодні
the
будемо
full-scale
говорити саме про
invasion.
художню
We're going to
літературу.
speak about
І
fiction in the
мені
first
дуже
place,
важливо, аби
and
ми з пані
that's
Тетяною зачепили конкретні теми
crucial
і
for me
конкретні
that
книжки, якщо у нас буде
Ms. Tatiana and I
на
touch
цей час
upon
можливості.
specific
Що я
books
сьогодні хотіла би
and
сказати,
genres.
що
if we have enough time. According to my observations, most of the books published since 2023 have specific meanings and senses. We started speaking not only about the importance of Ukrainian language, but the importance of Ukrainian book as it is. And now we mostly speak about the war, about how to live in this new reality with our children and teenagers. And there are many developmental literature. As a specialist in non-formal education, I can say that there are many trainings, games, educational courses that improve communication, that help children to improve self-awareness and emotions. But when we speak about fiction, there is a gap. I believe we're missing books and information. Only if we look deeper into the specific topics in each specific book, it may work. Let's speak about some statistics. I first say what I know, and then I will give the floor to Ms. Tatiana. I can see the positive trend since the beginning of full-scale invasion, and this trend is that more Ukrainians start reading. We can see that more Ukrainian books are bought, including the children's one, and the promotion of reading and Ukrainian book come from the top down, and the institutions promote this idea. The Ministry of Education, Ukrainian Book Institute, as well as many other institutions that ensure the interventions to disseminate literature. We speak about book fair, festivals, forums that are hosted not only in Kyiv but across Ukraine. Reading is not an entertainment now, it's a powerful mental health support tool. But I believe you will second my opinion that besides therapeutic and psychological mission, that children's and teenage literature also has this enlightening educational mission. We need to have all I's dotted in many issues. So my first question to Ms. Tatiana is the following. How does children's and the teenage literature change, and what are the trends since the beginning of full-scale invasion? What developments are there in the area of children's literature? And maybe you have some introduction regarding the reading and children's literature, namely. Over to you. Thank you very much. Hello, dear participants. I second Ms. Irina's words that we're very thankful to the organizers because you integrated the two words, because mediation literature will also bring a child into this context. We say that children are our future, but when we get down to some specific changes and education and then literature, we're going to speak about we just don't change enough, and instead of adapting that to new generation, and those processes are very slow and struggling. So it's very important to speak about this issue outside of the professional bubble. I've been working in education for 20 years, and I served the children for over 20 years in pedagogics and literature and children's psychology. When Ms. Irina introduced me as the activist of reforming the literature the area, this is something we have to look at. To change our future, we have to provide as many tools as possible for for the children to reach their potential, and this literature context is of utmost importance. And this is the bridge to answering the question that provides the general picture of what has changed in the children's literature and reading since this pivotal moment of full-scale invasion. mediation. I would like to mention here that we speak about the quality of reading. It sometimes can be controversial. The research of the literature that will be the results, the survey regarding the engagement into reading, the level of reading carried out by the Ministry of Culture for the recent 2-4 months shows this frustrating process that when we speak about the literature, not about scrolling of news feed, we speak about this fiction reading and our link with the deep senses. The quality of reading has dropped significantly, and the number of the books published doesn't show any increase. We have this decline in publishing. We cannot speak from our narrow perspective of keen readers. And in the early years of full-scale invasion, we could see this resilience in, maybe heard this word, the non-reader. Because to read something consciously, you have to focus on something. It's not about reading 1 or 2 paragraphs, rather to focus deeply, to track the plot, to track the dialogues. And many of us during this psychological instability, when we had to take care of our security in the first place, that we read a book and they go back because we read automatically and we are not conscious, we cannot track and focus enough to stick to the plot within even specific scenes. So, and it was happening for 2-3 years, this non-reading. The survey shows that somehow it's getting better. Now we have stabilized in terms of our mental health conditions. We can focus, we keep the track on the novelties of the book market, but it also had the impact on the genre variety. It's very difficult to read the complex literature as well as the literature about the war, and we have a lot of that. Do we have a lot of works on the war and the children's teenage literature? Yes, because it relates to mediation. The biggest challenge was in front of the literature studies specialists and educators. They will have to explain to the children what was happening. Each book, being fiction, still explains to our readers what each word means. We're responsible for every word because adults are the shaped personality, and they have the choice whether they have to go deep into the story to keep reading or not. And we're responsible in front of the children for every and each word. The book Arsenal Fair mentioned had this quote: if you want to explain something through a cartoon or a film, or would rather opt for a book. When the child is reading, they can imagine what they psychologically read. The child will avoid some horrendous picture if they cannot sustain and live with this picture. So we speak about the responsibility of the authors in terms of explaining children what was happening. How shall we speak about the war and especially about peace? There are lots of literature that explains to the children some foundations, and it's also important that the literature provides the tools of comprehending this reality, because even for grown-ups it's so difficult to comprehend how civilized world allowed to happen that. So our children's literature is now saturated with the books about the war and war experience in the context of childhood. Ms. Irina, please guide me because I can speak about this topic much more about an hour and a half. I'm taking some notes, I have some comments. So finish your idea and I will step in then and will proceed take from there. Another important emphasis that have changed in terms of reading related to the adult literature. But now we speak about mediation through the children's literature. I've mentioned this word responsibility. So the entire content of the children's and teenage books has gained many more filters than before full-scale invasion. When we have these public readings with the children, we have so many more rules. At the beginning of full-scale invasion, we haven't had this experience, but we now do have, and this systematizing experience. At first sight, very innocent word can trigger a child because it has gone through a very difficult experience. There was we could once witnessed a very accurate reaction to the word a plane. We because now we cannot see any planes in our skies. Even some the word combinations can be triggering. We were looking, for example, for a replacement for the words broken glass or broken window, because this can trigger children even at the physical level. So the level of responsibility, level of filters that go opening for the children can be very different. What I've noticed today, that I notice now that there are lots of children's literature that focuses on overcoming the war and the effect, the impact it has. So my question is, what does the children's and teenage literature missing in terms of dialogue, reconciliation, some dialogue, etc.? That's a really great question. So, in the Bible of the children's literature expert, this is something that we pondering about all the time. Not only after the full-scale invasion, but even before that, we're missing it in children's literature. And this is funny. This is humor books because this humor brings relief, and also it can bring relief to the children. That's about psychological resilience that they're given by given by humor, and this is something they're missing. That could be a great guidance for the writers when organizing those art events. I've noticed that the people want to read something about amusing or about love or romance. I believe that echoes the children's experience too. I encountered the statistics, and I believe it was from Yakabu and Vivat platforms, like publishing houses, and they indicated that non-fiction, like memoirs, his history books, psychology, not as popular. Along with that, we can see the escapism topics trending, something like fantasy, something to escape the reality, or sci-fi, etc. Something that takes us away from our gloomy reality. Speaking about the children's literature, laughter is a savior here. It helps us all. What about fantasy? What about sci-fi? For children, maybe that's a pathway we should consider. Indeed. And it's not only the pathway we should opt for, but many many are also taking this road, both writers and children. When we look at the inquiries and then something about looking at the preferences, this is quite classical story. Children who become teenagers, young teenagers, are fond of fairy tales, and how to make this shift from fairy tales when the child is growing up. This is fantasy and sci-fi, and this and we're really short of it. This is something we're missing in the children's and teenage literature. So this is a very important way to place this complex content into this children's environment. You mentioned you wanted to speak about the specific books. And the second, third year of the war, the books no longer interpret or show the facts. Now we see the books that show the world we're living in, the world where we have the war, that they become a part of our just regular literature. We can speak about the children's of the fire times. That's a cool fantasy for the children starting from the age of 12, very high quality one. And the background and the foundation is the fight between good and evil. But it shows the reality, reflects the reality of today. So you can see very direct correlation. The venue is a Kiev and the invisible setting, the fantasy setting, and the parallel world of the railway. And we can see the historic sides of Kiev. There's a serious pillars for them. They see the story where they live through this experience in a safe environment. The book is to live through this complex experience in a safe experience. And
Так, зараз повторю книжку, і отримують відповіді на питання. І от в оцій класичній
So in this classical, absolutely history about fight of good and bad, the children see that it happens right here, right now. This story is more understandable for them. They don't have to dream about it based on their life experiences. Quite often, adults, they don't have power and instruments to explain to the children what's happening right now. And I'm talking about this particular book, Children of Fire Times, and also another book of Katerina Kotbienko. It's also fantasy for teenagers. And I invite you, like adults, to read this books. I spoke from the beginning about a non-reader, so how to overcome this non-reader status is to start to read full children books, because there won't be any places in the text where your tired mind will just switch off and put it away. So the children's book, they are brighter, they are shorter, they are simpler to digest. So you want to continue and continue reading. The name of the second book is Miracle Blood. And you just enter the site, the website of publishing house Barabuka. You will have a lot of recommendation there. And when I created this project 14 years ago with the help of very nice people, I saw a lot of private people asking me in private messages what to write, what to read, what do you recommend as worth reading to me and to my children. Because they couldn't oversee the market of Ukrainian modern literature. And now you can read it on this database Barabuka, or just Google it like fantasy Barabuka, and you will see, the link is already in the chat, so it will lead you to the necessary website. This project is a pure voluntary project, and I wanted to talk again about this Barabuka. It's not an advertisement. It was very difficult to build this project and support it for some many years. So, my dear colleagues, please go follow this link and read these books, The Wild Bloods, and also the second one, which I recommended. I see that the Mr. Polsky wants to put in a question. I don't hear you.
Давайте спробуємо
Let
ще
us
раз.
try again.
Я поки що сердечок у чатику наставлю, хто відгукується.
Я так розумію, що у нас є деякі нюанси все-таки з
I think we have
зі
some
з'єднанням, тому
connectivity problems. So, Mr. Serge, when you join us, please activate your mic and start speaking, and I will continue. While Tatiana was talking about the books and saying all these important things, I reread the chat and I saw a link to children with autism and autistic spectrum. How much is the approach different, or how much is the same book different when you work with children which are under the spectrum? Can one and the same book be the same, represented the same way to different children? And if this book needs someone who will explain about what this book is, or it's enough to just leave the child alone with this book? Yeah, we have Serge back. He wanted to ask some question. I keep your question in mind too. Yeah, of course. Probably I will be not very into your topic, but you spoke about the books which divide the children from war, protect them from war, about the parallel realities. But my personal opinion, I have nephews, the children who are my focus group at the moment, and openly speaking, I have relatives in Kharkiv, which is being constantly bombed. And no matter how much I like to read, and my nephews like to read, but when you are in Kharkiv, and when the all possible munition is flying over you, ruining your walls, not in a book, but physically, and at this moment, reading will not save you. So the question is here that parallel realities are very cool, but when you are not in Ukraine, because when you are in Ukraine and you are in these places which are being constantly shelled, it's very difficult to distance yourself from their reality, and especially it's valid for the children. I am now based in Lviv, but when my relatives come to me, they say that they have an opportunity to reload in Lviv. So we have to, according to my personal opinion, as a person who can influence to the current situation, I'm a volunteer. I attempt to help all the IDPs in Ukraine and abroad. And I think that what we need is not just to talk about books or something else, what to read, what to watch, but how to survive. And to shout about mediation in terms of having some settlement agreements between the countries. And the people are dying, the children are dying, unfortunately. And the essence is that we can publish extremely many books, smart, interesting, but with some time, there will be no one left to read these books. So it's nice to give us a very beautiful story about fantasy and other books. But as a founder of a team Polish band, we make songs about war, songs about war, and I know they are not very popular because some more dance music is much more on the air, even if they don't have any content in any sense in them. So, for example, if you say about quality literature will not will be read less, and it used to be read less, and now during the war also. And the same situation is with the music. Excuse me, I'm a guest. I was invited as a guest, and I'm asking for moderation. I think Mr. Serge just took the floor from me. If you have a question, please voice your question. If not, we will continue. We all have our own missions. Someone work in the medicine, someone in the literature, in education, and I think that we have only one common mission, it's peace. At this point, we are talking about mediation and literature. I think that this topic will be discussed further. Our task today is to talk about mediation in general in the literature as an educational instrument of mediation. Because if we talk, continuing your topic, literature in the bomb shelter, at some point when you're being shelled, you either don't need it or you need it as a therapy in a certain moment. So we are talking about education. We're talking about how to make this fiction raise as many topics, how to settle the conflict, how to live with the conflict with the least losses, how to leave the conflict, how to communicate, how to support communication. So I don't want our conversation now to become a fight or argument among us with the question what we need in literature. We all need peace, we all need victory, but not here. We are here about mediation in literature, so let's continue this topic. I have another hand raised, Pavlo. We can give you the floor, but in a couple of minutes I will ask the moderator. I will come back to our conversation with Mr. Tana with a question regarding children with special needs, with autism or autistic spectrum. If these children need someone, a mediator between themselves and a book, and adult who will explain what is it all about in the fiction, or if you can talk about some books which help them to understand topics without adults. Yeah, I want first of all to comment on the Serge, because his meaning is very, his opinion is very typical, and I want to answer you that literature is a safe instrument. I want to remind you again, I was speaking that we guarantee security of the kids, and this is point one. And we don't divide our children to the children who are abroad or who are here. They all need the same competencies. They all need the same support. Please be attentive to that. About the children with autistic spectrum, yeah, there is a golden rule in the children literature, and generally, not meaning, not depending on the age of this children. With teenagers, it's easier to work with them. But the golden
людина,
rule
коли,
is that an
коли
adult,
дитині щось їсти,
when you
вона завжди
offer
це
something
покуштує. Це
to your child
найголовніше
to
правило.
eat,
Так
you
само
will
і зі
try it.
змістом
This is the
стосується.
most
Жодна
important. The
стороння
same
людина,
thing
ні
is with
психолог,
the
ні педагог,
content.
ніхто не скаже
Not a
дитині,
single person
будь-якій дитині,
from the
будь-якого
side
рівня
psychologist or educator
інтелектуального,
or teacher
ментального і так
will
далі.
not say the
Не може
child
сказати замість батьків чи
uh,
замість тих, хто дбає про цю дитину,
will
замість
not give
опікунів,
better
що цій
advice
дитині
than
буде
the
краще. Тому
children,
та
which
книжка,
this
яка
particular
для
child
однієї дитини
needs.
буде
So
абсолютно
this
безпечна
book
і
can be
релевантна її
absolutely
досвіду
safe
життєвому,
and
так
relevant
само для
to the
іншої
experience of
дитини
this
може
particular child.
бути дуже
For
травматична або
a different
травматична.
child,
Ти на що
it
накидав
can be
панцир.
really
Тому
traumatizing or
передусім, коли ми
re-traumatizing.
пропонуємо
This was
дітям
the
будь-що,
hint of
ми,
Mr.
дорослі,
Serge.
несемо за них
So when we
відповідальність, маємо
suggest
це
something to our kids as adults, we are
проектувати через
responsible
себе.
for them,
От, і
and
це
we
перше.
have
Друге,
to let it
щодо
go
дітей
through
із спектром.
ourselves.
Це настільки велика
Children on the
різниця у сприйнятті
spectrum.
може бути,
It's
що
a
ми не
very
можемо
big
нічого
difference
спрогнозувати. Тобто
in
я
how
так само, як
they
людина
treat
з
the
меду,
world,
можу
how
сказати, що
they
ось цій дитині
understand
може
it.
бути одне.
So
Це перше.
I
Тому
cannot tell
обирати
you
літературу треба
exactly
обов'язково
who
із фахівцем,
and
який
what
супроводжує цю дитину.
exactly
Інша
needs.
справа
You,
дуже
in each
важлива, коли
particular
ми
case,
говоримо
talk
про
with a
інклюзивність
specialist, talk
літератури,
with a person who
про
is
те,
close to
як
this child
нашим дітям
and who knows the
загалом
child.
розповісти
So
про
in
дітей з
generally,
іншим
how to
типом
talk our
сприйняття, з іншими фізичними
children
можливостями і так
with
далі.
the
І я
different
хочу тут
physical
наголосити, що
abilities,
є
with the
дуже
different
багато уже
perception.
книжок на сьогоднішній день. За останні 2 роки
The
вони
issue of
почали
books.
виходити
Yeah,
більш
during the last 2
прицільно,
years,
які би
I
пояснювали, ми ж говоримо про
observing
медіацію,
some
про
new
інструментарій
books, and we're
додаємо
talking
іншим
about
дітям через
mediation, about
літературу.
the
Що таке
instruments,
інклюзивність, що таке безбар'єрність?
how
Чому
to explain the
раніше
children
ми,
through the
наприклад,
literature,
майже не
which
бачили ніколи
is
дорослих людей із
inclusion.
ампутаціями,
Some
зараз
children,
бачать,
they
як це
never
опозиція
saw
і
a
транслювати свою
person with an
реакцію або не
amputated
транслювати її.
limb,
Тобто
and
от
now they do
тема
see such persons
інклюзивності,
quite
тема
often. So
безбар'єрності зараз
the
теж є в дитячій
inclusion,
літературі. Вона
how
дуже важлива,
to
вона дуже на гіпервідповідальна,
underline
вона
it
є
in the
прямою. І
literature.
я би
It's
теж
also
радила
very
почати нам,
responsible,
дорослим, входити в цю
and
літературу, як здійснювати
it's
цю медіацію таких складних
really
питань, саме
challenging
теж
how
через
to do
дитячі
the
книжки.
mediation in this
От
complicated
нещодавно
issues
вийшла дуже
through the
класна книжка,
children's
художня
book.
для дітей
Recently,
молоджого
I have
віку,
seen a
видавництво
book
ранок,
for the young,
бестселер вийшов до моєї школи. Я дуже
young
раджу цю книжку. Вона якраз
teenagers,
поєднує і
and
хорошу
this
таку
book
динамічну
unites
сюжетну історію, в якій
a very
багатий,
dynamic
як ви
plot
розумієте, мається на увазі
where the
різноманітність дітей.
strange
І,
people,
власне, також
and
короткі
here they talk about
вплетення
various
інформації про це,
children,
тобто як
and then
це все
they
можна донести
explain
дітям.
why are they so special? Why are they so strange? Yeah, the book you've mentioned now, it's good because it's the first experience for many how to understand certain questions. And if we talk about mediation, about conflicts, this book can be the first experience when a child gets to know how to behave in a conflict ecologically, how to leave the conflict, how to continue your life after this big and important conflicts. So you have positive and negative heroes in this book. And I had a question: how to talk to the people, to the children about conflicts, how to show them who is good and who is bad, or what is bad and what is good. Maybe it has changed something. Maybe it's better not to use these adjectives when we interpret, when we translate, when we are trying to say something to our child to assess it as good or bad. Yeah, pedagogically, it's a very difficult question. The last trends in psychology and education, the modern writers, they have to stick to some certain modern views on pedagogics as well. 40 years ago, it was absolutely okay to beat your child slightly, but now it's absolutely unaccepted. Yeah, it's our nature, it's our new generation. The new generation is totally different from the previous generation. It was always like that, but we as adult generation react that these children are the children are different, and we have to treat them differently. When we talk about the good and the bad, we just mean it as general concepts about your views. And when you use an adjective, good or bad, we don't know what is behind the good and what is behind the bad. I don't want to get into too much details, but there is a concept arch of a hero. So this hero from the beginning can be treated by the reader that we treat him as a bad one. So we give him an assessment and evaluation, and we try to avoid these evaluations, because when the hero is getting to new circumstances, and then it turns out that he was just not aware enough, or how to explain children why some people are killing other people. How can we explain? We tell them just in my book, it's for primary school students. I call them you are the bad bad. And this is a subjective evaluation. When we step over their moral and ethical norms, it's unacceptable. When you lie in some minor situation, one child lies to another child, then we know the reasons, and someone needs to say sorry and to show on this example that that is incorrect to act like this, and then the child makes conclusions. Thank you for the answer, and have many questions in my head. Let's talk about the topics which are worth looking for those who are interested in mediation and conflict resolution, empathy, and those who create such books, the topics which were worth writing about in the modern books. You spoke about school, and I immediately thought about bullying. I think it's a modern and very massive routine which is happening at schools. When we talk about schools, yeah, bullying. Then when we have newcomers in our classes, when a newcomer comes, then the person is treated not very positively. Then friendship, and then relationships with the parents. It's also about conflicts and also searching for your own identity. For me, it is somehow everything connected to. Probably you can tell me about some other topics which you can see, and let's just touch each of these topics. Yeah, if we talk about a key topic, conflict, how to resolve the conflict, let's say at school, with friends, with parents, with siblings, we can cover a lot of circles now. But any book, any fiction for adults, for children, there is a conflict. Someone doesn't find mutual understanding with another one, and then they are looking for the instruments how to find this mutual understanding. And when we speak about the topics, everything which you've mentioned is they are all burning topics for each age group. On the other side, when we talk about age groups, for the little kids, for the preschool kids, this will be different. The format will be different, how we present these topics to them. We will talk to preschool children about conflict with the parents, about based on metaphor and comparison with animals, like a rabbit and a dog, and with all the children, we will already introduce the people and to compare it with the environment in which the child is living. The school, the newcomer, it's easier to believe to this story when the story is about a class in a Ukrainian school, in a lyceum, or but not in an American school or in some other foreign school. So we have to see if there is a division or not. We don't need this division. We need to give support to the kids, and they need to understand where they are, in which school they are, which parents this child has. That should be an identification of himself with the hero and with the environment. Also, it's important. I'm thinking now. Story is quite old. It's about 7 or 10 years old. It happened in the Ministry of Education. At that point, my project Live Writers was developing. And when I say the children need support, and today's writer writing about today and right here, right now, gives you more understanding of what's going on in the book and how we can project it to our own lives, and not to read like my parents used to read Nestaiko because they were of the same age, and they say now that my children need to read him as well. Now it doesn't work like this. You need to find some modern writers. Modern Ukrainian literature. We have a catalog of such literature, and it was a revolutionary one because alive people entered the school program. If you Google alive writers, you will find a lot of them on the web. So when the methodologists look at those topics of this catalog, they started to be really stressed because there was a topic about a divorce of the parents, and this methodology said, how dare you involve such a topic? You don't dare to touch such a topic with the children, because we are all so innocent and pink, and we don't dare that. Yeah, I say we dare to do that because with the help of the literature, we are creating the field of trust, and then we can continue explaining some complicated topics to the children. It's extremely important how to show the kids the world as a very various world, and the topics they are being ashamed of. Probably they lived through it in their life, and it stays for them a trigger, and they are afraid not to be impeccable. And this today's literature is very open to bring some information to the children, which was absolutely a taboo like 20 years ago. The people wouldn't even dare to discuss it in their kitchen. Yeah, I know a book from Larissa Denisenko. It's about the different types of families. They speak about the fact that you can have two mamas when you talk about sexual identity. So you can discuss this topic to less triggers, more freedom, and to define your own identity.
Як на інструмент і на сюжети також як на інструмент, теми, які там піднімаються, але ви гарно
Well, looking at books like at the tools, but it was really relevant to mention about the authors. If the publishers hear us, those who would like to read the topic and cover the book to cover the topics we've mentioned, could you give some tips, some advice to authors for this book to to really reflect current needs. And we speak about mediation, for example. Someone wants to write a book to highlight the topic of mediation in literature. What are some tips, some advice, some recommendations? How do you see the work with authors? Because much depends on the author.
Але для того, щоб книжка з'явилася в
Absolutely.
світі
But
як
to
така, то
bring
тут
the
дуже
book
багато
to
залежить від
life,
видавця.
much
Дійсно,
depends
видавці
on
у
the
нас
publisher
сьогодні
too.
ходять
And the
між книжками
publishers
і
today are
намагаються
running
дотриматися водночас
between the
комерційної
raindrops
складової,
because
тому
first they
що
have to
видавництва
look at the
встановлюють, що видячи цю
commercial
книжку на
component
продажу, от
because the
вона там
publishing
не
house
була
cannot survive if the
гостро
book is not
соціальною, та
purchased,
яку
no
би
matter
за
how
потребами
relevant topic
суспільства вона не
it
виконувала.
covers,
Якщо
no
видавець не
matter
може
what
змогти продати цю
society
книжку,
needs, it
ну то
meets.
книжка не стане
If the
явищем
publisher cannot
своєю
sell the book,
місією,
it
і
won't
видавцу
perform
просто
its
будуть гроші
mission,
на вітер.
and
Тому
the publishing house will
така
just
моя
waste its
порада
money.
авторам,
Well,
це,
so
якщо
my
ми говоримо
advice
за
to the
авторів дитячої
authors
підліткової книги,
would be
то
the
це
following: the authors about the
максимально
children's and
не то, що
teenage
тісний контакт
books.
з дітьми як такий. Я не про те,
They
що постійно
should
ходити там на уроки
establish
по
this
24 там декілька
close
24
contact with the
годин,
children.
але
I don't
постійний
mean to
моніторинг
attend
дійсно
school
течій
to observe the
діяльності,
children,
як вони
but they have to
відрізняються у
monitor the
контексті
children's
поколіннєвого
life, how they
взаємодії.
differ
І
among
тоді
this
буде
intergenerational
гарно видно,
communication.
от зараз ви часто
And
чуєте про
I can
письменників,
hear it quite often time
такі
now
думки.
from the authors.
У мене є одна колега, яка буквально
I have this
списує
colleague
за підлітками
who
сленг для того, щоб
just
її книжки, це дуже
records
відома
slang
дитяча
words.
підліткова письменниця, одна з найкращих
Listening to the
україномовних
teenagers,
письменниць.
she's one of my
І
favorite
вона
teenage
безумовно для
literature
того, щоб
authors.
бути
And to make
релевантною досить
relevant
підлітковою, а ми як
for
би ми
this
глибоко не
reality check,
занурюємося, ми все
no
одно інша
matter how
покоління.
deeply we
Вона
go
постійно
into the topic, we're still a different
включається в ту
generation.
хвилю, ті слова
So
вона
she
запам'ятовує.
steps
І
into
для них
this
актуально,
wave.
сьогодні
She
це актуально, бо
learns
знаєте,
the
те, що нам,
words
дорослим,
they use,
здається,
something is
от
relevant or
чітко
irrelevant
знати,
for
як
them.
робити
Because
паралелі
sometimes
з
grown-ups say,
у школі.
you have to be aware of
Іноді
what to
нам
do
хочеться
when
це
you're bullied
донести,
at
цей
school.
інструмент,
We
а
want to
дитина цю книжку
communicate that
просто
to
не
the
візьме
child,
і
but the
так.
child wouldn't
Тому
even
тут,
care about,
знову
wouldn't
ж
even
таки,
bother reading this book.
універсального правила не
So
існує.
there's not a silver
Є певний,
bullet here.
ну скажімо, гаразд.
No
Я про
one
власний досвід
fits
скажу,
all
як зробити
recipe
так, щоб
here. I
важлива
will
річ була
speak about my
сказана,
own
і щоб
experience, how to speak something important
реалізувало це
while the
завдання. Тому
publisher
просто видавництво
publishes my book.
приходило неодноразово і
Very
я там
often, a publishing
вивчити
house
цю тему
approached
для того,
me
щоб
to write a book on
я,
this
як
other
професійна
topic,
письменниця,
and me,
написала
as a
книгу.
professional
Ну,
author,
тобто,
was asked
так,
to
напевно,
write a book.
одні з останніх 3 моїх книжок виходили
These
саме
were
за
my 3 latest books that were published at the request of the publishing
Дякую.
house. Thank you.
Взагалі, як ви думаєте, чи можна
And
формувати
in your
культуру
opinion, can we
медіації
shape
не тільки
mediation
через
culture
автора,
not
а
only
й
through
через
through an
роботу,
author, but
наприклад, зі
also
школою,
through the
бібліотеками,
work
з
with
якимись
schools,
читацькими спільнотами,
libraries, some
читацькими клубами?
reading communities,
Бо
reading
тому що одна
clubs?
справа автору написати,
Because one
вибачте,
thing that the
вивірити
author
навики
writes
промоції
that
цієї
and the
книги,
publisher
але
promotes
ще
this book,
важливо, як ми між
but another
собою у
important
такому
thing is
звичайному
how
житті
we in our
допомагаємо
everyday
темі
life
розвиватися і як ми про
support this
неї
topic
говоримо.
to
Звісно, що в цих
in its
в
development, how
спільноті
we'll speak
медіаторів,
about it.
в навчанні
Of course,
медіаторів
when
можуть
in the
працювати
mediators
різні книги. Але
training
говоримо
and the
про
mediators
буденне
community,
звичайне
we can
життя.
look
Говоримо
at
про
these
школу.
books, but we speak
Що,
about this
як там?
everyday life. We speak about the
Дякую. Я, до
school
речі,
and
дуже
other
хотіла про це сказати,
education
щоб ці
area.
спікери, вони
Thank you
могли
very
потім
much.
сказати,
I
якщо ви до цього
forgot to
повернулись,
mention
саме
it
про
in my
проговорення
previous
книжки. Та, тому що
question.
одна
That's
справа, що ми
about the
там
discussion of the
бачимо цю
book.
книжку і да,
One
дуже
thing,
дякую за це слово
yeah, thank
насичена,
you
яка
for
саме про це
this
говорить. Одна справа,
concept
що ми
of shared
почитали, це
reading.
класна книжка, наче
Yeah,
так.
so that's one thing is,
Іноді
here you
якісь
go, that's a cool
смисли
book,
у серії
go
хороших
read it.
книжках, якісь смисли можуть
But
бути неочевидними.
some
Одна людина
senses
побачила
cannot
один
be not
важливий для себе
obvious in
сенс для
some books.
власного досвіду,
Someone
а
saw
дитина може побачити
one
щось зовсім інше.
important
Тому ми
essence,
розглядаємо
while
книгу
a child can see something
як
quite
точку
different.
входу в
So
розмову.
we can
Тобто,
see the
коли
book
ми
as the
далі,
entry
або коли
point
ми
to the
разом спільно читаємо разговоримо,
conversation.
по тій ж
When
читацькій
we have
спільноті
this shared
обговорюємо,
reading,
може
when we
виявити щось таке,
discuss books looks at the reading books, we can reveal the essence, the interpretation in the actions of the characters and the plot that the adults don't even see that. When we, I will give the example. what difficult conversation we can decide. For example, the peer committed to suicide. You cannot discuss it in your kitchen during the lunch. You cannot even figure out how to step into this conversation for the we don't want the child to shut down this topic, because how we can see the level of tension from the situation inside of the child. We take a book and offer it carefully. Or we say, "Oh, I've read this book." For example, this book, how one child's experience of their peers suicide, and we step by step carefully discuss this book. We can shape this algorithm and start this conversation. Well, if we speak about the questions, I would like, I've mentioned these guidelines of living authors. The first one is for the parents with a list of recommendations that cover various topics, and the living authors of how to speak with the children about the war and peace. And this project must engage the psychologist, and she helped us to shape this very careful questions regarding the mediation to discuss this or that difficult topic. What a question safe to ask from the child. I have not many things to say, not many optimistic things to say about school. I'm doing my best to change the approach to reading at schools per se, because we know that at school children do not do reading, they rather do history of literature. The literature at school does not echo the modern essences and the modern conversation. If we speak about the folklore, for example, back at school, we read these folk songs where this young lady is volunteers because she was dumped by her fiance. But things are very different now. Do not impose these patterns of gender interrelations, interaction that are 100 years old. So I cannot say anything about this shared reading deep essences at school. We I'm feel for the teachers now as the someone whose family are educators. The teacher now has to try to catch up with this curricula, following their calendar schedule, and the teachers do not have time to delve deep into multidimensional detail of plots in the literature piece. So I rely on the parents who wouldn't expect much from this one book that the child will get down the reading, but at least you can take your child or your teenager to a bookshop and let them buy whatever book they prefer. I had this experience, and it was educational for me. I have three daughters, and I suggested that she can pick any book at the bookstore, and she picked one, something with glitter, something not of high quality and highly intellectual. And then I said, okay, stop. This is just the first step. If the child could pick a book independently, it shapes her behavior to pick, and it can develop the taste to reading. This bar where keeping high, this is the bar of internal development that will never go high if you didn't have a chance to develop it, to bringing up step by step. We have so many questions, they emerge one from another. I have so many questions. I'm trying to be concise. So the question is the following. It's about the methods. Many experts, including Barabuka experts and Ministry of Education, say this joint reading is so important. And they say just stop reading to discuss certain moments. They also promote drawing the emotions to exchange this impression. What other tools, what other methods are going to be efficient that promote the values of communication, empathy? What could be instrumental here?
Обговорювання це на сьогодні, на
Discussion
сьогоднішній день найпростіший
is
варіант,
the
тому що якщо ви
simplest
навпаки проговорювати чи
method
щось вигадувати,
because you don't need to reinvent
треба спершу це
a wheel.
навчити, скажімо
You
так. Коли
just go through this
тут
stage
якраз
first.
більше впиратиметься в те,
And
які
here,
питання для цієї розмови, для цієї
you first have
дискусії,
to
які
look
запитання
at the
ставити, от
questions for this
так
entry point. This is
як говорила
more
тільки пані
difficult.
От, коли мова йде про
When we speak about
питання оцінки, так, коли ми про
this,
емпатію
when we speak about empathy, how we can respond to these other stories, this could be just no judgment, no moralization, because the children detects that, spot that very clearly when an adult tries to achieve push the agenda. So the main rule, don't try to achieve something with this one conversation, because the child can figure that out. So, okay, the moral behind this story is the following, and my family wants to hear that I judge, that I disagree with this or that character. Don't give this opportunity for the child to escape this conversation. You better ask some innocent questions, like ping pong. What's your opinion on that? And how would you behave in this situation? And how the situation could unroll in a different way? And share your own experience, because each story in a child's or teenage book somehow relates to our adult experience. And going back to shared reading, there are certain restrictions in terms of the age, because when a child, in inverted commas, over the age of 14, you cannot do this shared reading. So, first of all, you have to read this book by your own, and anyway, you will see the question you want to ask in the context of this book to your child. I emphasize only a very close person knows the context of this child, no matter how genius educator you have next to you. Even they may fail to initiate this important conversation because they don't know the background of this child. I also thought about this abstract, the summary of this book, because we look at this first page to find out what this book is about. Sometimes we have this scarce description of the plot, and they have this some anchors for catch our attention. And I believe that it's very difficult for the parents to see what is there in that book and the dimension of conflict and mediation. Of course, if they mention the word bullying or school, the parents be like, yeah, I'm going to buy this book because for my child of the age 10, 15, 17, it's going to be relevant. So this summary, this abstract is often problematic. If I'm asked what book is about conflicts or emotions, I can think about emotion ABC. So I believe these annotations, this abstract, quite problematic, and how competent we are in this topic. So my suggestion is that someone should include a tip, this hint, what this topic is about, that it will refer to higher empathy level, communication. So I would like us to bring more attention to the emotional area to improve communication skills. And what does children's Ukrainian literature miss in terms of dialogue, empathy, reconciliation?
Я вже про смішне сказала, та
I've
якраз
mentioned
хочеться,
humor,
звісно, якщо
and
беремо саме цей контекст,
if we look at
емпатію
this
і
context
спілкування,
about
то
empathy and
дійсно бракує
communication,
сміливості видавців
the publishers
розширювати
don't have enough
лінію
courage
оповідань на
to
складні теми.
expand the
Тому що
line
саме на
of
складні
books
теми, те, що ми
on
вже
difficult
говорили,
topics.
наприклад, там
Something we've mentioned.
ну, про розлучення говорили, гаразд,
For example,
те, що
divorces,
називається,
or
я це беру
something that I
латиною,
put that in
сексуальна
inverted
орієнтація.
commas,
Це
the
такі теми, які дуже
non-traditional
важко знайти
sexual
розуміння, знайти, знову
orientation.
ж таки, точку
It's very
погляду з
difficult to
дітьми.
find the entry
І
points in the
ці
conversation
видання,
with the
якщо вони
children.
вивірені
And
психологічно,
if
необ'ятливі з
these
моєї точки зору, якщо вони не
books do not
моралізують, а
impose any
показують, що є,
viewpoint, that it do
для
not
того, щоб
moralize, do not
діти
judge,
побачили
but
цей
rather
світ і
show
всі його
the
багатогранності, зробили
variety,
самостійний вибір
that this
у цій
world has many
багатогранності, бо таких видань у
dimensions,
нас
has
бракує,
the
тому що
variety.
їх дуже важко
We're
продати,
missing
і
these
тому
books
що
because
їх
it's
дуже
very
важко
difficult to
читати
sell them,
насправді.
and it's very difficult to
Є
read them.
книжка, або знову ж таки,
There
коли
is
ми
that
там
book.
говоримо про
When we
дітей,
speak
які вживають наркотики,
about them,
теж дуже важко про це
children abusing
говорити.
substances,
Можу
it's very
порадити
difficult to
книжку
speak about that. I can give the
Наді Білої.
I can
Ця книжка, вона
advise
одна з найяскравіших
to
підліткових
read
видань, які
the book,
говорять на
which
тему,
is
коли
one of the
вживають
acute
діти
ones
вживають алкоголь,
about this
наркотики, потрапляють у дуже
alcohol
складні
and substance
ситуації
abuse. They
насильства.
find themselves in a
Як
very,
подати
very
це
difficult
іншому?
situation of
Напише в
violence.
анотації
How to sell this
видавець,
book?
що
The
про
publisher
це
is
ця книжка.
going to
Натяками
describe this
напряму.
abstract
По-перше,
without
всі дорослі
some
зразу злякаються.
hints,
Нащо
but
ти таке
directly, and that
несеш
adults will be
взагалі?
intimidated.
Нащо
Okay,
я не
I do
буду
not, I
дитині
generalize.
свої таке
I'm not
далі
going
читати,
to buy
наприклад, це
this book for
страшно
my
і погано,
child
і
because the world is so
словом,
scary and we live in
це
a very
про,
terrifying
напевно,
context.
загальну культуру,
And that's probably
чи
about this
традицію, точніше, не так,
general
культуру,
culture,
традицію,
maybe not
сприймати
culture so much,
книжку
but the
як
tradition to
такого
perceive a book
помічника, та?
as an
Помічника,
assistant
який, можливо,
that
скажімо так, розкриє, що це є
will
проблемою. І для
expose
того, щоб про
this
проблему почати
problem.
говорити, її
Because
потрібно
to start
винести
to
на
speak
світло.
about the problem,
А в
you have
нас
to bring it
книжки
up
не
to the
так
light.
сміливо
And the books
виносять
are
на
not
світло
so
складні
brave
проблеми,
in
як, наприклад, про
exposing the
світ. Ми
difficult
в цьому сенсі
problems
відстаємо
like
дуже багато.
we have
Це
it around the
погодьтесь,
world. We're trailing
розумієте?
behind
За
in
винятком
those
однієї
terms
теми. За винятком, на жаль,
in
хотілося б, щоб ми
literature,
і тут відставали,
apart
але,
from
на жаль,
one
ні.
topic,
За винятком теми, як говорити з дітьми про
about
війну. Тут ми
speaking
ведемо
about the
проект, тому
topic
що
of
ми,
speaking
на
about
жаль, ми,
with
власне,
children
вже
about
самі
the war.
навчилися про це
There we
говорити.
are on the front line
Нещодавно
because from our own experience
приїжджали
learn how to speak
експерти
about
із
that.
Інституту дитячої
We were
психології
visited recently
інституту, і
from
вони
the
брали
Norway
участь у
Institute of
фахівців,
Children's
інтерв'ю
Literature, and they interviewed
про
us,
те,
the
як їм
Ukrainian specialists,
приготуватися
on how
перед
they shall
літературу говорити
prepare
з дітьми про
to
війну.
speak
Тобто
about the war
це
through
не
the
той
literature with the
передовий
children.
досвід, який
It's
би
not the
хотілося привнести у світ,
pioneer
але от
experience we would like to share with the
Я
world,
коли
but this
сказала
is
про
what we have.
анотацію, це теж
When I've mentioned
власне
about this
почуття, як
shaping the
мама
abstract
підлітка,
summary, I
яка
spoke from the
намагається
position of
структурувати
the
книгочитання,
teenage mother.
дуже
I
багато
try
чого
to
оприлюднить.
promote
Він
reading,
відкриває,
to speak
починає
about
читати,
the
каже:
books.
ну тут немає
And
ніяких проблем,
my
насильства.
son
Значить,
opens
якось
this
вигаданої
abstract. They
історії,
say,
він
this is
не
like
контексту. Тому, власне, оце
nothing specific
про те,
here.
що
I'm not
анотацію
interested in
хотілося
this
бути
topic.
початковою,
What
власне,
we
щоб
would like to
якщо
have
є
this
якась проблема, наприклад,
abstract
там
summary
розлучається
more
сім'я, то дійсно
exciting. For
відкриваєш
example, if
анотацію,
you have
починаєш
this
читати,
problem
що
of a
це
divorced family,
історія
for
про
example,
розлучення батьків,
and
і
it
про те,
says
як
this is a story
дитина
about
в
the
тому всьому живе.
divorce in the family,
Але,
how the
звісно, це
child
не для всіх, я би
survives it.
сказала,
But it's not
побажання.
for
І так як
everyone.
ми
That's rather
на широку
a wish.
публіку
And since we speak to a
теж
wide
людей, які мають
audience
стосунок до медіації, до
who
юриспруденції, мені хотілося теж
deal
такий
with
меседж
mediation
послати,
and
що якщо у
legal
вас є ідеї, є
profession,
історії, є
my
кейси,
message is the following. If you have the cases, if you have ideas that you would like to fulfill through fiction, do not hesitate to not shy away from approaching authors
саме оці, як пані
of
Тетяна сказала,
fiction.
реальні історії,
And
а не те, що було десь там колись
it's
і
more
зроблено настільки
fascinating
цікаво
to look
сучасним
at the
часом. Тому
real
ці реальні історії
stories,
тут і тепер
and we can use
переказували і за
them,
допомогою
we can
книг
retell
доносили
them and
до
communicate
людей.
them
І
with a
в мене ще
book.
така зараз прям картинка намалювалась.
And I
Мені
have
би дуже
this
хотілося,
image in front of
щоб
my
у,
eyes.
наприклад,
I
кабінеті
would
прокурора,
really
в
like
кабінеті
that in the
юриста або в
cabinet of
кабінеті
legal aid,
медіатора
of
чи іншої
mediate, of a
людини з цієї
psychologist, or
сфери була
some
така
other people
поличка, книжкова
have this
поличка, де були би
bookshelf,
зібрані
and it would hold
книжки, художня література,
the
яка
fiction
би
books
стосувалася їхньої роботи.
that
От
relates to
є
their
запит,
work.
і людина
There
знає,
is
що
a
можна, наприклад,
request, there is a
порадити. Та, бо,
need, and
можливо,
the specialist
впаде
can advise
око
something, recommend something, or the
клієнта
client
на
can just
книжку якусь, і
catch
потім запитає. Дуже
the
хотілося, щоб
title of the
от аби
book, and they may
поєднати ці
wonder
ще я
about
сказала
that.
на початку,
So this is
поєднати два
something I
слова
said at the beginning.
література
We
і
would like
медіація.
to
От, власне,
bring
мені здається, що не тільки через
in
спеціалістів, не тільки
the
через те, що ми
literature
можемо
and
про це більше
mediation
говорити,
and integrate
писати про
them.
це.
We
Ми
have
маємо
to
створювати
write
візуал,
more
власне,
about
ці
that. We have
книжки,
to
які
also
вже
create
є
this visual
на ці теми
component.
і
The
які
books we
стоять
already
у
have
кабінетах.
on this
Я зараз
topic,
би
and that
хотіла,
would
щоб
find
ми
a
дали
place on the
слово
shelf
тим,
in the rooms,
хто
in the
мав
offices.
свої
I would like
запитання,
to give the
бо
floor
до
to
нас вже
someone who
час все ж
had
таки
their
дати
questions.
відповіді.
Let's
Можливо,
spare
хтось у
some
нас буде
time for
зараз
question
переглянути
and
чат, їх дуже
answers. Let
багато.
me look through the chat. We have
Так,
lots of
неймовірна цінна
comments
думка,
there.
що книжка є
That's a
точкою
very
входу в
valuable
розмову із дитиною.
idea that book
Добре.
is an entry point to the
Дякую за
conversation
те,
with
що
the
ви
child.
коментуєте.
Thank you for the
Просимо
comments,
ставити
and
запитання, якщо у вас такі є.
please
Можете
ask
в
questions
чаті
if you
або
if you have
можете
any.
через підняту
You may
долоньку.
raise your
Мені
hand,
здається,
you
що
can type
за
them on the
годину часу
chat.
ми не
I
можемо
believe that
встигнути
during 1 hour we cannot
і розповісти про все, що можна
speak
говорити в літературі про
about
медіацію,
everything that
про
literature may
врегулювання
cover:
конфліктів
mediation,
і
conflict
спорів.
resolution,
Проте
and dispute
ми
resolution.
зачепили, ми вже
And
говоримо
yet
на цю
we
тему, це дуже
touched
важливо.
the
І
base,
якщо все-таки
and
говорити про
it's
літературу,
really
яка не
important.
художня,
And
до
if we
речі, я
speak
от
about
гуглила спеціально
nonfiction,
і знайшла
I
книжку
googled and
про
found
конфлікти і
the book
вирішення.
about conflict
Це як
and
вмію
its
управляти
resolution.
конфліктами.
I can
І це якраз та
manage
книжка
conflict.
не художня, але
And
вона
it's a
досить
non-fiction book, but
хороша.
it's
Чому хороша? Тому що це
it's
для
a good
діток
one
3, ні, не 3,
because
5-8
the
років,
target
але
audience is
вона
5 to
зроблена таким
8
чином,
years.
що
It
там
is
демплейки,
written
там
in the
прості,
way that it has
зрозумілі
stickers.
картинки,
It has
прості, зрозумілі
simple
пояснення. І,
and
власне,
clear
завдяки цим
explanations
наліпкам
and images.
можна
And thanks to the
відразу з дитиною
stickers,
працювати,
you can work
обговорювати, і таким
with the
чином,
child, discuss
якби
some
дитина доторкається
important
до
topics,
того,
and it
про що
helps
ми
the
з вами
child
сьогодні говоримо.
to look at the
Отож,
topics we discussed today.
запитання,
So,
якщо
your
є.
questions, if you have any.
Я намагаюся пройтися по тих запитаннях,
I'm
які в
trying
мене
to
ще були, але мені
look at the
здається, що
questions
ми майже
I
їх
have.
всі обговорили, щоб не було повторення.
And
До
just not
речі,
to repeat them.
тему ще про
By the
одну із
way,
тем. Ми проговорили про дружбу, і мені
we
здається, що
mentioned
забули про
friendship,
говорити про теми, які
but
добре
we
було
didn't
би
mention
піднімати в
the
художній
topics that would be good
літературі, і
to
яка
speak
стосується
about in
конфліктів.
the
Це ж
fiction,
тема
and this is
підліткового кохання,
the
першого
teenage
кохання, і,
love,
звісно,
this
тема
first love
ревнощів,
and
які
jealousy
виникають якраз тут.
that emerge within
Доволі
this
багато
context.
є такої літератури, таких історій.
I believe
Тому,
there are
якщо ви теж, можливо,
many
знаєте якісь
stories
книжки,
like that,
то ви теж можете
many
написати.
literature like that. Do you know any? Yes, I can recommend some because I mentioned this author. It's books by Olga Kupriyan. She published the series of that called Little Miss. And there is a wide range of such stories for teenagers, young adults. This is the first love and the newcomer, and living displacement because of the events in Ukraine and coming back, relationship with the parents, jealousy. Yes, and the bullying topic is very important. And my suggestion here, my recommendation here is Anastasia Melnichenko materials. She is also the expert
не скажу в якому закладі, але вона одна в Україні, я вважаю,
in
найсильніших
I
фахівчинь
believe
з
she
протидії
one of
булінгу.
the
В неї дуже багато
key
інформації.
counter-bullying specialists in Ukraine. She has lots of information, lots of analytics. She has her methodology. She writes fiction. Anastasia Melnichenko. And also recalled one book on the first love, about the conflicts of this age, and recalled Ludmila Kolb. And the title of the book is The Appeal, this attraction, about this sexual appeal, soul to soul attraction. That's quite a good book. You can offer it as a quality reading to your children. Miss Tatiana, can you share certain life hacks? Take how to make children love reading. I believe many parents struggle with this question. Very few modern children who are passionate about reading and spend most of their time reading. I will be happy to hear your recommendations too. I do use some life hacks, but I would like to promote reading at home. Thank you for this question. Well, if the adult asks about it, it means nothing is lost. It's very important to hear this question. I actually gave my fundamental recommendation. Just take a child to a bookstore. Do not say, okay, we have this serious visit to a bookstore for some serious intervention. I'll just make it chill and easy. You went shopping, and almost all malls have bookstores. You can also go to online bookstore, but give your child a chance to pick a book themselves. Well, I mentioned my younger girl. I believed she is my biggest non-reader, but it turned out that situation is quite different. All the trends show that young teenagers love mangas. The less text, more pictures. This is the children's book that there are just few lines of words, but those children that are grown up still need this format. But now they do not care about much text, but they need to make it more complex, not about this rabbit and fox. Now, when she can pick her books independently, she goes for that mangas and not restrict her, have this opportunity. I realize that not all parents can afford that, but still the books are much cheaper in Ukraine than around the world. And the first life hack, just let them pick books independently. The second one is having books at home. If you don't have books at home, I realize that parents don't have time to read, but the books can still be around, and the child and our teenager just sees that this grown-up person buys books from time to time and bring them home. So the book as a phenomenon becomes something casual. They won't be confusing. Why do you have these books over here? When a book at home becomes a routine, that's another step to promoting reading. And another thing is that adults also read. When your child sees you reading a book instead of scrolling your feed, it's a very important incentive. But I keep recommending you don't do not enforce reading on your child, because this resistance, because you will see this resistance to this pressure, especially among teenagers. So do not be so straightforward. Do not enforce that on your child. That then it's not the way to promote reading if they cannot be seen as violence against them. And I can see this idea. Maybe someone will see that as recommendation. I say, okay, look, and this book has the story, and the character has a pet, and the cat pet. So through this favorite character, through a pet, character's pet, from the very young age, they get engaged. And even that's just story for adults, and I mentioned that they have this red cat, and they get interested in that. I have the family, their children love Minecraft. There is the entire series of books there. Just look at the children's interest as dinosaurs, cats, and just share a book on this topic. Do you have experience how to promote shared reading for the child with special educational needs and this regular child? That's all individual. There is no one fits all solution. I would like to say that everything is possible, but without knowing the level of reading experience, I unfortunately cannot comment that. Much depends on the adult who organizes that. If you are inspired and you have a small hope that you can do that, go for it, try it, because
Так, у нас тут є ще про
it can work.
рекомендувати фахові джерела. Ну, я так розумію, цим джерелом може бути
To my
Барабука
understanding,
сама,
the source
якби
can
чим
be
можливо
either
нас
Barabuka itself or
трошки направлять в цьому запитанні.
can you give us some directions, please? Yeah, I can join you here. Our participants who yearly join our forum, they know that we prepare materials for the participants. We collect recommendation from speakers, recommendations from chat. So of course we will get all these materials together. You will get them on our website, but taking into consideration the length of the forum, we have more than 100 speakers. So give us some time, please. We will systemize this information, put it in place. Yeah. I think that we've missed one more question. The question was, yeah, I think we thought from the beginning that 90 minutes will be too much, but you see the people won't let you go. Yeah, I also see the question. How do you think can sometimes the thoughts of the author be incorrect, and if someone is checking the books before they're being published? Yeah, to my personal opinion, yes. Their opinions are sometimes incorrect. That's why I say before you give your child a book, read it yourself, check it. Sometimes the publishers say, yeah, you can sell this book so well, they are so popular, but I see there are some unethical stories. You by no means have to give it to your children. Also, the legal aspects. In 2022 in spring, we had a very loud incident when one famous publishing house just printed in, thanks God in Ukraine, they didn't manage to do that, because all the professional community was shocked, but they left Ukraine at this point. They worked abroad, but they printed a book with the real stories who died during the beginning of the full-scale invasion, with the real names of these kids and with mentioning their wounds and their injuries. It was impossible to work in either psychological or also legal field. That would be absolutely unacceptable. Yeah, unfortunately it happens. Can we secure us from it? No. But how not to get into this trap? Yeah, you go to those publishing houses which you trust. They are the most famous. They have reputation. They would never put their reputation under such risk, publishing some strange stories, which can be quite ambiguous for the readers. And yeah, the last question, whether whether the conflict is covered in the books. Yeah, there is a very famous Ukrainian writer. He's a modern one, and he's very popular, Sashko Dermansky. I hope you've heard about him, and he has very special humor. It's quite open. And one of his stories, his parents are eating kebab in a couple of words. It's just the background. It's not the base of the story of the plot that they are eating this kebab. And these parents come because we're talking about the paradigm of the past and the present. So these parents came and said, like traditional parents, they say, sometimes they criticize this Sashko Dermansky. They say, what did he smoke before he created this story? And it caused really huge amount of hate to him, because at that point we say, yeah, with your child you can do it. There are specialists who analyze it, and you have to take into consideration when you print or publish such book and give it to the children. So it's very important. And you ask also who controls that, who controls the text and the narratives in the children's and teenagers literature. Before the war, they were only editors and proofreaders, and now it's written on the book that there was a supervision of a psychologist. It's especially important when you talk about these triggering topics, about these complicated polyphonical topics, when for one person it's not triggering, for another person or for another family it can be extremely traumatizing. You spoke about a lot about publishing houses, but let's underline that the last 5 years also self-publishing is very popular. So the author can come to any printing house, not even a publishing house, and to print his books, sometimes in hundreds or sometimes even thousands of examples. I'm being an author myself, and I know about the situation. A lot depends on the context on the author. When the author comes to the printing house, then he covers the costs for printing himself, and the point of checking, of controlling how fair it is. There is no check, and it's very important how critical the author to himself is. And for me, it's important to have a better reader when it's a book for child or for teenagers. I will get this better reader from this age group. I will get feedbacks from them, and yeah, just pay attention to the officially published books by official publishing houses. When we speak about mediation and conflicts, that yeah, or you can also go to some books presentations to meet the authors, to hear from the author. And also there was a comment about mobbing in the chat. We didn't touch this topic, but I think that around yeah, we can meet it only in our teenage literature, because our teenagers from 15, they are already allowed to work, and probably Mr. Tannen knows the exact book which covers this topic, or probably our participants know this book. I don't have it on my mind. Yeah, when we talk about the teenagers, I can't remember anything like bullying, when sometimes we talk about working teenagers, and his, of course, relationship with his employer will be managed by the adults. Also, there is a question about the books which were endorsed by the Ministry of Education and Science, non-fiction books and educational books. Yeah, educational books which are getting to the schools directly. And when we talk about children's reading, we speak about the books which are being sold in the bookshops. So if it's endorsed by the Ministry of Education and Science, whether it is a sign of quality, I would say not always. And one more question we missed, it will probably be the last, if the conflict between teacher and student being revealed in the children's literature, yeah. This is 14 years plus. I would say I also, as an editor, had such a book, such a story. I started to read it, and it wasn't published finally, because it was so negative. This description of the teacher was so negative that when a child reads this book, and the child needs to be in contact, constant contact and long contact with the teacher, it would just set up the mind of this child completely against teachers. So the decision was taken not to publish this book, because this responsibility in children's literature, there will be always light at the end of the tunnel. The end should be always positive. And in this story, it was absolutely disappointment. Yeah, we are not always happy with our teachers. Not everyone is lucky to get only perfect teachers. And then you also read this book and you add some petrol to the fire. Yeah, I can't tell you now, and I can't remember about any book on this topic at the moment. Yeah, I think that we can finish now, finish this huge topic which we have been discussing today. Of course, to say finish is too much. We just began to speak about it. We just slightly touched the topic. We were speaking about this not obvious partnership between mediation and literature. We spoke about certain books which describe conflicts, misunderstanding, and we spoke about how to behave in a dialogue, what to do if you have certain problems. We covered topics which exist now in the modern literature. I want to remind you that you can address the writers if you have some ideas to tell them about your ideas, that we will create something helpful together for the kids. And it will be important that the book coincides with the reality, with our current life, with our war experiences, which we are living through with our children. My name is Irina Rudika. I was with you today in Tatiana Stus. If you need more advice or sources, we will provide you with all this information. Thank you for your activities, for your likes, for your questions. We hope that this information was not just interesting for you, but also useful, and you will share your experiences about our meeting with your friends. Yeah, I'm also very grateful for your activity. It was a big pleasure to see your faces. Quite often people don't have their videos on, but it was a pleasure to share my experience with you. Thanks a lot.
Пані Тетяно, я просто спостерігаю за вашим сердечком.
I'm just
Хочу показати
observing
наше
your
сердечко,
heart,
на
and I
ньому
want you
написано
to show
медіація, з
our
медіацією в
heart.
серці. І от знаєте,
It's
про те,
written
як ви
mediation
відчували
in
сьогодні.
heart.
На одній
There,
хвилі бачу у Ірини
and
теж серденько.
I see that Irina has a heart too. Great, thank you. I always say this is my working instrument from 2020 when COVID came in and we started to see each other only at the screen. So yeah, I'm very happy to be synchronized with you.
Я хотіла ще подякувати пані
I
Ірині за
also
цю
wanted
прекрасну
to say thank you
ідею
to Ms. Irina for this great idea.
ролі спікерки
And
сьогодні, тому що ми початково, коли
you as a
розмовляли
speaker
про
today,
те, як
Tatiana, you were
зорганізувати
suggested to
цю
us
власне
by Ms. Irina.
панельну дискусію. Ми
And
думали про все ж таки
I was
літературу
thinking,
для дорослих,
first of
яким
all,
чином
about
через
literature for
літературу,
adults
через
and
літературу
how
подати тему медіації,
we can
а
present
потім, власне,
mediation through literature.
згадався
And
наш
then
досвід
we
з
thought about our
проведенням
experience
уроків
of
миру та
lessons
справедливості. Це, власне,
of
ті уроки,
peace and
які
fairness, the
проводила
lessons
Українська
which
академія медіації в співпраці
Ukrainian
з
Academy of Mediation
медіаторами,
conducted in
суддями,
cooperation with the
юристами.
mediators, judges,
І ми
lawyers,
також
and
співпрацюємо із
also we
Службою
cooperate
освітньої безпеки Національної
with
поліції і
the National Police Educational Security Service
Ну, власне,
and with the
багато
Educational
власне суб'єктів
Self-Governance
залучені в цю ініціативу.
Service.
І
So
от,
a lot of
знаєте,
stakeholders are involved into this
періодично так
initiative.
виникає,
And I
що
constantly get this feeling
через дітей
that through the
доносимо
children,
дорослим
we
інформацію
bring
про
the
медіацію. Тому що
information
так
about
цікаво, коли
mediation to the
викладачі нам
adults.
розповідають, як у них там
When the
це відбувається в діточок, і як
moderator tells us
вони говорять
about
про те, що
the
а
feedback
потім
from the
нам
children,
викладачі, вчителі передають
and when
інформацію, що
they say, yeah, our
батьки
teachers
питають у них, а що це за
pass the
медіація така, що
information
це
to
моя
us,
дитина
and then
принесла
the
якусь історію про
adults
медіацію.
ask, what is
Що ви там
mediation? My
робили?
child
Ну,
comes
от.
back
І
home
таким чином
and speaks about
зацікавились
mediation.
через
What
дітей
exactly
і
did you
ідеї
do?
для
So this
дорослих. Тому що коли ми говоримо про,
fact
знаєте,
that the
поширення
adults are
інформації про
starting
медіацію,
to
ми
be
більшою мірою все
keen
одно
uh,
дивимось на дорослу
through their
аудиторію. І
children.
це
Yeah, this
надзвичайно
is
цінно, що
really
ми через більшу
amazing and
призму
very
подивилися цю
valuable.
тематику. І я сподіваюся, що це, як
I hope that,
влучно Ірина зазначила, знаєте, початок такої
as Irina said, that will be the
розмови
beginning of a
на широку
conversation
аудиторію. І пані
for
Тетяно,
the
ви
big
влучно
audience.
цю от
And
ідею
Ms.
вхопили
Tatiana,
про
this
дотик
idea
інформаційних бульбашок. Я прямо ж, в мене серденько
about the
затьохкало,
touch
коли
of
ви на початку про це
informational
сказали. Думаю, ой,
bubbles
все, це точно меч
was
час.
very impressive for me.
Дякую вам дуже за це.
Thank you.
Книжка
Thanks a lot.
інструмент, і цей інструмент може допомогти
Yeah,
і
the book is an instrument, and this
медіаційній
instrument
бульбашці. Тому
can help
ми
the
завжди
mediation
раді.
bubble. So we
Література
are
завжди
always
рада.
happy.
Тому
The literature is always happy.
Здається, техніка у Іри не витримала вже, так? Добре.
Тот зв'язок, який зник, але дав довести до
Та-та-та.
кінця цю подію.
The connection is with Irina is gone, but I think that we have heard everything what we were supposed to discuss. Thanks a lot, Ms. Tatiana, all our participants. In 20 minutes, we will have the next panel discussion. Please join us and follow us on social media. We will move ahead through our forum. It's only the first day today. The more will follow. help, but it's a huge pleasure that we can greet you today at our forum with this extremely important topic. And Odessa's forum, it couldn't happen without your issue, the maritime disputes issue. It's not just mediation, also other opportunities to use for this kind of dispute resolution. I know that you are extremely experienced. Yuri is the head of the UA Maritime Law Committee. He's an arbitrator. He's the managing partner of UMAC committee, and he's the head of Sergeyev's law office. Today is the World Oceans Day, and the floor is yours. I'm extremely curious to listen to your panel to see how the disputes could be resolved and which practice exists worldwide. Thanks a lot to Luisa, to Ukrainian Academy of Mediation, for the suggestion to conduct this panel during this World Ocean Day. The topic is arbitration, mediation, or hybrid modern approaches to resolving maritime disputes. And our respected guests, I will briefly introduce them, and then we'll tell you again in more details who our respectful speakers are. George Lambrou, he's an international dispute resolution specialist. He's an attorney and arbitrator and International Arbitration Council. I will talk about George in more details later. Jonathan Lutz is an international commercial mediator, arbitrator, and barrister accredited by the International Mediation Institute and the Civil Mediation Council. Thank you, Jonathan. Professor Andrea Lista, professor of maritime and commercial law, director of the Institute of Maritime Law, legal counsel of Southampton University, and also our colleague, lawyer, and advisor, Andrea. Nice to see you. And we also have among the speakers, Karina Horova, arbitrator of the International Commercial Arbitrage Court at the Ukrainian Chamber of Commerce and Industry, partner at Interlegal. Thank you, Karina. And again, I want to say that we had a common presentation together with Mykola Melnikov, partner at Interlegal and also deputy chairman and arbitrator of the maritime arbitration. And Mykola is now fighting against the aggressor. He is at war, and unfortunately, he will not be able to join us today because he's performing his military duties right now. That's why I suggest that our colleagues, you please stick to our agenda. We discussed it with you. If you need technical support, please don't hesitate. We will show your presentation, we'll demonstrate the slides and help you by all means. Dear participants, let's start. Let's start today from a very interesting presentation of George Lambrou. It is called Modern Trends in the Maritime Arbitration. George is a very famous solicitor of England and Wales, arbitrator, and he's densely connected with maritime disputes, maritime arbitration. He represents the parties. He is either the head of the arbitration committee or an arbitrator himself, and he has a huge experience of participation in arbitration conducted in London, Athens, Istanbul. So the main cities in our arbitration sphere. Professional practice of Mr. Lambrou is very broadly represented in the maritime law, and of course, maritime arbitration is an important part of this. Before he joined Keystone Law in 2018, he was a partner of Thomas Cooper London law firm, and he is famous also for his work with the maritime disputes. He is also a co-director of education, Chartered Institute of Arbitration. He is a member of London Maritime Arbitration Association, has a lot of other titles. It's too long and we are limited in time, so I will not read it further, but you can Google it. George, the floor is yours. Please feel free. And I wish you fruitful work during our session. Thank you for agreeing to present today.
Thank you very much, Yuri, for that very kind and generous introduction. First of all, I want to thank you because if it wasn't for you in organizing this session, it's very, very difficult to organize these things. And I'm very, very grateful for all of your hard work and diligence in getting this great team together. It's wonderful to share the tribunal with old colleagues and friends. And I'm thankful for the opportunity. One thing I just wanted to ask about the slides. Now, will the slides be shown by the organizers? Yeah, okay. So we could start with the first slide then. And then the next slide, thank you. So before we talk about current trends, I thought it was important to give a little bit of a background of sort of big picture, start with the big picture. How do people around the world generally settle maritime disputes? And it's an oddity because maritime disputes take place clearly all over the world. This is an international business between international parties. They have disputes of all sorts taking place all over the world. So you would think that there would be many, many different places around the world where maritime disputes are resolved. But in fact, for historical reasons, the vast majority, I've heard figures of almost 90% of maritime arbitrations take place in London under the rules and terms of the London Maritime Arbitrators Association. So this is the context. And when we talk about maritime arbitration, because of the huge numbers taking place in London, this is why the emphasis is placed there. In 2025, the most recent statistics, there were an incredible 3,469 appointments, and these are estimated. Probably the numbers are higher than this. And for about 2,015 arbitration references, that's in 1 year. And out of those, the arbitrators made a total of 563 awards, of which 83 were made after an oral hearing. Now, let's compare that to references in other institutions or other centers around the world. If we could see the next slide, please. So historically, this is a summary of caseloads of very well-known arbitration institutions around the world. I want to emphasize these are not maritime cases. These are all cases. So we can see that although certainly by other measures, you might say that sort of the ICC in Paris or the LCIA or the SEC are great institutions, and there's no question, and they perform an amazing job, and they have very many high-value claims. But if you look at sheer number of appointments, then the London Maritime Arbitrators Association has by far a much greater number of appointments and a heavier caseload. So this sort of puts things in context in terms of when we're talking about maritime arbitration in London, what it is that we're talking about. Next slide, please. Now, this all sounds very impressive, and if you looked at these numbers, you would think that everything is resolved by arbitration. But if you look at a closer look at these numbers, then, and we analyze them just a little bit, then we'll see that based on those statistics, it looks like that if you had 2015 references, of which and you had only 563 awards, then you're talking about only 27% of the arbitrations which commenced ended up in award. So 73% did not end up with an award. So what happened to the 73%? Well, those were either amicably resolved by the parties in some way or not pursued further. They certainly did not end up in an award. Then we look at oral hearings. And we always imagine arbitration, there's this oral hearing. But here we only look at 4.1% actually proceeded to an oral hearing and an award. So the rest of them were based on the exchange of documents alone. So the conclusion you can reach from this is that the overwhelming number of disputes which were actually referred to arbitration end up being resolved outside of those arbitration proceedings in some way. And again, we're looking at London, which has by far the biggest caseload of any other city in the world. So this is a very good representation, and it also is consistent, and I'm sure my colleagues would agree with me, is consistent on my own personal experience based on many arbitrations. These numbers and these percentages seem to be consistent with what I also have experienced. The next slide, please. So what are we looking at here? How are these other cases being resolved? Well, the most common form of, let's call it a hybrid dispute resolution mechanism for maritime disputes currently, based on my personal experience, is a combination of arbitration, where arbitration commences, but then the parties engage in negotiation in the background in parallel to those arbitration proceedings. So very oftentimes you'll have cases resolved between the lawyers in the case, and they'll resolve it through one-to-one negotiations. Based on my own personal experience, the second most common form is a combination of arbitration and mediation. And this is a run in parallel. Sometimes you can have mediation before the arbitration commences, but because many times parties are concerned about time bar issues, and because it's so inexpensive to commence arbitration, it costs £400 to make the appointment fee. Parties many times will commence the arbitration and then move to mediation. But the mediation, as we know, can take place at any point throughout the dispute, either prior to the dispute or during the course of the dispute. Many other rarely used, although very effective, is something which we call expert determination, which is where the parties agree to refer the technical question to an expert and agree to ask that expert to resolve the dispute. And either the parties would agree to follow or agree just to take it under advisement, but not be strictly bound by that technical expert's determination. The important thing to remember is that in London, because it's a very conservative seat where parties, and because of the history of arbitration in London, parties feel uncomfortable adopting what we call med-arb or arb-med combinations, where you have the same person acting as an arbitrator and then acting as a mediator. This is extremely rare in my experience, certainly in maritime disputes in London. So whatever is happening in parallel to the arbitration, but on a without prejudice basis. And I think I just want to spend a minute talking about without prejudice, because it's often used in a way which people don't, it's misused. Without prejudice is a mechanism under English law, whereby a party can put forward a settlement offer, enter into negotiations, but anything which is exchanged during those negotiations or the mediation are strictly without prejudice to the arbitration proceedings, which means that it's prohibited from any information or document which is exchanged in those negotiations to then be produced before a tribunal. And the reason for that is to protect the ability of the parties to negotiate without having that count against them in the arbitration. So if I say, for example, in a mediation, let's say Jonathan is the mediator, and I say, you know, we had a mediation, I offered 20%, the other side actually was ready to accept a certain amount in settlement. It means that they were admitted that they were wrong, and I'm going to produce this back to the arbitrators. That's strictly prohibited. And this is how these hybrid mechanisms, we call them hybrid mechanisms, but actually they're parallel, and nothing is inhibiting with the, let's say, sanctity of the arbitration proceeding itself, but lots of things can happen outside of those arbitration proceedings. Next slide, please. So what are the current trends? Well, the one current trend I notice is that there's a relative increase in the role of non-London-based lawyers representing clients in LMA arbitrations. Many lawyers, as we know, are coming from Ukraine, directly representing clients in London maritime arbitration, doing an excellent job in doing so. Many lawyers coming from Turkey and from many, many jurisdictions around the world are representing their clients before a London-based tribunal without instructing English solicitors for the full representation. So this is a trend, and as the skills of non-UK lawyers increase, as they're as they become more familiar with London maritime arbitration, they feel more comfortable representing their clients. And in my view, that's only a good thing. I'm saying that now as a London solicitor, but I do think it's a good thing because I think this helps bring down the costs. It brings a lot of advantages. And if it's done well, it can be a very effective way of representing a client where that lawyer is closer to the client and has a much better idea of how to represent that client from the ground. A second trend, as we, of course, everybody's talking about, but I just did want to point on some of the amplifications, is the use of AI. AI is being used. There's no denying that AI is being used. It's being widely used. It's going to continue to be widely used. And it's being used now for analysis by experts, preparation of submissions. But is it also used perhaps by clients looking for advice before they go to the lawyer to say, well, let's see what the AI is going to tell me about the merits of my case? It is certainly used to prepare advice by lawyers for their clients. Is it being used by the arbitrators? Are arbitrators perhaps using AI to help them draft some of their awards? Well, that certainly is the case. And there have been a lot of debates about what are the codes of conduct for this and whether this should be disclosed. We won't get into that now. I just want to point out that these are the trends. Final slide, please. Looking ahead. Well, looking ahead, my own personal view is that through the use of AI, those current trends will accelerate. So there's going to be even greater access to London arbitration by non-UK lawyers who will be using AI to prepare their submissions. There's going to be, I also believe that there's a high chance that there's going to be actually higher percentages of settlement. Why do I say that? Well, if both sides are, even before going to their lawyers, plugging in certain questions and documents and so forth, and getting similar answers into AI. There's a dispute, both sides are putting the same questions in with the same documents, they're getting very similar answers. It seems to me that the scope of their differences are going to perhaps decrease, and that is where we're going to have a greater role for mediation, perhaps, for other forms of dispute resolution to close that gap. There's also going to be less contractual disputes in terms of the wording of contracts. There's going to be less contractual disputes in terms of information as we have better information, better drafted contracts. There's certainly the potential for AI to reduce the amount of arbitration awards, but I think also increase the scope for mediation to play a role once the parties have accessed and received advice and information from their lawyers in a combination from AI. Happy to answer any of the questions, but those are quickly the points that I wanted to highlight. Thank you very much.
Thank you very much for this insightful presentation. Dear colleagues, should you have any questions now to George, he can answer these questions because we have in spare time. This is our last session, and I hope that organizers that if we need that, we can go a bit beyond the timing outlined for us. I mean, until 8 p.m. Kiev time. Dear participants, do you have any questions to George? Please. George, I can't see any questions for now, but maybe we will have them later on, and I will have a few questions related to your presentation. But let me ask them after the end of the panel. I will ask the questions to each of you. At this point, we say the word of thanks to George, and I hope you will be able to stay with us through the session. Is that correct? Thank you very much. And I'm giving the floor to the next speaker. And our next speaker is Jonathan Lux. He's an international commercial mediator, arbitrator, and he has a vast experience of 37 years. He used to work in major law firms and went all the way to the co-founder, and now he dedicated his time to the mediation, and he is accredited at the International Mediation Institute and the Civil Mediation Council. He was acknowledged as one of the best lawyers in maritime law, and he has many, many other achievements, and I hope we're going to hear about today. And I'm giving the floor to Mr. Jonathan, and the topic is mediation and hybrid precision in maritime disputes, practical aspects, and modern trends. Jonathan, over to you.
Yuri, thank you very much. I concur with the thanks to you and to the organizers expressed by George. If you could put up my extensive slideshow comprising just one slide, that would be appreciated. Do you have that? It's the next page, then it is maybe 2 pages. Great. Really, ladies and gentlemen, it's just so that you have in front of you the structure of my talk and will therefore have some idea where I am at any particular time, hopefully. So starting with the introduction, life was indeed simple when I was growing up. Court litigation and arbitration were the only things on the menu. And just for an idea of how things were at that time, or at least in the view of some, I would quote US Supreme Court Chief Justice Warren Burger, who said this in 1982, and I quote, "The existing judicial system is too costly, too painful, too destructive, too inefficient for a truly civilized people. Reliance on the adversarial process as the principal means of resolving conflicts is a mistake that must be corrected. For some disputes, trial will be the only means, but for many claims, trial by adversarial contest must in time go the way of the ancient trial by battle and blood. So said Chief Justice Warren Burger, as I say, in 1982. Now things are very different, with multiple ADR processes, of which mediation is by far the most popular, and various hybrids. Also, the world is changing, and not in a good direction. Of course, there were always climatic and political issues, but not on the scale of what we are now seeing. I reference in particular the recent COVID pandemic and today's world, where it's not fanciful to suggest that three overbearing dictators, Presidents Xi, Putin, and Trump, may be about to carve up the world into their respective spheres of dominion and control. Now, what do pandemics and overbearing leaders have in common? Well, I suggest they are disruptive, interfering significantly with the world trade, which is the lifeblood of our industry, and may make it impossible for one party to a commercial venture, through no fault of his own, to perform the contractual obligations which he reasonably took on just some short time before. Litigation and arbitration are rights-based systems, and rights are, of course, important. I certainly wouldn't disagree with the notion that the rule of law is the very underpinning of a free and democratic society. But will such a rights-based system keep world trade afloat when the threats we face and their impact on the contracts our clients conclude are quite literally incalculable? For example, remember the case of the Suez Canal closure quite some years ago, when the vessel had to sail more than twice the distance at more than twice the cost in order to perform the voyage charter contract. As I recall, the English court dismissed the argument that the contract was frustrated and that the owner was entitled to freight corresponding with the particulars of the voyage actually undertaken. It was held that mere financial hardship alone is not enough to frustrate a contract, and that the hapless shipowner would be held to his bargain at the contract freight which had been agreed. So the traditional legal arguments, frustration, force majeure, may quite literally drive one party into liquidation. Let me now move to my second heading, the shape of modern mediation. What does mediation have to offer in this changed world? Well, as we know, mediation is quite simply facilitated negotiation, where a third party, the mediator, assists the parties, often two parties, but maybe multi-party, to resolve their dispute. Its origins are ancient, and time doesn't permit me to go right back through history. But in the UK, that stretches at least as far back as the 15th century, when the parties would attend what were called love days, when the baron would assist the commoners in resolving their disputes. However, I think mediation of the sort we now practice in the UK has a much shorter history. Its birthplace is in the USA and no more than about 40, 50 years ago. That's perhaps no surprise, given that the twin evils of cost and delay in the litigation process are at their most acute in the USA, and an alternative had to be found. Again, as you will know, there are different schools of mediation, from the purely facilitative to the evaluative, with all shades in between. And then there is also what's called transformative mediation. The orthodox view, with which I concur, is that mediation should be facilitative. My standard mediation agreement provides that if the mediation has reached impasse, and if both parties so request, then I, as mediator, would give a non-binding view as to settlement level. In other words, this will only happen if the mediation has failed, and fortunately, most mediations are successful. Now, I'd be happy, but at the end, in response to questions, if it's of interest, to run through the typical procedure which would be adopted in a mediation in London. But again, time constraints, I will move on. In fact, there is no set procedure, and the mediator will work with the parties to devise the best procedure for the particular case. Counterintuitively, the rate of the success rate of mediation is very high, approaching 90%. I say counterintuitively because, of course, the mediator has no coercive powers at all, and either party is free to get up and walk out at any stage. The fact is that mediation seeks to achieve a mind shift, and most parties are happy to stay and see what can be achieved. Finally, under this heading, I just mention briefly two recent developments. One is local to England and Wales, and the second is global. In England, we have the very recent decision in the Churchill case, where it was held for the first time. That was a Court of Appeal decision, where it was held for the first time that the court has power to make an order compelling the parties to mediate, and the power to impose sanctions if one of the parties refuses. The global development I'd refer to is the Singapore Convention, Singapore Mediation Convention, providing for the international recognition and enforcement of mediation settlement agreements. Now, it's said that the New York Convention played a big part in putting international commercial arbitration in the #1 position for the resolution of international commercial disputes. If that's the case, then of course it's to be hoped that the Singapore Convention, which is modeled on the New York Convention, will do the same for mediation. I will next take headings 3 and 4 together, hybrids and some examples. We have as George indicated, moved on from the previous rather binary court or arbitration offerings to a rich tableau of ADR processes and the possibility to combine these. Whilst there are all sorts of possible combinations, the ones I will now address are ARB-MED and ARB-MED-ARB. I know that in some civil law countries, it's accepted that the same individual can act as both the mediator and arbitrator. This is not accepted in England, and in my view, for very good reason. After all, how can the neutral receive all the confidential information which is shared with a mediator and then close his or her mind to that when acting as the arbitrator? Let's look at an example of a hybrid process. In Singapore, which has been very resourceful in the mediation space, first SIAC, that's the Singapore International Arbitration Centre, and then SCMA, that's the Singapore Chamber of Maritime Arbitration, adopted a protocol where the party first starts arbitration, and then the arbitration is stayed, and the parties attempt mediation, generally under the SIMC, that's Singapore International Mediation Centre, rules. And then, if the mediation is unsuccessful, the parties can go back to the arbitrators to proceed to an award in the usual way. On the other hand, if the mediation is successful, and as I've said, most are, then the parties have the option to take the settlement agreement back to the arbitrators to make an award, and that award should then be enforceable under the New York Convention. I'm not a great fan of this for several reasons. Firstly, it can be something of a straitjacket in that the mediation takes place right at the beginning, whereas mediation may actually have better prospects if resorted to later, after several steps have been taken in the arbitration. Secondly, it's certainly a valuable feature to be able to convert the mediation settlement agreement into an arbitration award and then have the possibility of enforcement under the New York Convention. However, we now have the Singapore Mediation Convention, and therefore, in many cases, it will no longer be necessary to convert the settlement agreement into an award for the purpose of enforcement. Another example of a straitjacket approach is the multi-tier dispute resolution clauses, which are quite common in the maritime world. Most of the suite of BIMCO contracts contain such clauses, which typically provide sequentially for good faith negotiation, followed by mediation, followed by court or arbitration proceedings. In my view, it's useful to have more flexibility regarding the timing of each process, rather than having to conduct, for example, the mediation phase before being able to progress to the court or arbitration phase. All that said, resort to hybrid processes is increasing. Also, as I mentioned, the English courts now have power to order the parties to mediate or engage in another ADR process and to impose sanctions if one of the parties refuses. my next heading, some practical perspective and a real life story. As we know, the key distinguishing feature between arbitration and court on the one hand and mediation on the other hand is that the former, court and arbitration, focus entirely on legal positions, whereas mediation focuses on underlying interests. The best story I've heard illustrating this difference relates to an orange. But as we are a maritime gathering, let's make it a ship full of oranges. The claimants argue that the oranges are theirs, and the respondents argue the reverse. What could a judge or arbitrator do in this situation? Award the oranges to the claimants, award them to the respondents, divide them 50-50 or in some other proportions between the two parties, or perhaps in a corrupt jurisdiction, the judge or arbitrator may decide to keep the oranges. Well, of course, in this situation, the skilled mediator drills down and establishes that one party wants the fruit of the orange to make orange juice, and the other party wants the skin or rind of the orange to make marmalade. And lo and behold, the interests of the two parties can be accommodated out of one and the same consignment of oranges. Now, it's of course rare for parties' interests to align quite so neatly, but I think it is a clear illustration of the difference between positions on the one hand and interests on the other. Now for the case. It involved an aspartame buoy charter party between the owners of a small fleet of tanker vessels and an oil major charterer for the carriage of a cargo of crude oil in the owner's vessel, the Chip London, from Jeddah to Rotterdam. The charter contained the customary laytime clauses and the option for the charterer to cancel the charter should the vessel fail to arrive at the load port by the date and time stipulated. As we know, as maritime lawyers, it's not necessarily a simple matter to say precisely when the ship is to be treated as having arrived. In this case, the owners maintained that the ship had arrived at the load port prior to the cancelling date, but the charterers, on a falling freight market, it has to be said, alleged otherwise. So the charterers cancelled the charter and the owner was forced to refix his vessel at a substantial loss. The charter provided that London arbitration, in accordance with English law, was to apply, and the owners commenced arbitration proceedings to recover their losses. After claim and defence submissions had been served and documents exchanged in the arbitration was stayed so that mediation could take place. In the arbitration, ignoring any quantum issues, the result could be either that the ship had arrived, in which case the owner wins, or the ship had not arrived, in which case the owner loses. In the mediation, there are, of course, private caucus sessions, and the mediator established that owners were struggling to meet their running costs and needed to maximize the possibilities to employ their fleet. And secondly, that their mortgagee bank held a fleet mortgage and therefore could close down the owner's entire operation if there was a default on the loan. Then, in private caucus session with the charterers, it was established that the charterers had no issue with the owners or the vessel as such. They were motivated to cancel by the possibility to make considerable savings in a falling freight market, and they recognized the possibility that they might lose in the arbitration. Well, what then came out of the mediation? In fact, the original dispute was parked, and the owners and charterers entered into a new long-term agreement whereby the charterers gave owners first refusal for the carriage of charterers' cargoes between specified load and discharge ports at market freight. Now, this cost the charterers nothing, but was far more valuable to the owners than even winning their arbitration case in full and recovering the loss of freight, plus interest and costs. It was therefore an outcome based entirely on the parties' best interests, and it was an outcome which no judge or arbitrator would have had any power to order. My final heading is conclusions and hopefully interactive discussion. My conclusion can be put shortly, and it is that mediation, combined sometimes with other processes, is a force for good. Would anyone disagree? Thank you.
Джонатан, щиро дякуємо вам за те, що ви
Thanks
поділилися
a lot,
вашим досвідом з
Jonathan,
нами. І
for your
сподіваюся, що
experience.
також, як і
Thank
ви
you
в
for
слайді,
sharing.
в останньому
In
пункті,
the
що у нас буде
last
плідна
point of your
дискусія,
slide,
інтерактивна
I
з
also
нашими
hope that
слухачами,
we
з
have
нашими
an
учасниками.
interactive
Якщо є питання, то, будь
discussion.
ласка,
If you have
можете їх
questions,
задати.
please.
Тут бачу, з'явилися питання до
I
Джорджа. Чи
already
є
see
зараз
one
питання до
in
Джорджа? Будь ласка.
chat to George. Do you have now currently questions to Jonathan?
Jonathan, чи зможете ви бути з нами до
Jonathan,
завершення нашої
are you
панелі?
able to stay with us until the end of our panel?
Yes, Yuri, I should ideally leave to get to another appointment at 6 p.m. London time, but that gives us about 40 minutes. Is that okay?
Добре, дякую. Сподіваюся, так.
Yes, thank you. We hope that yes. But if you have questions to Jonathan now, please, we are ready to hear them. And Jonathan is able to be with us the next 40 minutes. Please use it. But before we give the floor to Andrea Lista, we will probably ask all our speakers now, what are the hybrid procedures which, up to your opinion, are the most efficient? Which hybrid procedure do you consider the most efficient? You mentioned Singapore's procedure. Probably you or your colleagues have another point of view or additional information in this regard. The most efficient.
So, may I venture a comment? I have suggested that flexibility is the watchword, is the important element. And I have suggested in an article a few years back that arbitrators, London arbitrators, have the power to order parties to mediate and to impose cost sanctions if they fail to do so. Now, I know that is a somewhat controversial suggestion, but it's one that I do hold based on provisions in the English Arbitration Act. So I think the most efficient hybrid is if the backdrop is arbitration. I've already said if the backdrop is court proceedings, the courts can definitely now can definitely now order parties to mediate. But if the backdrop is arbitration, then of course there is nothing to stop the parties at any stage from agreeing that they will ask the arbitrators to stay the arbitration for a sufficient period for a mediation to take place. Or alternatively, for those who endorse my view that the arbitrators have power to order this, the arbitrators themselves could stay the arbitration to enable mediation to happen. So that in that way, there is flexibility as to the timing of the mediation.
Зрозуміло. Джонатан, Джордж, ваша думка з
Thank
цього
you.
приводу?
I understand. Probably, George, you also have an opinion on this, the most efficient hybrid procedures in the maritime disputes.
Yeah, I mean, my opinion is going to be the most common opinion that you hear from every lawyer, which is it depends. It depends on the case. It depends on the people involved. It depends on so many different factors. And that's why I completely agree with what Jonathan said about flexibility. I think that's what's important, is that there's flexibility, both, first of all, in the legal representative, to be aware of and be educated and to know that there's more than just one path to follow. And this is critical, and this is why forums like this are so important, and to educate people around the world that there are these different options available to you, and this is what we are constantly working on. But it absolutely depends on so many different factors that I could not point to one particular system and say this is the most efficient one.
Зрозуміло, Джордж. Дякую. Тут з'явилося питання.
Thank you. I understand too. There is a question. What do you think?
Як може бути
How
вирішено спор
can the dispute be resolved with the help of mediation
вирогідному корпоративному компоненті
in a corporate component with the Ukrainian vessels? Probably we will better ask this question to those who practice in Ukraine. And if you don't have particular questions to Jonathan, let's invite our next speaker. Let's say thanks again to George and Jonathan, and those who can stay until the end of our panel discussion will continue answering your questions.
Could I just answer that, the question, the one you just posed, just because I have a real life experience of this, and just to answer your question exactly. So last year I was acting for the owner of a vessel which was trapped in Mariupol during the Russian invasion. The vessel was expropriated, and the crew were taken as prisoners of war. They were then exchanged, they went home, but the vessel still remains now out of the owner's control. And we had a big dispute with the underwriters of this vessel to seek compensation for the loss of the vessel. And this dispute was resolved eventually through amicable negotiations, face-to-face negotiations, and not through court processes or through arbitration. So even in these extreme cases, we can see that alternative forms of dispute resolution are actually working to achieve a result where the owner received compensation.
Щиро дякую, що поділилися прикладом.
Thanks again
І
for this
йдемо ми далі
example.
за нашою
We
програмою
will
нашої панелі. І
move
хочу з
forward,
задоволенням
and I
надати
want
зараз слово
to
і
give the
представити
floor
професора Андрея
and
Ліста. Мені
introduce
особливо це приємно,
Professor Andrea
враховуючи, що я
Lista.
також як ідея поєднує
It's my
викладацьку
honor
діяльність та діяльність
to
адвоката.
present
Професор Андрій
Andrea,
Ліста –
introduce
це
Andrea,
професор
because I
Господи
also
комерційного права, директор
combine
Інституту
educational
морського права при школі
activity
права
and
університету
legal
Саутгемптона.
activity.
Його наукова та
Andrea
професійна
Lista is a
спеціалізація
professor of
Об'єднане скло,
maritime and
морське
commercial
право,
law,
міжнародне право і
director of
право
the
міжнародне
Institute of
комерційне право.
Maritime Law,
Він
legal
активно
counsel
займається юридичним
at
консультуванням
LMAA,
і в різні
supporting
професійні
member,
етапи своєї
and
професійної
he's
діяльності
actively
виступав консультантом
involved
Європейської
as
комісії
a
та Європейського
consultant of
парламенту. Та
European
також, як
Committee
і
and
наші
European
інші шановні
Parliament, as well
спікери,
as
має
our
велику
other
кількість інших нагород
respectful
та відзнак. І, Андрея, я з
speakers. He
задоволенням
has a
надаю
lot
вам
of
слово.
awards,
Дуже цікава також
and
доповідь. І
it's
я
my pleasure
бачив
to give the
кількість
floor to
слайдів,
you.
і
I
знаю
saw
також, що їх
your
15, і
slides.
вони
I know that
такі
you have
об'ємні.
15 slides, and
Дуже вас
the
прошу
volume of
не
slides
обмежувати
is
себе,
quite
проте
big.
пам'ятати про
Please
наш
don't
таймінг.
limit
І тема
yourself,
у
but
нас
remember
коротка
about
якість
our timing.
розпорядження про вирішення
And
спорів у морських контрактах,
please
практичні
stick
питання виконання
to
і сучасні виклики.
the
Будь ласка,
timing,
Андрея,
and
вам
the
слово.
topics is mostly about the challenges of modern maritime contracts. The floor is yours.
Thank you very much, Yuri, for this introduction, of which I didn't understand a single word because I think I lost the translation into English, but I think, you know, it was a great introduction in any case. Ladies and gentlemen, around 70% of charter parties now contain hybrid multi-tier clauses, which provides for mediation and arbitration. So the question is, what happens in case a party bypasses mediation and commences arbitral proceedings instead? And that is what I would like to answer, the question I would like to answer with you today. But first of all, I would like to thank very much both Yuri and Luisa for their kind invitation. It's an honor and a privilege to be here in front of a distinguished audience and illustrious speakers. So I'm very, very pleased and honored to be here with you. So if you could please share my presentation, I would try to go through my slides as quick as possible, so as to then have a chance to discuss with you together some views on enforcement of mediation clauses with some, I hope you will find interesting observation. Thank you very much. We can go to the next slide, please. Right. So what I wanted to do is to discuss with you the enforcement of mediation clauses. If you're going to be so kind as to follow me for the next 15 minutes or so. From, first of all, a general perspective and from the maritime practice perspective, why this twofold approach? Because I noticed, both in my personal research, but also in practice, that there's quite a striking difference between how mediation clauses are structured in international commercial contracts overall and in maritime practice. So we can go to the next slide, please. And the next slide. So we're starting with the general commercial practice. So I just wanted to show you very briefly a couple of mediation rules which are not designed for maritime contracts. One is the Vienna mediation rules, the standard clause 0.7, which tells us that in the first place, in case a dispute arises, you need to refer the dispute to mediation, and then if it has not been resolved by mediation within a specific time limit, then you will need to go to arbitration. The next slide, please. Within the same vein, we have the ICC standard mediation clause, version D, and actually I was involved in an ICC mediation a month ago, and the structure is also very clear. So the parties shall first refer the dispute to the mediation via the ICC, and then if after a certain amount of days the mediation doesn't achieve the result which intends to achieve, then you move on to arbitration. And as we shall discover, ladies and gentlemen, this is quite different compared to the standard BIMCO multi-tier clauses, MED-ARB clauses. And this is something that it was mentioned before, both by George and by Jonathan, so of the possibility of commencing mediation after you start arbitral proceedings. And that actually creates a situation which is a bit different in terms of how we then face in practice a possible breach of a mediation clause. Next slide, please. So two questions. If we freeze here and we're talking about these two mediation clauses, the ICC and the Vienna one, they are structured in a very precise way, in the sense that it's very clear that first you go to mediation, and then after that you go to arbitration. So if we have an hybrid clause which is structured in this way, giving precedence to mediation first, and then after you go to arbitration, there are two questions that we need to ask ourselves in terms of enforcement. So first of all, how does this create a contractual obligation? So is mediation a condition precedent which you need to fulfill in order to proceed then to arbitration? And are you going to be in breach of contract if you don't go for mediation, you bypass mediation and you go straight to arbitration? Procedurally is another important question, is what is going to happen then if in case someone bypasses the ICC mediation clause and goes straight for arbitration? Is it a jurisdictional matter for the arbitral tribunal to decide, or is just a matter of admissibility? This is a very, very important distinction, ladies and gentlemen, because if it is a jurisdictional matter, then it's something that you can challenge also at a little level in terms of a challenge under the Arbitration Act 1996 as amended by the 2025 Amendment Act here in the UK, or at the level of under Article 5 of the New York Convention on Recognition and Enforcement of Arbitral Awards. Whereas if it is a matter of admissibility, then you can't have that. The decision of the arbitral tribunal is final, and you're not going to have recourse to grounds of appeals, both before a court of law and then at the enforcement level, at the enforcement stage, through the the New York Convention. Next slide, please. So this matters because of what I just said in terms of grounds for possible future appeals. Because if it's a matter of jurisdiction, I repeat, then you can challenge the jurisdiction of the arbitral tribunal at a later stage. If it's a matter of admissibility, instead, the decision of the arbitral tribunal is going to be final. Also, time bars are also very important. So, for instance, I'll give you an example here of Danish law. On a general level, mediation attempts can suspend the time bar, but they're not going to be able to break the time bar. So the time is kicking, and that might be an incentive to bypass mediation and to go for arbitration. Next slide, please. So to answer the question of whether the breach of a mediation clause is a matter of admissibility or of a jurisdictional matter, there's consensus on Anglo-American law, but also Singaporean law. And I mentioned also there's a Dutch Supreme Court decision here in front of you. I'm not going to go into the details of that. What I just want to say is that the general consensus on jurisprudence level is that we are talking about a matter of admissibility, not of jurisdiction. Next slide, please. Now, going on to maritime commercial disputes, we can go straight on to two examples of BIMCO multi-tier clauses, mediation arbitration clauses. So we can go to the next slide, please. So the first one is the 2002 clause, and in essence creates this possibility, this hybrid mediation arbitration clause. And you can see that the idea is either party may at any time refer the dispute on to mediation. And this actually calls into question what Jonathan was saying before, and I totally agree with him that at that point, through the agreement of the parties, the arbitrators should have the power to suspend the arbitral process and to enable parties to go on for mediation. Next slide, please. And again, basically, the idea is the intersection here between the mediation process and the arbitral process, the arbitral procedure, is in essence that the arbitral tribunal may take the mediation timetable into account in order then to fit everything in with the timetable of the arbitral process on its own. The next slide, please. Now we go on to the 2021 BIMCO mediation alternative dispute resolution clause. And again, the idea is at any point of the dispute, there's the possibility to refer the question on to mediation. And then there are some procedural steps to be undertaken as a consequence to that. The next slide, please. And again, it's important, I just wanted to emphasize again, and this is what also George was pointing out in his talk before, that it's not unusual to start mediation after the arbitral process is already in place. So that is basically something that, and this is actually quite interesting in my view, because it is this is not something that I found in international commercial contracts on a general level. This is perhaps a little bit, you might find it a situation, similar scenario also in this kind of contrast, but this is kind of interesting for a maritime law perspective. The next slide, please. So now the key issues, and then I'm going to wrap everything up. So the idea is, in essence, in terms of enforcement of a mediation clause or an hybrid clause, which provides for mediation and then arbitration. First of all, it depends entirely on how the clause is structured, because if you have a situation like the Vienna mediation rules or the ICC rules, where from the language is quite clear that there is a condition precedent, that there is an obligation to go for mediation first and then to move on for arbitration, then you have a more emphasis, I would say, on the possibility of enforcing it legally as a condition precedent. Whereas I would say that if you have a wording which is vague and in terms of how the mediation clause is structured and the possibility to commence it also after the arbitration proceedings are started, then it's a bit of a different animal in that regard. And I would say that the idea is there's also general perception. I think perception is very important in terms of how people have a perception of mediation in terms of, because you can see many clients, and I think it's really an experience that is common to many of us. There's a dispute arising. First, they try to reach a settlement, And then they say, okay, well, we couldn't find a settlement. Why do we need to go for mediation? We already started our own mediation, which is a very, very different proposition from mediation, actually. And more often than not, the presence of an expert mediator is going to make a difference. You know, someone as illustrious as Jonathan, for instance, in my experience, will make a big difference. But this is not the perception that many clients have. And so, hence the idea of then, okay, let's go for arbitration and let's disregard mediation. We already started the mediation inter nos. So that is the idea. So how do you bypass all of this? Well, the drafting then phase is going to become crucial in that regard, and you will need to be very precise and very specific in the drafting. The next slide, please. And this is the last slide of my talk. So again, the importance of drafting in terms of then, if you want really to enforce it, the idea is if you clearly define what comes first and what comes next, and that there is a clear obligation to go for mediation, then in terms of enforcement, things become a little bit different compared to a broadly drafted mediation clause. And there's two cases there which are non-maritime law cases, the Channel Tunnel and the Cable Wireless. In the Channel Tunnel, what happened was there was a mediation and arbitration clause. And what happened was that one party breached the mediation clause and started arbitration instead, and the other party started a legal action before a court of law. And basically what the court told us here is that if you have a mediation and arbitration clause and someone bypasses the mediation clause, that doesn't entitle you to go to court. You need to go to arbitration, of course. And what is interesting instead is the Cable and Wireless case. And this, again, links very well to the last observations that Jonathan made in his talk before. And it is the idea that if there is a mediation clause and then you don't have arbitration, but you have a mediation clause and then you have jurisdiction before a court of law, then the court of law will definitely in the UK mandate mediation. But there are elements here which are of public policy value, in my view, in a sense that you try, of course, as a court of law to try to avoid, the overbearing number of cases, and you're going to basically mandate the parties and order the parties to go for mediation instead. Right, so ladies and gentlemen, so this is all that I wanted to discuss with you, but I find quite interesting that there is a bit of a difference between the maritime world and maritime contracts, especially charter parties and other international commercial contracts. But I think there's quite a lot to be learned by this. And I also think that what George said before in his talk is really relevant, that artificial intelligence is really having a huge impact, will have a huge impact on all of this. And also, in my view, it will render mediation more prominent in the future. So, ladies and gentlemen, I shall not aggravate you any further. And like I once said on an English radio, if you have been, thank you for listening. Thank you very much.
Щиро дякуємо, Андреа, за
Thank you
ваш
very
виступ.
much, Andrea, for your presentation. Thank you for these insightful slides and the links for very specific forums, some reference. Can you hear me in English? Can you hear interpretation?
Yes, now I can. Thank you.
Чудово, чудово. Чудово. Скажіть, будь
Excellent.
ласка, ось стосовно застережень щодо
And
медіації, які
regarding
стосовуються в
this
морських контрактах,
mediation clauses in the maritime contracts, what is the attitude of the parties? Are they ready to include these clauses in the contract in 2026 and on, given certain experience of their application? Let's say it's been for 5 years now. What about the parties? Are they ready to apply these clauses? If not, why so?
Yes, I mean, we've seen that. We did a bit of of a research project on this with the Institute of Maritime Law, and we were able to survey a certain amount of charter parties. And we did see that they are very common nowadays. So there is a predisposition to that. Now, in terms of then how things are shifting, I think again, I'll just reemphasize what George said. The fact that many parties nowadays are using artificial intelligence and feed in their questions on to AI once the dispute arises, and that really shifts things on towards mediation. So there's going to be a big change in relation to that. So I would say that in order to answer your question, Yuri, they are very common now. So, and that is a fact. They will become much more prominent because of the role of AI in the near future, for sure. In terms of then of enforceability, I wouldn't see it as an issue anymore, in a sense that it's more to the advantage of the parties rather than an issue of enforceability at that stage, at that point. So it is more the idea of, again, what is very important is the perception of how people are starting to perceive all of these, and the perception of mediation as an effective alternative dispute resolution mechanism, more effective even compared to the past. It's going to be very important. It's going to make a huge difference in my view.
Дякую, Андреа.
Thank you, Andrea.
Враховуючи там останній мій досвід,
Given my recent
читав
experience,
документи, які були
I've read
створені
various
колегами з
documents
штучного інтелекту.
drafted by my colleagues using AI, and unfortunately, there are lots of hallucinations in those documents, and they're associated with practices that don't even exist. What are we gonna do if we encounter the clauses and the commercial maritime contracts drafted with AI, and you won't be able to apply arbitrary or mediation procedures? What shall we do? It's not the question not only to Andrea, but also to George and Jonathan. If AI creates contracts that have clauses that do not meet IMCO requirements, the requirements of other institutions, what shall we do?
Сподіваюся, було чутно питання, так?
I hope you heard the question.
Could you please repeat it one more time, just to make sure I understood it?
Так, без проблем. Я маю на увазі, що якщо ми зараз багато говоримо про штучний
Today
інтелект,
we're speaking about AI at length, and we can see in practice that those who use it to draft the contracts, they apply the Supreme Court practices in Ukraine that does not even exist. They do not verify if they have facts and submit the documents to the courts. And we will increasingly encounter the situations when people draft the contracts without using standard BIMCO formats, and it's going to have the clause that are going to apply the mediations of these other institutions, but they won't comply with the real practices. Will we be able to use this practice then?
Well, if I might, just I like to compare. My impression of AI is that it's something like Google Maps. You know, when I was getting in a taxi and Google Maps first appeared, there were many taxi drivers who said, Google Maps, so unreliable. There's no way. I know the best way. And many times they did. And many times the maps made mistakes. But increasingly, as the years go by, I think we can all agree that every driver is using Google Maps. It's extremely reliable. I'm not saying there's never any mistakes, but has improved hugely. At the end of the day, the driver is responsible for getting you to your destination in the same way that the lawyer is responsible for everything which is put in the contract. And we had a recent case in England where a lawyer presented a case to the judge, which included some hallucinations, some cases which did not exist. He blamed it on AI, and the judge imposed very, very severe penalties on this lawyer as an individual lawyer, a huge fine, because the message was, this is no excuse. You have come to this court, you've misled the court, and there will be, as a solicitor, an officer of the court, you will face very, very severe consequences for misleading the court. It doesn't matter why you misled the court or how you misled the court. The bigger picture is that when we come to drafting contracts, as AI improves, I think it's going to be much better than many non-lawyers drafting, commercial people where English is not their first language, brokers and various people cutting and pasting clauses which are inconsistent with each other. This is actually what's happening now. So it's hard to believe that things are going to get worse.
Well,
and probably with time they'll get better.
I would just add this, that
Так,
the English,
будь ласка, дякую, Джордж.
the
Thank you
English
very
court,
much, George.
the English court's approach issues of construction with expressly in mind that their role is to make sense and not nonsense of the contract, if they can. But if there is something included because the AI drafter has hallucinated, then the question might be, can you demonstrate, can the parties or the party who wants the contract enforced in a certain way, can he make out that there was in fact a common intention as regards the particular provision? And if there was a common intention, then the contract may be rectified so as to reflect that common intention. But it's undoubtedly causing a great difficulty, and therefore lawyers may be saving a lot of time using AI, but they should be using at least some of the time they spared in checking the output of the AI system they're using.
Щиро дякую, колеги, щиро дякую,
Thank you very
Джонатан.
much, dear colleagues. Thank you very much, Jonathan. We have the resolution of the Supreme Court that says that the application of AI by lawyers without the verification can be seen as disrespect to the court. And I can see that Arno Kupin wants to ask the question. If you can unmute yourself, dear tech support, could you please enable the person to unmute himself? And I can see there are other questions on the chat that are quite of general nature that do not relate to the presentations. So we will answer them after we hear the last speaker of today. I hope that we will be able to give the floor to Arnold further. And I'm giving the floor to Karina Horova. She is an attorney and the partner of Interleague commercial firm, and she's deputy chairman in arbitration and maritime arbitration, and her professional activity is the participation of various maritime disputes at various levels in various jurisdictions. And she's arbitrator of the ICAC, and the topic is the changes and the procedural moderation, adaptation to the international arbitration standards, and other. Karina, over to you. Dear colleagues, I hope you can hear me well. Loud and clear.
Супер. Перш за все,
Indeed.
дякую
First of
організаторам.
all,
Це
thank you
справді
very
дуже
much
ефективний, дуже
to the
масштабний захід.
organizers.
Дуже
That's
дякую за
very
запрошення. Це
powerful
насправді честь
event. Thank you
для
for the
мене, для мого
invitation.
колеги приймати
It's an
участь в
honor for
якості
my colleague
спікерів
and I
стосовно
to be
мого
here
колеги
as
Миколи
speakers.
Мельника,
Regarding
Юрича
my
Степана.
colleague
У нас сьогодні
Mikola
була змога
Melnik,
поспілкуватися
I
з ним
had a
буквально
chance
хвилинку
to
телефону. Він
communicate with
передавав,
him
переказував
over the
всі
phone.
поважні
He was
вітання і
saying
дуже,
hello to
дуже
everyone,
засмучений був,
and
що не зміг
with great
прийняти
regret,
участь,
he
але
says
я
that
сподіваюся,
he
що
couldn't take
наступного
part in
разу
the
в нас
event. But I hope
все
next
вдасться,
time
і ми
we
будемо
will
виступати
do
вже
much better.
вместе.
Next time it
Сьогодні
will be two
моя
of
тема,
us.
вона, ну, така,
Next
звучить
time.
доволі
My
складно,
topic
але
may sound quite
буду
complex,
намагатися
but
скласти це по
I will
таким
do my best
простим речам, щоб це було зрозуміло, щоб це
to
було цікаво.
dismember it
Прошу
into
організаторів,
simpler
власне,
sections
поділитися
to make it
презентацією.
more interesting. Dear organizers, please share my presentation.
Дякую. Насправді в
Thank you.
фокусі сьогодні питання розвитку
Today, we're
морського
looking at the development of maritime arbitrary and international commercial court developments. We look at the procedures of modernization, digitalization, and adaptation to the international standards.
Спочатку трохи introduction,
Let's start with the introduction. Please go back to the previous slide. Let me speak about these two arbitration institutions. They are the fundamental for Ukraine. This is International Commercial Arbitration Court and the commission that work at the Chamber of Commerce of Ukraine. The court operates since 1992, and currently it is quite an well-established arbitration institutions among the European institutions, and it's continuously operating arbitration, and it incorporates the leading experts, including from overseas, from 38 countries on the world. And so we have both Ukrainian and international experts, and the parties can select. About 600 disputes are considered by international commercial arbitration. What is interesting, if we look at this 2025 statistics, about 80% of those disputes are the disputes emerging from the commercial contracts signed during the war. What does it mean? It means trust. Despite the challenging wartime conditions, business continues to trust this arbitration institution, both Ukrainian and international business.
Що свідчить про репутацію цього
And
арбітражу?
it speaks to the reputation of this arbitration court. When we speak about the arbitration committee, it has been launched in 1994. It's a more niche one, and it looks at maritime disputes, but the business who is a part of the maritime sector in Ukraine trusts this arbitration thanks to the flexibility of the procedures, to the lack of some corruption aspects. So it enjoys good reputation in Ukraine. Now let's speak about the advantages of these two arbitration institutions. these two arbitration institutions ensure the prompt consideration of the cases. Both arbitrations have the regulation that provides for consideration of 6 months. This term can be prolonged, but statistically, about 90% of disputes are considered within this term. I guess we can all agree that it's quite prompt from that both the Arbitration Commission and the Arbitration Court made the final ruling that cannot be appealed, that can be declined in the court at the state level due to some procedural violations. Since the staff of two arbitration institutions is well coordinated, we do not usually have such groundings. The parties during 6 months gets the final decision that can be enforced. Further, when we speak about the appeal of this decision, there is no appeal procedures. They do not have the institution of appeal, but only the procedure can be disputed. Statistically, only 2.5% of the decisions are submitted for the appeal according to the procedures, and only 1% is withdrawn. It attests to the high qualification of arbitration experts that the compliance is in the focus, so there is no grounds for this appeal. The cost of arbitration in comparison to other institutions is quite competitive. It's 3 to 4 times less than in other international arbitration institutions. That's another benefit of these arbitration institutions. Statistically, the decisions of international arbitration court are enforced in over 110 countries of the world. So the decisions of this arbitration is recognized not only in Ukraine but also abroad and enforced.
Далі стосовно цифровізації та оновлення
Now
процедур.
on digitalization and revision of the procedures, both arbitration and the commission, when looking, when considering the disputes, follow the regulation. As a user who represented the interest of the parties at the arbitration and as the arbitrator, I can say that this regulation is so clear and it is very well written. If the dispute does not imply the engagement of a professional lawyer or an expert, the representatives of the parties can go through this arbitration following this regulation. The regulations of both arbitration institutions are not carved in stones, and they are reviewed every 2 or 3 years. Why is that? Both arbitration institutions are quite adaptive. They follow the trends. They do their best to adapt and introduce the innovations and trends in the legal community. They take into consideration the amendments to legislation. For example, in 2023, the regulations saw the amendments on mediation. They provided the mediation arbitration procedure or arbitration mediation arbitration mode. Now on the communication between the parties, since around 2020, the parties have the opportunity to proceed with online communication. There used to be the snail mail communication, then now we switched to online communication. Each representative have the access to e-folders that can see all the acts adopted in the arbitration, all the documents submitted by the parties. It facilitates the procedure and also saves the time a great deal. most of the hearings are held as video conferences. It wasn't available. It used to be not available. Now it is available and it is widely used. It's the advantage not only for the parties but also for arbitrary, so that during the martial law, the overseas experts could participate online. It's a very useful and efficient tool that is really used. Looking ahead, both arbitration institutions speak openly that the key changes in 2026 is to launch the e-platform. So not only communication is going to be carried out through emails, not only will the parties have the access to the materials of the case, they will launch the e-platform that will be look at will consider the case from the submission to resolution and the filing of the case. There's a prompt information of the parties that some new documents emerged in the case. It will also ensure the opportunity to comment on the procedural documents. This was all make the participation of the parties easier, and I emphasize that it is not necessary that the parties have to engage lawyers into the arbitration process. Things are going to be much easier. This is this is the highlight of the year to come, at least in 2026, and the institutions are going to put all the effort to launch this platform. The aim is not only to facilitation the procedure, but also mainstreaming of the processes to make it easier both for the parties, but also the arbitration secretariat to be more efficient. When we speak about the adaptation to international arbitration standards, Ukraine used to have the legislation framework that governs the international commercial arbitration within the law we had, but this law was based on the model legislation on arbitration, and it incorporated all key trends and principles. The recognition and enforcement of the resolutions, limited interference of commercial courts, the autonomy of arbitration clauses. It was all introduced and it has all been working all the time. In May 2026, there was the pivotal event for the entire arbitration community. The law was adopted on amendments of some laws of Ukraine regarding the expansion of competencies of international arbitration. And these amendments expanded the competence, the scope of international arbitration institution. Now, Ukrainian standards are more allied with the international standards. When I say that we extended the scope of arbitration, I mean this. When we look at the previous edition of regulation, it mentioned that could consider the disputes with overseas elements. It meant that there should be some branches or HQ of some party overseas. Now, it says that the parties can agree that the object of the arbitration contract association with more than one country, it will be the actual found ground for the International Arbitration Institution to accept this case. For example, two legal entities dispute with one another if they are registered in Ukraine, but they agreed that the implementation of the contract is performed outside of Ukraine, or the scope relates to some foreign element, and this is the reason to submit this case to International Arbitration Institution. Another key amendment is that the court will be able to consider investment disputes. It's very relevant for Ukraine, given our expectations of a victory and lots of investments in Ukraine. So we build this foundation for the opportunity to consider investment disputes between any party that is a part of investment process in Ukraine and the state. These were amendments to the law, then the revision of regulations and amendments to the implementations of all of that. Of course, it takes time to develop certain practices. When we speak about the expanding the scope of the disputes and the competence of arbitration, we shall see how it's going to work. But we can see very positive signs of the improvements, and it evidences that our arbitration adapts to international standards. Thank you. Thank you very much, Irina. Indeed, for 10 days, we have the new status of International Arbitration Court and Maritime Commission. I understand you very well as the arbitrator that it has happened. And given that this is the International Mediation and Law Forum, I would like to say that our esteemed mediators who work in the Ukrainian Academy of Mediation we have this registry of mediators approved by our institutions, and we can approach them to seek the dispute resolution. Let's have a look at the questions. I saw, by the way, that our dear Jonathan Lux had to leave our meeting, but he left his contacts, his email. And should you have any questions to him, he said you could email him. So let me have a look. What are the requirements to International Arbitration Court mediators? I believe that the Presidium of the Court of the Chamber of Commerce of Ukraine now is this registry holder. So I believe we can forward this question to them. You can actually send the question to the organizers, and we will reply to you. And I believe much depends on the Presidium of the Chamber of Industry and Commerce of Ukraine. But the requirements are quite transparent. We won't see any issues. There were the questions on corruption on the chat, and you mentioned corruption issues in your presentation, and the question was the following. How can the dispute in the Ukrainian court be addressed in the view of the corruption component? What's your opinion? I can only speak about arbitration, and this follow-up of my idea about the zero corruption scandals around our institutions. This is what our arbitrations are so proud of. There was no corruption scandals whatsoever for these years. Sometimes let's be honest, we can see that in the courts, but arbitration institution didn't see any. But we have to fight that in the justice system. I can share my experience, and the company's experience, we have to be utterly honest about that. We must not afraid of that. We saw the corruption manifestations from our counterparties, and we were very honest about that. We even had a publication where we compared two cases with absolutely identical circumstances, but the court rulings were very different, and we believe it was due to corruption aspect. So we decided to speak loudly about that, to counteract that, not to be complicit through being silent. And take every opportunity to fight corruption. I can see the chat also has the question to George. The question is the following. It's not about maritime disputes, but rather about our current situation. The question is the following. In case Ukrainians suffered loss of life or their families loss of life due to attack, and it affected them or their health, in your opinion, can mediation be applied here among the people who are victims of the aggression of the Russian Federation, in your opinion?
I don't really feel that I'm very qualified to answer that question. So I mean, if I can just pass, it's a little bit outside of my specialty. Sorry.
Дякую, Джордж. Розумію. Я мав задати
Thank
це
you,
питання.
George. I understand that. I had to answer this question. It is really difficult, but I believe that during other sessions of this forum, where we look at these questions, we will be able to ask it. Those we will ask them from someone who protect people, safeguarding people affected by the aggression. And I also saw the hand raised. I can no longer see it. If you would like to ask the question, that's the time. Actually, I have the question. Andrea, George, Karina, please share your opinion on the following. Can we speak about the new maritime dispute resolution culture where arbitration, mediation, and other ADR function as complementing mechanisms? I would like to hear your opinion.
I'm happy to share my experience on that. I have to say there's different view. When I talk to other lawyers, there's different views on this. So there is one school of thought, the more traditional school of thought, which is that mediation is a good thing and it can help resolve disputes very efficiently and cost efficiently and all of the good things that we know about mediation. There is, however, another school of thought, which is that mediation is basically a waste of time. That it's a good excuse for the lawyers to charge more money, to go to the room, to learn all of the secrets about the other side, because they're disclosing a lot of information and documents, and only using this as a kind of preparation to be better prepared for the arbitration. I'm just conveying what these two schools of thought are. Some lawyers think it's a more costly process, which does not often end in results. My own view is you need to look at the facts and the statistics, and I think it's quite undeniable, as Jonathan pointed out, that there's a huge amount of disputes which are settled amicably. But as I said before, it does depend on the case. And if you have, a very straightforward case where it's just simply a debt which is not paid, there might be an argument not to spend time on mediation and go directly for the decision to enforce. Again, it really depends. I think what I will say is that mediation is now widely accepted in maritime disputes as a process which needs to be seriously considered by the parties and is seriously considered by the parties as part of the overall suite of dispute resolution tools. It's increasingly used, it's favorably looked upon, but it's certainly not appropriate for every case.
Yeah, if I can follow that up, I totally agree with what George was saying, and also on the basis of my personal experience, is also depends a lot on the perception that clients have about mediation and their past experience as well, because you might inquire into clients who had really horrible experiences and in mediation and just say, no, I don't want to go through that again because it was a huge waste of time, is a waste of legal fees and so forth. So there's various elements there that need to be considered. For sure, the nature of the question, the dispute, the quantum as well, they have a lot to play in terms of role in determining whether to go for mediation as well. And ultimately, I also think, I mean, this goes back onto my personal talk, is also depends on how you want really mediation to be effective in terms of drafting the mediation clause. And I think it all goes back also to that point, in a sense that you, more often than not, you have mediation clauses which are really vaguely drafted, and they don't really convey the idea of something that, you know, parties are going to be really inclined to go for. But on the other hand, it's also true that if you draft a mediation clause which is very specific and you really render it a conditio sine qua non in terms of legal obligation, you might really put off parties from mediation altogether, for signing the mediation clause. So I think mediation is really a strange creature in when it comes to alternative dispute resolution mechanism. And also, it also goes back onto the fact that it's not legally binding either. So it is really an attempt to solve the dispute at an earlier stage compared to go to arbitration. So I think there's so many elements that go together and then ultimately will dictate whether parties will go for that or not. But it's without doubt can be a very efficient way to solve disputes. Really, really, absolutely. Very effective.
Можна продовжити, так?
Так, будь ласка.
May I continue, please?
Що стосується
Yeah.
моєї думки,
Regarding
досвіду,
my
насправді, на жаль,
experience,
що мене
unfortunately, we haven't met
процедури
in the maritime disputes mediation. But the trend which we are observing is that the parties are more concentrated on resolution, on amicable resolution. We have now 80 disputes in arbitration, but they are not ended with an award. So the parties want to have an amicable resolution, not to spend too much money on arbitration, not to spend too much time, also to keep their commercial relations. So yeah, there is a trend for amicable resolution for our community, for our business. Mediation is something new, and if you continue to promote it, business will come to it, because the trend again is to find a peaceful, amicable solution, and not to get an award which is need to be enforced, which is binding. Yeah, this is exactly what we are doing now. We are promoting mediation now, and it's important to see the presentation of George again. If you look at it, we can say the percentage, how many of the parties are ready for the amicable resolution. So please address the organizers to get the presentations, because they just reflect the trends, especially in the maritime sphere, that the parties are ready for this kind of resolution. We see a lot of cases which are being treated by London Association of Maritime arbitrators, and we see that just a very small percentage are ending within award. Dear participants, we hope that we will have a fruitful discussion. We understand that it's already evening, Monday's evening, and probably you are ready to you are ready to celebrate the World Day of Ocean, and that's why we're not getting too many questions. There's one question left. I will try to formulate it. How to put the ethical issues of arbitration procedures with mediation accordingly. Let's just talk about the ethical aspect in arbitration when mediation is being implemented. If you have an opinion or an experience. What are we talking about? Which ethical standards are being implemented in both mediation and arbitration? Maybe we have mentioned them already. What can arbitrator? What is he allowed? What is he not allowed to do? What he may do or not may do? George, the floor is yours.
Yeah, sure. Well, very briefly, I would say that we must always remember that the overarching obligation of an arbitrator and of the court, the same, is to dispense justice. So this comes above everything else. So of course we need to do it consistent with the law and consistent with the evidence and the party submissions, but no arbitrator that I know is going to issue an award which is blatantly and completely unjust. That's inconsistent with the overall obligation of a tribunal, which is, again, above all else, to dispense justice, the same as the court. In mediation, there is no such obligation. So, in fact, the parties could agree something which is completely unethical in mediation, and their agreement would be binding, and there's no authority above them to not allow this agreement. The parties are free to agree whatever they want to agree, providing, of course, that it's lawful, but it may be still unethical. There's no bar there, as far as I'm aware. So counterintuitively, we might find that there's more scope for unethical agreements in mediation than there is in arbitration. But to be honest, at the commercial level where I operate, I don't think ethics is really coming into play. They're very rarely, it's not a factor. These are commercial parties, they have commercial disputes, and I've very rarely come across any kind of question of ethics.
Дякую. Ну, мабуть, тому що це питання від адвокатів.
Probably because this is a question from lawyers, because we have rules for the lawyers, attorneys' ethics. When you are in the case or when you are walking on the street, you are still an attorney, and you always have to be in accordance with the standard, with this lawyer's ethics stipulated by your state. So that's why the attorneys, they put such questions. Probably someone else wants to ask or add.
Так, ну бачу, що з
I
нами
see
ще
that
залишилося 230 людей.
we have 230 persons with us, and it's great. We had 305 at the beginning, now it's 230. I'm grateful to all the participants. Today is the first day of our marathon of the 10th International Forum Mediation and Law. This is our last panel. Dear speakers, George, Jonathan, Andrea, Karina, I'm very grateful for you for coming to us, for supporting us with this panel dedicated to the arbitration and mediation hybrid mechanism of maritime disputes resolution. It went all great, to my opinion. And thank you for your presentations. Thank you for your time. We know that your time is extremely expensive, and again, we understand it and we respect it. If the organizers have any questions to us, we are ready to answer. Tell us, please, if we are able to, if we are allowed to finish our panel. The organizers are only grateful to you for this interesting discussion, for these different perspectives on the maritime disputes resolution. It was a pleasure to spend this evening time with you to reflect on what the modern methods, options of dispute resolution are, that hybrid is practically becoming a trend and a norm. Thank you, Louisa. Thank you for your invitation, Ukrainian Academy of Mediation, for conducting such serious and exciting events. I don't know who works for such a long time involving so many cool specialists from Ukraine and from all over the world to promote mediation in Ukraine and abroad. And I hope that with our effort, mediation will be even more spread in Ukraine and also in the whole world. Dear participants, today is the first day of our forum. We are finishing the day, and it was very intense. It was very various. We have 5 days ahead. Tomorrow we'll have different panels. We will start from the topic which will be extremely interesting for all the youth, students, representatives of the universities, and of course, organizers of international and national competitions on mediation and negotiations. Then we'll have an interesting panel about restorative justice. It will also be very intense, the discussion around the developments in restorative justice in Ukraine, and not only in Ukraine. Also, we have a panel dedicated to the introduction of obligatory mediation, and also our experts who already have it in their countries, or they are just on the way, or they had an attempt of implementation of obligatory mediation, and this attempt was unsuccessful. So we will hear this international experience. Then we will speak about the representative with the representative of media. It's about polarization of mediation, that awareness and the level of awareness on mediation among the people, among businesses, is not very high. So it's worth uniting, joining our efforts to make partnerships, to work with the representatives of media, to convince them that mediation can be also and has to be also covered and presented by the media outlets. And the end of the day will be connected with the activity of notaries and mediators. So we had a separate panel for judges and mediators. Tomorrow it will be with notaries and judges, and the day after tomorrow that will be with attorneys and advocacy of mediation. We have a lot of interesting panels. Thank you for being with us. Join us if you can. I understand that you cannot spend all the time with us. The recording, all of you will have access to the recordings. You will be able to look all the topics you are interested in through. Attorneys, lawyers, these 10 panels are accredited as promotion of your qualification, as your training. You know that there is an issue sometimes with scanning codes. I hope they are available in the beginning and at the end of the event. Also, court representatives, this is considered also like an official training for you. So gradually we are developing and we are raising awareness about mediation. Thank you. In case of any questions, we are available. We'll send the link to all the materials on the forum to the chat. We will add more presentations of speakers, additional materials which are being shared by the speakers. You will always be able to click the link and get all the documents. So we are continuing also translating presentation. If the initial is in Ukrainian, we'll translate it in English and vice versa. And to finalize the day, we'll send you the link to the online exhibition of the paintings done by children about the ocean of understanding, the ocean of mutual understanding. So you can visit this online exhibition and you will see how amazing these paintings and pictures of our kids are. And it will also add some energy and light to our everyday life, which sometimes needs additional resources. I wish you a nice evening. Thanks to our interpreters, our technical support, and everyone who supported us during this meeting. Links, QR codes, materials, all this work behind. Thank you for that. See you tomorrow.